Okay, good morning, everybody. This is the Colorado Oil and Gas Conservation Commission. It is Wednesday, February 16th, and it is 9 a.m. And this is our normal public meeting, and we will start with a roll call.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez,
Here.
Commissioner Hackett,
Here.
Commissioner McGowan,
Here.
Commissioner Mesner,
Here. Commissioner
Nanjapa,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present.
Excellent. Thank you very much. That is a quorum. We welcome all of our attendees. We have approximately 92 people participating with us today and rising. Appreciate the attention. We have a full agenda today. We have a consent agenda. We have 4 OGDPs, and we have numerous members of the public that have signed up to participate with us. I would like to reflect that we amended the agenda yesterday to reflect the public participation and to try to identify a more precise estimate of timing and for purposes of taking up the various matters on our agenda. That agenda is now online and folks can go see it if they desire at the Colorado Oil and Gas Conservation Commission website. We start the day with commissioner comments. Any comments from commissioners today? Commissioner Gonzalez and then Commissioner McGowan.
Thank you, Chair. I'm going to go ahead and make a quick disclosure. I don't think this is news to many folks, but this is going to be regarding the Longs Peak OGDP that we will hear today. It's important that I disclose that I worked for Occidental Petroleum and its predecessor Anadarko Petroleum prior to my appointment to this commission. My work at Oxy included oversight of the DJ Basin Mineral Land Department, including mineral land related long-term planning of Oxy's Longs Peak area. It's been over 19 months since I left that role, and I do not recall specific detail about the project other than just general geographic location. I believe that I'll be able to participate in this matter impartially and without bias. I have consulted with Commission counsel on this matter, and I do not plan to recuse myself from docket 2107-00114.
Thank you, Commissioner Gonzalez, for that disclosure. AG Davenport, do you have anything further with regard to the disclosure? I noticed you showed up.
I do not. Just wanted to make sure everybody knew I was available.
Okay. And I am comfortable with that from Commissioner Gonzalez. If any commissioner has discomfort, please let us know at this point. Otherwise, we will accept that and be able to move forward. Seeing no discomfort, your disclosure is accepted. So thank you very much. Commissioner McGowan had also raised her hand for commissioner comments.
Thank you, Mr. Chair. Last week, folks may have recalled some testimony from Broomfield City Council members, and I couldn't figure out if it was a failure to communicate, which was what we had an issue with, or a misunderstanding. But in talking with Commissioner Hackett, I think what was being requested for was not air quality data, which my understanding is the operator has released, but a request to have access to their logs, their activity logs, which unfortunately fortunately or unfortunately, depending on how you look at it, I guess, neither agency regulates or oversees activity logs that are sometimes part of work for an operator on site. So my understanding is the air emissions data has been released and the county has access to that. But I think that they're feeling like they're kind of in the washing machine cycle, because I'm not sure that either agency really has the ability or authority to require the operator to share those activity logs. So I just wanted to let folks know that I did talk to Commissioner Hackett about kind of what the he said, she said was, and I know that CDPH is still, and our staff are still working with Broomfield.
Excellent. Thank you very much. Commissioner Hackett, did you want to follow up?
I did. Yeah, thank you for the opportunity. I just wanted to provide a little more context on what Commissioner McGowan had said. So there is the Air Quality Control Commission pre-production monitoring regulation, which is in Regulation 7, Part D, Section 6. And that section, if you look there, it does require that the operator submit monthly monitoring reports, air quality monitoring reports, which include activity logs, including a description of the monitoring operations. However, it doesn't really require the level of detail that I think Broomfield is hoping for. It really just, discusses what phase of development they're in. And then also, CDPHE, the operators are only required to provide that information as part of their monthly monitoring report. So we don't have any authority to compel them to provide it outside of that process. However, in light of a lot of the questions that we've been receiving from the Broomfield community, the Air Pollution Control Division staff did expedite their review of Extraction's December air monitoring report. And they just released that last night, and I believe they have shared that with Broomfield staff. And part of that, they've also requested some additional information. So if we could see if we can get some more details about any activities that were occurring on December 4th, which is around when the emission spikes were recorded by Broomfield's monitoring system. So just wanted to share that additional bit of context. And also that's a nice little segue into the comment that I wanted to make during tomorrow's Air Quality Control Commission hearing. Staff with the Air Pollution Control Division will be providing a briefing to update their commissioners on the oil and gas pre-production monitoring program that they've been implementing. And I know COGCC commissioners won't be able to attend because you'll be busy with the financial assurances, but wanted to make sure members of the public and other folks listening in are aware of that briefing tomorrow. So thanks for the opportunity to comment.
Commissioner Hackett, will that, I assume that meeting would be taped so that we might be able to listen in later at a time when we're not embroiled in financial assurance rulemaking?
That is correct, Chair Robbins. And the meeting materials are already posted on the Air Commission's website, so you can scan through the presentation documents, and a recording, just an audio recording, will be made available after the hearing.
Excellent. All right. Thank you very much. Anything further from commissioners before we dive into our agenda? All right, then we will take up the agendized items. The first matter we have is a consent agenda. There are several pooling and several spacing applications with recommended orders from our hearing officer. Do any commissioners have questions with regard to the consent agenda items? Seeing no questions, do we have a motion to approve consent agenda?
So moved.
Second.
A motion from Commissioner Gonzalez and a second from Commissioner Nanjapa. Any further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Consent agenda is approved unanimously. We now will take up docket number 2107-00114. This is an application by Mcgee Oil and Gas Onshore LP for a OGDP labeled the Longs Peak Oil and Gas Development Plan. We will take this matter up in order. We will first hear from public comments from officials from the town of Firestone. We will then hear from public comment folks that have signed up, and I believe we have approximately 39 folks that have signed up for public comment. Each person will be entitled to 3 minutes of public comment. We then will hear from Mcgee with regard to the presentation, and then we will have an opportunity for commissioner questions and deliberations. I do note for the record that we will have with us individuals from our staff, from our permitting staff, if we have questions relevant to any of the presentations or this application. Hearings Manager Larson, did I get all that right? And are we ready to go with officials from the town of Firestone? I see you brought them to the panel. Okay. With that, I believe that we will first hear from the Mayor of Firestone, Frank Jimenez. Are you there with us?
Yes, sir.
Good morning. Can you test your microphone for us to make sure we can hear you pretty good?
Good morning. This is Frank Jimenez. Are you able to hear me?
Yes, we are.
Perfect. All right. Thank you. Good morning. My name is Frank Jimenez. I'm a trustee and mayor pro tem of the town of Firestone. I've served on the board for nearly 4 years. Address is 9950 Park Avenue, in Firestone, Colorado, 80504. I'm here to speak in favor of the Mcgee Longs Peak plan. Our residents of Firestone largely support, as you likely know, oil and gas operations in Colorado and in Weld County. Many of our residents are employed or otherwise affected by oil and gas operations. And even those that are not or may have initially had some sort of objection to the plan, favor landowners' rights and landowners' ability to use land in ways that they so choose. As I mentioned, there were some individuals that had initially had some concern with the project, but the applicant responded to those concerns, and it did so in a way that was favorable to many of those that had initially had objections, and with their support for landowners' rights, so now support the project as a whole. But really, most importantly, I think we need to note that the removal of the 39 wells and 10 facilities this project will bring benefits the town as a whole. We're consolidating operations into a much smaller area. We are potentially plugging in abandoned sites that are throughout the town of Firestone and affect many, many residents. And really, when you look at the plan to plug and abandon some of these 39 wells, 2 of the sites are in close proximity to the current proposed site, which ultimately many argue will benefit even those residents in that area. One of the other things I like to mention is the applicant has always been willing to work with town residents. They've always shown me and my neighbors a willingness to listen to residents, to accommodate needs as best as possible. And I think they truly do show an understanding and a willingness to listen to the concerns of residents and address them in any way possible. And because of that, I would just like to reaffirm my support of the project on behalf of myself and those that I've spoken with that also support the project.
Thank you, Mayor, for the comments. We normally just listen to comments, but this is a very critical issue for us. And so I, in particular, had a couple of questions for you, if that's okay.
Sure.
So I understand that in 2021, the town entered into an operator agreement with between Firestone and Mcgee, and that as a result of that, provided you supported the application, you would receive a donation of land. Can you talk to me about that? The operator agreement doesn't go into detail about that, and I find that to be an interesting twist.
Sure, I will start, and I'll probably defer over to our staff, who can probably speak to it much better than I can. But yeah, as part of the operating agreement, there is a donation of 78 acres in the southwest corner of Grant Avenue and Frontier Street. Adrian, can you maybe speak to that a little bit further?
So this is AJ Krieger. I'm the town manager. Chairman Robbins, I am scheduled, I believe, to be the 3rd public commenter. I am happy to try and deal with your question right now, or I can wait until it's my turn to speak, whatever you wish.
Well, why don't you deal with the question now, and then that way you still get 3 minutes to talk on whatever you would like to talk, because this is something that's interesting to me.
To my 3 minutes. Mr. Robbins, you are in fact correct. In 2021, the spring of 21, our board of trustees approved what we call a cooperative development agreement with Mcgee. One of the things that it provides for is the donation of 78 acres of land. That's correct. And I can talk for a second about what we anticipate doing with that 78 acres of land. But it also specifically provides for there being no assurance of approval. There's a specific separation of that agreement. And that's why we took it on a very separate track. There's no link between the board approval of that agreement and an eventual approval of a special review use application, Mcgee ultimately submitted. And if you read the agreement, and you probably have, you'll also note the specific requirements that Mcgee as the applicant conform and completely comply with all the other facets of our town code, including our land development code. And then finally, it also provides for some operational standards and some mitigation measures. And other agreements around the region, you'll sometimes, I think, see these referred to as BMPs. We just call them operational standards. But those are specific standards that we know from experience are important to residents and are the things that wind up impacting residents within any close proximity to these sites. These are the things that have at times the greatest impact while the operations are occurring.
Yeah, no, I did. I went back and I read through the agreement. In my former life, I was involved in representing local governments in these sort of development agreements, as you may be aware, Mr. Krieger. So appreciate those comments. I think what I'll do is I'll let the additional members of the trustee and yourself, Mr. Krieger, provide your testimony. I do have some follow-up questions, but maybe I'll wait until after we hear from Mr. Daugherty, is that right? The next Firestone trustee that is going to present.
Yes. Good, thank you, commissioners. I'm Sean Daugherty, and I'm a trustee. I've been trustee of Firestone for 2 years. Address is 9950 Park Avenue, Firestone, 80504. And you know, this site, when we had our town meeting a few weeks ago, I was very surprised. I was expecting the local neighbors, you know, for pretty obvious reasons, since it's within their visual sight line, to have a lot of opposition. What I was very surprised with is that not only during public comment, we had members in support, but we've received 40 letters of support as well for the project. You know, my ears are most in tune to the things that are most critical to our residents, and those are the risks that are involved. And as that hearing unfolded, as that public meeting unfolded, I was actually surprisingly and significantly impressed with the kind of above and beyond risk mitigation features and investment that Mcgee was making into the site, regarding, you know, state-of-the-art noise reduction technology, odor reduction technology, and odor elimination technology to some extent. You know, just an incredibly robust third-party contracted master traffic plan that showed a tremendous amount of effort in response to traffic data in the ways that traffic would be managed around this site. You know, the water transportation, I mean, an incredible effect on the limitation of traffic issues with underground water facilitation, and air quality monitoring. I mean, at every point, my ears became more open, because I went in with, you know, you got to prove it. And I know these residents and the ones that are looking at this thing, they're upset about this. And I over the course of that presentation, I became somewhat impressed, and actually significantly impressed, ultimately with to me, the main factor. I think as folks have communicated their concerns, and some were health and some were traffic, the common element in every single concern is, I don't want to be looking at this thing. This is big, and it's material, and it's industrial, and it's an aesthetic issue. I got out of this that this really was primarily an aesthetic issue for the residents in close proximity, and I was incredibly impressed with Mcgee's focus on that issue, and actually on a neighbor by neighbor basis, depending on the, I'm sorry, I'm not there, but they're going way above and beyond in terms of making aesthetic improvements to this to make it visually bearable. Thank you.
Thank you, trustee Guillory. Town Administrator Krieger, we now recognize you for 3 minutes, and then I do have a follow-up or two after you're done.
Thank you. Good morning, Chair Robbins and members of the commission. I'm AJ Krieger. I'm the town manager here in Firestone. My address is 9950 Park Avenue in Firestone, Colorado, 80504. This application represents for the town of Firestone, our first application, and what I would call the post Senate Bill 181 and the related rulemaking environment. And as such, one of the things that I want to assure the commission of is that there was a very careful and thorough and diligent staff review of this application. And it really followed an extensive pre-planning effort. And I'll get into that in just a second. We recognize that, we attempted throughout our process, both with Mcgee prior to the hearings and then between the Planning Commission and the Board of Trustee hearings, to respond to and to mitigate impacts cited and concerns cited by residents. And we appreciate that that's somewhat of a subjective determination, but we believe the record will show that in every substantive concern raised either by the Planning Commission or by concerned citizens, that we attempted to respond and it provided for specific mitigations. I'll talk about a couple of those in a second. I think a careful review of the testimony and the public record will show that there were maybe some sub areas of concern, but two primary areas of concerns were about traffic. And I will note that we actually even continued the public hearing to provide additional time for Mcgee to respond specifically to traffic mitigation measures, and they did that. And you also, of course, heard from Trustee Doherty talk about what residents expressed as a concern over visual impacts and aesthetics, and Mcgee did quite a bit of work, including, as he mentioned, a commitment in front of our board to work on a neighbor-to-neighbor kind of a case-by-case basis with residents. And our board noted that, and I think led in part to the approval. What I want to assure the commission of is that there's a history in Firestone of working in a cooperative way to achieve some balance and some peaceful coexistence between energy development and the quality of life in a growing community. And I really think this application serves as a good example of that. Everything we've done, including board consideration and approval of the cooperative development plan agreement, has been done in complete and full transparency. There's testimony and a public record associated with the various public hearings. And what I think our board tried to pursue and ultimately was successful of was achieving balance that also provides some widespread benefit to the entire town. So thank you for the opportunity to speak, and I'm happy to answer any questions the commission might have.
Thank you, Mr. Krieger. Appreciate the town of Firestone officials and administration testifying before us today. You discussed in your testimony the Planning Commission's review of the matter, and my understanding is that the Planning Commission denied the McGavin pad and approved the Columbine pad. I tried to go online to sort of listen to that, and I was completely unsuccessful in being able to figure out how to do that, and that's on my part, so I apologize. But Mr. Krieger, if you could you provide some perspective around the Planning Commission's approval of Columbine location and denial of McGavin?
Yes, and I was just jotting down a couple of notes to remind myself as I answer your question. One is, I like to joke sometimes, I'm always the bureaucrat in the room. And so actually what our Plan Commission does do is provide a recommendation to the Board of Trustees about approval or denial. They don't specifically approve or deny any application. So you are correct when you refer to the Planning Commission having what you might call a positive disposition on the Columbine site. They unanimously recommended approval there. and recommended denial of the McGavin site. In reviewing the recommendation and being familiar with the Plan Commission hearing itself, I think it comes down to a couple different factors. One being compatibility. I think that the Plan Commission felt like there was a lack of compatibility at the McGavin site. And I testified during the Board of Trustees public hearing that I believe that to be in error. And I'll explain to you and the commission why I said that. One, the town's comprehensive master plan specifically refers to and provides for oil and gas development and energy production throughout the town of Firestone. And it recognizes it as not only a permitted use, and which I'll get to in a second, but also as something that is in the town's best interest to provide for it. Two, it is via the special review use process. Energy drilling and production is an approved use in every land use classification and every category. So our land development code specifically provides for oil and gas development and every zoning classification, subject to a specific set of circumstances and rules. And then three, in 2020, our board adopted a comprehensive rewrite of the Firestone Land Development Code. And in that land development code, we updated, and depending upon your perspective, you might say, made more restrictive regulations for oil and gas within the zoning classifications. So I think there is sufficient record to support that the town of Firestone believes that energy exploration and production are in fact compatible with other land uses in the town. The other primary area where there was some concern in the Plan Commission was over traffic. And Commission, you guys probably see this all the time. Some of these numbers and some of these traffic studies and analysis can get a little bit confusing. And what I know happened in the Plan Commission consideration of the McGavin side in particular was there was a misunderstanding about some of the traffic analysis of the traffic study, such that as there was discussion about the traffic impacts and traffic counts, et cetera, those numbers were actually inflated, that they were actually overstated in terms of what the study and what the analysis showed. And so that became, a primary focus for us as we prepared and as we directed, by we I mean town staff. As town staff prepared for the Board of Trustee meeting and as we directed Kurt Mcgee to be prepared to be responsive to those issues. That's one of the things we wanted them to focus on, was making sure that there was a more accurate portrayal of the traffic study, and so that the Board of Trustees could have a better understanding of the associated impacts, et cetera. But I think the Plan Commission only focused on a couple of those areas. As I said, as I testified during the Board of Trustees hearing, I think they reached those conclusions there.
Thank you very much, Mr. Krieger. Appreciate the additional explanation from the town's perspective. Don't know that I have any additional questions. Does any other commissioners have questions with regard to the Firestone officials?
Chair Robbins.
We've got three hands that shot up all at the same time, but I think I saw Hackett and then Messner and then McGowan in that order.
Thank you, Chair Robbins, and thank you for the comments from the Firestone staff. I did have a question. I'm curious, how often or how frequent is it where the Board of Trustees approves a project, whether it's oil and gas or not, that has been recommended for denial by the Planning Commission? Is that a frequent occurrence or not very frequent?
I think it's relatively infrequent. I can't tell you this is the 8th time or the 6th time. I don't know. I would only be guessing. But I would say, obviously, it's provided for, and particularly given the different roles of the Plan Commission and the Board of Trustees. So I can't answer a specific question about how many times. And yeah, I would say it's relatively infrequent, but certainly not unheard of.
Commissioner Messner.
Thank you, Mr. Chair. And thank you all for participating today. I just for the record, I wanted to make sure that you all are speaking for the Board of Trustees for the town of Firestone and not as individuals. Is that correct?
That's correct. I think you heard the Mayor Pro Tem and Trustee Doherty speak on behalf of the town as elected officials, and myself, AJ Krieger, as town manager.
Okay, thank you. Just trying to better understand the land use review process in the town of Firestone, and I do understand based on your testimony that you've got a planning commission review that makes a recommendation to the Board of Trustees, and then the Board of Trustees makes a final determination on that. In your review process, do you allow for additional information to be provided to the Board of Trustees that was not available to the Planning Commission, or does the Board of Trustees need to make a decision based on the record that the Planning Commission and the information provided to the Planning Commission?
Actually, I think that's a terrific question. As a matter of fact, they wind up being separate and independent quasi-judicial hearings, up to and including a prohibition for Board of Trustee members. They can't even attend a Plan Commission hearing. The decision that the Board of Trustees makes during any quasi-judicial matter has to be based on the specific evidence and testimony provided during that specific singular public hearing. So to your question, it isn't unusual. In fact, it probably happens often that additional information, perhaps for context or better overall explanation, is provided to a Board of Trustees after a Plan Commission hearing. I think that's common and is probably generally expected, because both the applicant can, in that case, benefit from the Plan Commission's questions and analysis. Town staff will often direct the applicant based on the Plan Commission's input. And so, yeah, but they're completely separate and independent quasi-judicial hearings.
Okay, thank you. In your land review standards, understanding that the Planning Commission, one of the pieces that they utilized in making their recommendation was a compatibility standard. Is there a compatibility standard in your land use codes for oil and gas development?
Well, I don't know that it's labeled compatibility standard, but what you would look at would be compliance with the code, certainly. And in this application, there was a specific determination made by our professional staff that it was in compliance. The application is in compliance with town code. There's a recitation of approval criteria, and that was a part of both hearings. And as I say, I think the general reliance on compatibility makes specific reference to the overall master plan, or sometimes called comprehensive plan, and the presence of approval criteria and the presence of specific guidelines and standards within each zoning classification.
Okay. And just last question, and just keep in mind, I'm just making sure that I understand your land use review process and I'm not picking on you. The final determination, the final decision by the Board of Trustees, did that include any conditions of approval over and above what the applicant provided in their application?
Well, it does have specific conditions of approval. Marty, do you have that? For instance, one of those conditions of approval is that, bear with me 1 quick second. Yeah, Marty handed it to me upside down, which made it easier. But one of the specific conditions of approval is came about as a part of the testimony and a part of the public hearing, there was concern expressed by our board of trustees about Pine Cone in particular, that is the public street on the north side of the well pad of the site. And there's a condition of approval that Mcgee will enter into a subdivision agreement, or sometimes called a development agreement. And among other things, it will provide for a widening and an improvement of Pine Cone that was in large part driven by that traffic analysis and resident comments. And there are others that deal with providing for, they're going to have to construct a trail. There are conditions, attached to the FDP, to the site plan, et cetera. But they're absolutely, they got to build a fire hydrant. I can't do this from memory, but there are absolutely specific conditions of approval that will be informed by the evidence provided during the public hearing and the board of trustees deliberations and their direction to town staff.
Okay. Thank you very much. I appreciate your responses to my questions.
Commissioner McGowan.
Thank you, Mr. Chair, and thanks for testifying this morning. It's helpful to have this perspective. I'm wondering if you all had discussions with the operator about potentially, and I'm talking about the McGavin site, using a different location, potentially maybe owned by the town that was further away from any RBUs. And are there any potential sites that could be used instead of the one that's being proposed that are further away from residential building units?
So you asked a multi-part question, so forgive me if I don't touch on everything. But going all the way back to the spring of 21, as a town staff, we actually participated in, I think they call it, the commission calls it, or the COGCC calls it, a pre-application meeting. And as town staff, we participated in that pre-application meeting, and we had already seen some of the alternate location analysis that we knew Mcgee was going to present. And so we were aware of it, and we listened to it during the presentation that day. So we were aware of other sites that they've looked at. And, we try and refrain from picking a site. We let the operator do that, and we let the commission go through its review process. But we were aware and I think comfortable with their alternate location analysis.
Mr. Krieger, just as follow-up to that, help me with the timing. Did that occur after the cooperative agreement was entered into?
I'm doing this from memory. I believe it happened. I do believe it happened afterwards, but they were very close in proximity. But I do think the pre-application was after board consideration of the cooperative development agreement.
Okay. And in further follow-up, you mentioned the receipt of a parcel of land of approximately 75 acres. What is the town planning on doing with that parcel of land? And how did that transfer of parcel of land play into consideration of oil and gas development?
Thank you. So I would say generally, we have made no specific commitments on future use of the land because we don't know if will actually be needed to us. What we generally contemplate is an expansion of an adjacent park, probably an open space and trail, an extension of an open space and trail corridor through the 78-acre piece. And then also probably some residential developments. So maybe getting a little bit into the weeds, but to try and give you an answer to a question. The area, the 78 acres is adjacent to our historic Old Town neighborhood. And we have just completed a sub-area plan of that neighborhood that contains with it some specific recommendations. One of our board's goals is to increase the availability of affordable or attainable housing options. And we think that town ownership of the parcel will help us better pursue that objective. But we have no set plans and we've made no specific commitments because we don't yet know if it's going to get deeded to us. And as for the second part of your question, I think as a town staff, we were diligent and intentional about separating the two, meaning the cooperative development agreement and also the land use application. We made no assurances, we made no guarantees. We, as a town staff, we can't. We have no idea what the plan commission and board of trustees will eventually do with it. But we did everything we did in a deliberate, transparent way so that people would know about it. And we've never hidden it. We think it's ultimately, should the land be deeded to the town, it'll be a significant benefit to the town. And we think it's an example of the benefit that can come from cooperating and seeking that balanced approach, if you will, for energy development. But we made no assurance. We specifically provided in that cooperative development agreement that the applicant, Mcgee, would have to strictly adhere to town code and to our land development code. So we did everything we could to transparently separate the two.
Mr. Krieger, could you also speak to the right of first refusal to the 15-acre pine cone parcel, and what that's all about?
So the 15 acres at the intersection of Colorado and Pinecone is, I think, long-term for the town of Firestone. It's potentially a desirable and important corner, and we want to manage future land uses there if it ever happens. If Mcgee ever decides to sell the land, we wanted to position the town as a potential buyer for it. But simply put, it's in a desire to control the eventual development there and make sure it's of a quality that matches the surrounding neighborhoods.
Okay. And I think this is finally, but I don't ever want to say that as a lawyer. So I looked at your code and you reviewed the oil and gas plan as a special use review. Is that right, Mr. Krieger?
Special review.
Okay. And under that, the board would have to have made a finding that the proposed use is, quote, compatible with adjacent uses in terms of scale, site design, operating characteristics, hours of operation, traffic generation, lighting, noise, odor, dust, and other external impacts. I'm quoting, I think section 16.3.2. Is that the determination that Commissioner Messner was asking you about that the board undertook in its review?
In terms of compatibility?
Yeah.
I certainly think it's one of the factors they considered, yes. I mean, I think they relied, as any elected board would do, they relied on testimony provided and staff analysis, but yes, I think they relied on that.
Okay. And would the Planning Commission have been relying upon the same criteria when it made its determination, noting for the record that you indicate there was additional information provided to the board after the Planning Commission?
With that clarification, that caveat that you just spoke of, yes.
Okay. I'm just trying to get the full set of circumstances from the town's perspective. I really appreciate town officials for being with us this morning and starting off with regard to this consideration. I believe Commissioner McGowan has a follow-up question.
Thank you, Mr. Chair. Sorry, I had another question I didn't get to finish. I'm wondering if you all saw the CDPHE consultation letter and if you could give me your thoughts about it.
The letter that would have been in mid-January from Mr. Hackett.
Yes.
That letter. Yes, we saw it, and we spoke to Mcgee about it. Generally, those things are outside of the town's land development code, But yes, we're familiar with it. We saw it and we were familiar with it, and we did speak to the applicant / operator about it. Yes.
Any follow-up, Commissioner McGowan?
Thank you, Mr. Chair. So I guess what I'm asking is, there are some, I think, some recommendations from CDPHE and conditions of approval, and some specific recommendations around things they'd like to see the applicant do that are more protective of public health and the environment. And I'm just curious to know if your discussions with the applicant gave you assurances that what the operator is requesting as part of their permit satisfies the concerns of the department in your mind?
I think some of those were of a technical nature that might be beyond, town staff expertise and areas, as I say, that's what I meant by outside of our land use code and land use purview. I do know that there was a good deal of discussion between the applicant, Mcgee, and our board of trustees about the rig itself and about options and alternatives there. And I ultimately believe, as evidenced by the positive vote, that our board was satisfied with the applicant's answers.
Okay. Thank you so much for being here today.
Sure, thank you.
Any further questions from commissioners? Commissioner Hackett, then Commissioner Nanjapa.
Thank you, Mr. Chair. And I did have a question. Later this morning, if commissioners would like, I can give more detail about the CDPHE recommendation on the CAML, the Colorado Air Monitoring Mobile Laboratory. So I'm happy to provide that detail later this morning. But the short of it is, right now we don't have a location to sample from. Mcgee will be, if this location is approved, they'll be sharing some of their stakeholder contact info with us. And then CDPHE will be reaching out to private homeowners to see if they might be willing to host that and willing to let us have electricity installed, which hopefully I believe Mcgee is open to paying for. But there's no guarantee that we'll be successful in securing that location. So I just kind of wanted to respectfully put that out there to the town of Firestone. If you do have any land holdings in that area, especially along the western portion of Pinecone Avenue, and if there's any way you can help facilitate us lining up an air monitoring location, we have considerable interest in monitoring at this location, given the sheer number of people nearby. So just wanted to kind of put that out there. And again, I'll provide more detail later this morning on the status of the CAML.
Mr. Robbins, would you like the town to respond?
Yes, please.
So, as Mr. Hackett will remember, we actually, as individuals working for a previous agency, have had a lot of experience with the CAML. In fact, it was a former colleague of ours that will claim credit for coming up with the acronym, and I'm not kidding. But anyway, we in a previous agency utilized the CAML and cooperated with CDPHE for the CAML's use for some extended periods of time. I think the simple answer to your question is yes. I know the town would cooperate, and to the extent that we control a piece of land that would be suitable, I'm sure the board of trustees would look favorably upon that. And if we can help facilitate a discussion about a place to park it, and it'd be the exact right way to say it, but a place to park it and a place to conduct the analysis, we're happy to help in any way that we can.
Thank you for that, Mr. Krieger. That was the only question I had.
Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you all for being here. I agree, it's helpful to have your perspective on these matters. I was curious about the new subdivision that is platted, that is closer to the Columbine location. Can you tell me a little bit more, if you know who the landowners are, or what the status of the mineral rights are for those parcels? Have they been severed, in other words, or are they going along with the properties? Go ahead.
Commissioner, so are you talking about the residential development to the south?
Correct, near the Columbine location.
Yes, ma'am. So that is in the town of Frederick.
Okay, thank you. Sorry.
So no, that's fine. I don't know the answers to the other questions.
Okay, apologies. That's my own confusion. Thank you.
Any further questions for the town officials? All right. Again, we, as a commission, I think wholeheartedly appreciate your being here with us today and for providing the perspective that you have this morning.
Thank you, and I know that on behalf of the town, we certainly appreciate the opportunity to participate.
Very good, very good. Okay, we will continue down our public comment list. Next up, we have Mr. Michael Freeman, who has 3 minutes to provide information to us.
Good morning, Chair Robbins. Can you all hear me?
We can.
Great. Thank you. My name is Michael Freeman. I'm here on behalf of Earth Justice, and I'd like to thank you all for allowing public comment today. We submitted a written statement last week, and I'm happy to answer any questions about those points. But this morning, I'd just like to highlight a few points. The commission should reject the Longs Peak OGDP because Mcgee is asking you to interpret Rule 604 to make the setback from homes essentially meaningless. Under Mcgee's approach, operators could drill within 2,000 feet of homes merely by complying with the commission's other regulations, such as the 400 series, and adopting some other mitigation measures with the commission on just an ad hoc basis. That approach contradicts the plain language of Rule 604 and would disregard the entire purpose of the setback regulation, as well as Senate Bill 181. The central point of 604B is this commission's recognition in emission change rules that putting distance between drilling and homes is a critical part of avoiding and minimizing adverse impacts. Just geographic distance provides benefits for avoiding impacts that go above and beyond what are offered by control technologies or other operational measures. And that's why Rule 604 applies in addition to compliance with all other commission regulations. And Mcgee's application just ignores the purpose of Rule 604. Mcgee is asking you to rule that its best management practices and other mitigation commitments are substantially equivalent to complying with the setback, but it's offered no evidence to support that finding. There's no discussion in its application about how its efforts on noise or odor or other plans compare with moving its operations further away from people's homes. I also note that the CDPHE has suggested doing modeling of benzene exposures to assess how Mcgee's operations would compare to moving them farther back from homes. And not only has Mcgee not done modeling, but as you've noted, Mcgee has rejected the CDPHE's recommendations to use additional protections that are in use elsewhere on the Front Range. Now, we understand that the town of Firestone supports these locations, but that support doesn't override this commission's rules. The commission has an independent duty to determine whether these locations are substantially equivalent to a 2,000-foot buffer. That buffer serves to protect nearby residents, not just the goals of the town government. And in fact, much of the reason this commission adopted the setback in the first place was because local governments, especially in Weld County, were approving drilling close to people's homes. So we asked this commission to make its own independent assessment of this proposal. In short, we are asking this commission to follow through on the commitments that you made in the mission change rules and require Mcgee to offer a proposal that complies with Rule 604 if it wants to drill in this area. Thank you.
Thank you, Mr. Freeman. You and I have worked together quite a bit over the years. I appreciate your intelligence and the thoughts that you bring. I do have a significant issue with one element of your presentation, and I want to correct the record. We do not have a 2,000-foot setback. We have a 2,000-foot siting requirement, and I think you're well aware of that. And I would like everyone to be aware that as we make determinations of whether to approve or not approve things within 2,000 feet, we are looking at 604, Rule 604. So just want to clarify that we take our job very seriously, and we will do everything we can to arrive at the correct determination today. But I do believe that you are mischaracterizing how we have set up our rules and regulations. And I know you want to respond, so I will recognize you for a response.
Thank you, Chair Robbins. With all respect, the statement of basis of purpose for that rule expressly refers to Rule 604 as a presumptive setback. And the language of the rule says no locations within 500 to 2,000 feet unless certain exceptions are met. And one of those exceptions on which Mcgee is relying is the substantial equivalent exception. Our point is that Mcgee doesn't satisfy and hasn't shown that that exception applies.
Very good. And smart lawyers, not saying I'm a smart lawyer, can disagree on what was meant, and we will rely on our record. Thank you very much. Does any commissioner, so I do note that Mr. Freeman did provide us with substantial written comment, which we appreciate receiving and appreciate the work that was done on behalf of, I think, not only Earth Justice, but Logic as well. So we appreciate that and want to recognize that you are also representing the League of Oil and Gas Impacted Coloradans. Does any commissioner have questions about that submittal that was approximately 12, 13 pages long, 14, et cetera? I want to give us opportunity to ask more specific questions, Mr. Freeman. All right, well, you obviously did a very good job with regard to that submittal because we don't have any questions. I know we've all read it and appreciate your bringing those perspectives to us with regard to your submittal.
Thank you.
Okay, I believe we're going to go a little bit out of order because there is a stakeholder that has to leave at 10, and we want to recognize that stakeholder, and that is Danny Fletcher. So if we could bring Danny Fletcher to the panel, we can hear.
Hi, I hope you can hear me all right. My name is Danny Fletcher. I do live in the Saddleback Heights neighborhood within 2,000 feet of the proposed McGavin site. Just for some background, I am a mother of 2 young kids, and when I first heard about this proposed oil site, I was a mix of emotions. I was concerned, scared, appalled, and angry. I know that you guys are all experts, but I don't think any of you live in this area. So, I mean, this is coming from me as a non-expert, but as a resident. My initial thought was, how could the town of Firestone allow this? I had a college roommate who was an environmental scientist, so I've heard for years of the ample negative impacts of these sort of sites on a community and their environments around them. Not only that, but with the recent Firestone tragedy only a few years ago, looming still in our minds, it's a little bit scary to think about the potential carelessness of oil workers and what that could impact the community with. The survivor of that incident had actually lived a few doors down from me and recently moved, and I'm so glad that she did, because if I could think of her feelings on this, I would hate to feel it. With the Senate Bill 181, I was under the impression that the health and the safety of the community came before the income of companies. Living within that 2,000-foot bubble, I have made a point in attending all of these meetings. More and more, as information comes to light through the experts and other community members about this project, and I've been feeling disgusted and violated. The entire situation is completely shifty and underhanded sounding when it's coming to the community. When you're hearing about parcels of land being exchanged, that is not something that voters or community members want to hear. When we are hearing about what the company plans to do themselves to help mitigate things, it also comes out as being not completely open and honest. The company wouldn't even disclose facts as simple as what essential oils they would be pumping into our air. Not all essential oils are good for every person, every age, every ailment, every gender, and certainly not every animal. We have the right to know what is going into our air, not just from the pollution standpoint, but from the minerals. Forget about that and move on to the noise, traffic, the displacement of the animals, the ruined beauty of the area, and the roads. Then with the oil company's own emission, it sounds like, again, there's that gift of land. Is that even legal? And is it okay for the town of Firestone to put our health, safety, and ways of life up for barter in exchange for land of that nature. None of this feels right to me or the neighbors around me. It just feels wrong.
Thank you for participating with us this morning and for your presentation. We do appreciate it. We now will go back to our previous agenda and move down the list for public commenters. And next up is Phil Doe. Mr. Doe, I do believe we have you as a panelist if you want to unmute.
Oh, okay. All right. Let me just say that you set a standard of 2,000 feet, which isn't a standard apparently. It's just what lawyers think it should be on any given day. Let me say that the state of California, through scientific investigations of a panel of scientists, has determined that the minimum setback is 3,200 feet. How you people can continue to ignore the pure science, the perfect scientific facts that are out there is beyond me. Explain to me, Mr. Robbins, why it is that the science that was conducted in California is not applicable to the situation here in Colorado. If it's 3,200 feet is the minimum in California, shouldn't it be 3,200 feet in Colorado? What science do you know, Mr. Robbins, that allows for such an exception? Please answer. Thank you.
Thank you, Mr. Doe, for your comments. We now will move to Barbara.
Would you like to answer my question?
We now will move to Barbara Mills Bria. Good morning, Ms. Mills Bria.
Good morning. As you know, my name is Barbara Mills Bria. I'm a retired structural engineer and I managed engineering group. And I worked in hydropower for 34 years. So I've been looking at the records that you guys keep in the COGCC database. And they indicate that Mcgee has reported over 200 spills releases since just a year ago. This is in the last year. And these, of course, are the only reported spills. So one could assume that there have been more, and if small enough, perhaps there's no need to report them. Since 2017, the database contains information on 476 spills, indicating that the spill rate has increased in the last year for this operator. One might ask how allowing a company with this record to perform its heavy, dirty industry closer than 2,000 feet from homes is protecting public health, safety, the environment, and wildlife. And it should be remembered that the 2,000 feet is rather arbitrary, as just indicated, since plumes of VOCs can travel farther, these dangerous chemicals. This commission, along with the career staff, has indicated their desire to offer whatever protection the industry needs, regardless of the law or the minimal way it has been implemented so far. One can only hope that the disregard for the intent of the law will stop now, and this operator will be held to the 2,000-foot distance so the harm to the people living near the facility will be somewhat reduced. Thank you.
Thank you, Ms. Mills Bria. We appreciate you being with us this morning. We now will call upon Mr. Weston Wilson.
Yes, can you hear me, commissioners?
Yes, we can hear you and we can see you.
Okay. What we heard from the town trustees was understandable focus by the residents on their concerns of what they can see or smell. So the mitigation offered by Mcgee has to do with noise mitigation, odor mitigation, and apparently something on aesthetics as well as the traffic. But obviously CDPHE has hit upon the key issue here. The reason we have at least a 2,000-foot setback requirement absent the waivers is because of benzene concentration. The ICF International report that came out in September 20 showed that there was benzene concentration out to 2,000 feet. Unfortunately, that report did not model beyond that distance. So certainly what the state is offering here to do modeling and measuring after the fact is inappropriate. We know from that report that there's an unhealthy exposure to benzene at this distance. And as you just heard, at least from one resident who was objecting, I don't think that you can conclude that all elements of 604B have been met. You must deny this project.
Thank you for your comments, Mr. Wilson. We appreciate you being with us and providing your comments. And now we'll call upon Suzanne Johnson.
Hello there. Good morning. My name is Suzanne Johnson, and I'm a new resident in the Saddleback neighborhood, the brand new lovely community within 2,000 feet of this proposed operation. I'm also the originator of Keep Firestone Beautiful, an online petition that was used to educate the community about this application. To date, we have over 800 signatures from people who are concerned about their health, safety, and quality of life, given the location of this proposed operation in the middle of a quiet residential area with beautiful recreation areas flanking their homes on this property. Nearly every day since I moved here, I have enjoyed walking and riding my bike along the Firestone Trail. The trail is peaceful, beautiful, and such a gift to this area of town. The trail starts at my neighborhood and heads west with a gorgeous view of the mountains and geese taking flight from Millivec Reservoir and then landing and grazing on the land of this proposal. And just 2 weeks ago, I was blessed with seeing two majestic bald eagles sitting in one of the trees on the south side of the proposed site. I had never seen bald eagles this close, and they were so beautiful. My photos and videos are treasures of this amazing encounter. These trees are within 50 feet of the proposed site, and I thought to myself, would those eagles be here if this operation were here? And then I thought, would I be on this trail if this operation were here? The Colorado Department of Public Health and Environment has recommended that this application be denied unless certain conditions be imposed to make the developments less impactful. Even with all the protective measures, most of which Mcgee has refused to implement, the development would still pose a major threat to public health and safety. If this enormous operation is approved, the answer to my question as to whether I would continue to use that trail would be no. I would no longer use the trail for walking and biking and enjoying the beauty of the land, the birds, and the wonderful air that I get to breathe. The risks to my health would just be too great. And this makes me really sad because I just love hopping on my bike and heading out for a ride to enjoy the land, pick up an item at Safeway, or have a coffee at the new Sterling coffee shop. And finally, I'd like to say that I disagree with Trustee Doherty. Many of us who spoke at not only the Planning Commission, but the Town of Trustees public hearing, were really talking about health concerns. Many cited studies about the impact to health when a facility like this is so close to their homes. So I would respectfully ask you that you deny this application and that you protect our health, our safety, the welfare, the environment we've grown to love, and on behalf of those majestic bald eagles, the beautiful wildlife resources. Thank you for listening, for being so serious and thoughtful with this decision that will impact many for decades to come. Thank you.
Thank you, Ms. Johnson. If you could stand by, I have a couple of follow-up questions. One, am I hearing your testimony correct that if this were to move forward, that the trail that is nearby would no longer, from your opinion, be something that you would use?
That's correct, Mr. Robbins. It flanks the actual development of this within feet. And while there have been mitigation proposed, albeit a cinder block wall, plants, maybe shrubbery, xeriscaping, I just can't imagine how that could mitigate the beauty of the trail that we have. And so to answer your question, no, I would not continue to use that trail. I would have to throw my bike in the car and actually drive somewhere, which is unusual for Colorado. A lot of us are blessed with being able to hop on no carbon footprint and just go.
Thank you for the clarification. You also, I think, testified that you spoke at the Planning Commission. Is that right?
Yes, sir, that's correct.
Did you attend the Planning Commission deliberation?
Yes, I was there for the whole meeting.
Can you give me your perspective of the Planning Commission's approach and deliberation?
I thought they were quite thoughtful in listening to not only each of the people who spoke at the public hearing, but had many good questions for town staff, many good questions for the applicant. So that I thought they were thorough in gathering the information that they had with the meeting time that they had, and that they were thoughtful. And they also were conversing with town legal too, I believe, on making sure that they were within criteria of the application. And so that's why many of us were very surprised that the recommendation to not approve, that the town indeed still did approve it, considering the thoughtful deliberations that took place at that meeting.
Thank you for the additional testimony.
You're welcome.
Other questions from commissioners? We appreciate you being with us this morning.
Thank you.
We now will turn to William Mcgee. I may have butchered that name. Apologize.
It's Mcgee, and you're fine, Mr. Robbins. I appreciate it. Can everyone hear me?
We can, and we can also see you.
Great, thank you. Mr. Chairman, commissioners, and commission staff, thank you for the opportunity to speak with you today, and thank you for your service to the state of Colorado and the citizens. My name is William Bill Mcgee. Along with my wife, Lisa, I live at 8837 Falcon Street in Firestone, Colorado. We have lived here in the Falcon Point at Saddleback subdivision for just over a year. I attended and testified at both the Planning and Zoning Commission hearing and the Board of Trustees hearing. I'm here today to ask you to vote no and oppose the approval of Mcgee's Longs Peak Oil and Gas Development Plan. I agree with many of the public comments that you received, and particularly highlight the letter you received in council from the Colorado Department of Public Health and Environment. Personally, I do not want this facility within 2,000 feet of my patio and backyard. It places me and my family at unnecessary and avoidable risk, exactly what the commission's regulations seek to prevent. We had no idea any of this was being considered when we bought our lot in June of 2020, nor when we moved in on December 29th, 2020. Quite simply, this large project does not belong in this highly populated residential area. I firmly believe oil and gas wells and a production facility at the corner of Pinecone Avenue and Colorado Boulevard in Firestone makes no sense for this area. Is it zoned to accommodate this? Yes, of course. Is it within the rules in the town code to put it there? Yes. But just because you can do something doesn't mean you should. This proposed site is surrounded by densely populated residential areas, a fantastic asset in the Firestone Trail that Ms. Johnson has already talked about, 2 golf courses, and a reservoir with its walking path. Many of these public locations and residencies are within 2,000 feet of this proposed facility, many quite closer. Locating an oil and gas production facility is just not consistent with the contemporary land use in the surrounding area. The Town of Firestone Zoning and Planning Commission thoughtfully deliberated, and they agreed, and as you know, voted to deny approval of Mcgee's application. It's been characterized in the Town of Trustees hearings that they were simply swayed by the overwhelming outpouring of support at the hearing and didn't thoughtfully consider the other things. I think that's a gross mischaracterization that was made by the Board of Trustees of the Zoning Commission's work. The 2,000-foot setback in COGC's regulations was put in place for a reason. Mcgee is trying to use the exception, claiming that location has substantially equivalent protections to a location that's 2,000 feet away. They've provided no evidence for this claim. In the end, no amount of mitigation can change the fact that approval of this application will result in wells and a production facility that permanently alter the landscape and environment in an area where it should never have been placed. Please deny the application for approval. Thank you so much.
Thank you, Mr. McGee. Quick question and follow up. Are you opposed? So this OGDP has two locations.
Right.
There's a proposed Columbine location and a proposed McGavin location. Is your testimony that both locations should be denied, or is it relevant to one location versus another?
Thank you, Mr. Robbins, for the question. I have no problem, quite frankly, with the Columbine location, and I didn't speak against that at either hearing. My concern is with the McGavin location.
And is your home located within 2,000 feet of McGavin?
It's just about 100 feet outside the 2,000 feet.
Okay. Thank you very much. Felt the
You're welcome.
Qualifying question was helpful for our consideration today.
You're welcome. Thank you.
Okay, continuing down the list, we now have Joe Walker. Or maybe not. Do we? Oh, there we go. Mr. Walker, we have promoted you as a panelist. If you want to unmute, we hopefully will be able to hear from you. Hearings Manager Larson, any ability to help Mr. Walker? Oh, I think someone just unmuted.
Did I get it?
You got it. Good job.
Awesome. So sorry. I'm Sherry Walker, and I'm going to speak for my husband, Joe. And so we've been married long enough, we can speak for one another. Can you hear me okay?
We can, and I agree with your statement about being married long enough you can speak for one another.
Only good things, right? I'm not an eloquent public speaker, and I'm going to be honest, I'm really a little nervous, but I'm just so full of emotion over this whole thing. I hope I can control myself and sound reasonable and grown up and speak eloquently. I totally agree with everything Danny Fletcher said this morning, everything, with all of the emotions, anger, and I can't believe it, and all of the things. I want to speak to the fact that Joe and I are both compromised health-wise. Joe is a two-time cancer patient, now battling with his second different cancer. He was an Army veteran exposed to Agent Orange back in the 60s. And no one knew back then what Agent Orange could do. It was to kill all of the vegetation. And later on, we find out that it harms and can kill people. I'm very concerned about this well site for health reasons. I disagreed with Trustee Doherty on the public comments that were made. It was mostly about the aesthetics, which I would agree. It's not lovely to look at one of those things, but our main concern is the health. One of the neighbors that I talked to at one of the meetings even told me she has really serious health concerns. I don't know if she is speaking today or one of her family members. And she said, on talking with her doctor, he said, if you are this close to this site, I suggest that you put your house on the market. It is unsafe for you. Joe and I, we're in our 70s. This is supposed to be our last home, and we hope to live our final days here. And I would please ask that you would not consider this for health concerns and other reasons. The other thing, I just really have a question to the town, though, is why did they allow this to be developed when they knew that this was a gas and oil possible production site, and allowing this? Why would they consider the sale of homes and home building to be so close to this site? We were led astray on that, and albeit it's our up to us because we didn't do all the due diligence in investigating all of the land. We were quite excited about this lovely home for us to retire and live our days in. And I'm very upset and angry that that did not happen. And speaking really quickly with, agreeing with Suzanne, hundreds and hundreds of geese every day are flying over our house. It's beautiful, the sound. And if she saw, I'm jealous that she got to see the bald eagles. But I'm mainly concerned my health. No one knows 10 years, 5 years, 20 years, which we may not be here then, what is going to happen to our health with all of the emissions from this well site. Thank you for listening. I'm not opposed to oil and gas. I'm opposed to it being this close to my home. I don't know any one of you guys that would want to live this close to an oil and well site. Thank you very much for listening.
Thank you, Sherry. You did a great job in testifying this morning, so pat yourself on the back. We appreciate it.
Thank you.
We want to thank your husband for his dedication and service to our country. I did have a follow-up question or two for you, if you could bear with.
Okay.
Where is your home in terms of location to McGavin and or Columbine proposed locations?
We're just east of the location. In fact, when they were working on an oil rig, we lived 2 or 3, maybe 4 houses down from Bill Mcgee. So whatever the feet that the distance was would be pretty equal to his. Whenever they were doing some work on the oil rig a few months ago, I could hear the sound of like a loud truck motor running, and I looked out front, I looked out back. Finally, I could see the oil rig, and I realized that's what it was. But we're very close. I can see it out my back door easily.
Miss, I'm sorry, I don't have your last name.
Sherry. I'm Sherry. You may call me Sherry.
Sherry, is your testimony opposed to both of the 2 locations, that is McGavin and Columbine, or just as to one, or could you clarify?
I'm going to be honest, I'm not crazy about the other one because I know we will be able to hear and see it as well. And I don't know the proper distance. I don't have the paperwork in front of me with the distance of the other one. But definitely opposed to this one. And I am greatly concerned. I've even thought if we would have to move, I don't know where we could move because Colorado prices have gone up at the houses so much. We would maybe have to even move out of state, which I don't want to do. I love it here. We've lived in Firestone 22.5 years. And I can't believe they would put something like this close to homes.
Okay. And when did you purchase the home that you're in now?
We moved in November with Thanksgiving Day of 2020, and we purchased it in April during the COVID, all of the mess of COVID. We purchased it in April of 19 or 20.
Okay.
Yeah, 20. Yeah. And nothing was mentioned about any well or oil site. We would not have purchased. No way would we have purchased a home if we had known that here.
Okay. Thank you very much for
Thank you
with us this morning, Ms. Walker.
Thank you very much.
We now will hear from Lori Anderson. Hi, Ms. Anderson. We've got you as a panelist. If you want to unmute, there we go. Now we can see you.
Yeah, there's a bit of a delay there. My name is Lori Anderson. I live about a half mile from large-scale oil and gas development in Broomfield, and I'm a Broomfield City Council member, though I do not represent the entire council or organization. My comments are related to future development and not in protest or objection to any existing permit. My comments focus specifically on the CDPHE recommendations, which provide important information for your consideration. However, these recommendations rely on a comparison of the McGavin pad to the extraction development in Broomfield, which was approved prior to SB 181. Neighborhood drilling, such as the Broomfield project, is what led to the need for and passage of SB 181. The subsequent COGCC rulemakings, including the party presentations and public testimony that led to the 2,000-foot setback, were based in part upon testimony from Broomfield residents and our experience. Perhaps technological advances in the future would lead to operations where emissions, noise, and other real impacts are controlled and substantially minimized, and safety and other aspects have been addressed, such that the operations actually provide substantially equivalent protections to the location being greater than 2,000 feet from residents. But we are not there at this point in time. Having the most protective conditions of approval does not thereby make the proposed well site protective of public health, safety, and welfare. Even with all the Broomfield BMPs in place, there have been a substantial number of health concerns filed by residents, which are clustered around the well sites, both within and beyond 2,000 feet. And this info is well documented in Broomfield's oil and gas related health concern summaries. Broomfield has a leading AQM program, and through advances in our monitoring program, we are capturing spikes in emissions, such as a recent benzene spike estimated at 224 parts per billion for a 1 hour duration, which is more than 20 times the ATSDR acute health guideline of 9 parts per billion. Although the focus of discussions has been on benzene, the state does not yet have enough research to understand which combination of chemicals in combination with elevated ozone and particulate matter is of most concern. However, these spikes of carcinogenic chemicals should be of concern, especially as you consider development within 2,000 feet of families. The CDPHE recommendations include only one reference to safety, stating the operator must send enhanced notifications to the nearby community. However, this places the onus of ensuring health and safety upon the very families that are being impacted and who have no authority over the operator. There is no mention of safety concerns, including well blowouts, fires, explosions, leaks, spills, or the heightened concern from wildfires. Recall the Stromberger fire and explosion, which utilized similar BMPs to Broomfield, the multiple separated fire near Berthoud, the Bennett fire during well completions, the Hudson well blowout that carried a mist of hydrocarbons over 2,000 feet and more. So these are not rare. The CDPHE recognizes that noise is more than just a nuisance, and it can result in health impacts. From Broomfield data, hydraulic fracturing and coiling and tubing were the top sources of noise that led to health impacts such as stress and anxiety from lack of sleep and disturbing to residents on a daily, nightly basis throughout these phases. The well sites in Broomfield also utilized the 32-foot sound walls on all 4 sides of the pads, despite the addition of a secondary sound wall and more hay bales to try to mitigate the noise at Livingston and the Northwest pads. Efforts to mitigate noise continue. I want to thank you for your time today, and I ask that you please prioritize the health and safety of nearby residents and deny the Longs Peak OGDP for the above reasons. Thank you.
Thank you, Ms. Anderson. Appreciate your being with us this morning.
Thank you.
All right, keeping down the list, we turn to James Sutton.
Hello.
Good morning.
Good morning. There we go. Thank you. My name is Jim Sutton, and I live in the Saddleback area, and I am speaking as a Firestone resident today. One of the big concerns I have about this is the amount of traffic that it's going to generate. The McGavin pad is on their own transportation report set to do about 45,000 truck trips. I know that when they brought in the traffic engineer later, they said that it was going to be about 25,000 round trips. I believe that's about the same number. It is also going to generate about 95,000 car equivalent trips, which is listed as being cars, SUVs, smaller trucks. So we're talking about adding 150,000 vehicle trips through a 2-lane road that has no shoulders and no sidewalks. It goes through 4 neighborhoods on the path that they are planning to take it out. And so I know that the applicant is going to create a sidewalk through a partial sidewalk down through the up to the Saddleback, the Falcon Heights neighborhood, excuse me. And so I know that that is supposed, but that is not supposed to be until afterwards. I think, you know, the 2,000 foot, I know the applicant has said that, you know, there was not a lot of people that applied back to their questionnaires and things from inside the 2,000 feet. But I think, like a lot of us, I live, excuse me, I live just under a half a mile away, or about 2,500 feet. There's a lot of us that live in that next 1,000 feet area that are going to be absolutely affected by this, just like the ones that are going to be in the closer area. So thank you.
Mr. Sutton, thank you for being with us. Quick question for you. Are you 2,500 feet away from both McGavin and Columbine, or just one?
So I'm about 2,500 feet away from McGavin and about probably, what is it, about 4,000 feet away from McGavin. The traffic is scheduled to go east away from our division, and it's away from most of the housing that's currently there. So that's why I don't have near the issue with the Columbine, is everything is scheduled to go. It's built outside of where there are current housing, and it's all scheduled to go away from the housing, where this is going to actually be going right from McGavin, will be going right through 4 subdivisions.
Okay, and just to correct your testimony, I think you said you're 2,500 from McGavin and 4,000 from Columbine. You said 4,000 from McGavin.
I'm sorry, yes, it's 4,000 from Columbine and 2,500 from McGavin, yes.
Okay. Okay, and just to finalize, and that the truck traffic from Columbine is not as problematic from your perspective in your testimony this morning.
That's correct.
Okay. Looking around, I don't think I see further questions. We do appreciate your being with us this morning and taking time out of your day to testify.
Thank you very much. I appreciate the time.
We now will call upon Steve Colvin.
And Mr. Chair, actually, Mr. Colvin's no longer available to speak this morning, so we can turn to Mr. Bill Coffey.
Okay, that sounds great. Thanks for keeping track of the chat. Good morning, Mr. Coffey.
Good morning. Commissioners, thank you for this opportunity to voice my opposition to Mcgee's application from the McGavin pad site and to ask you to deny this application. My wife and I moved from Louisville, Colorado to the Falcon Point at Saddleback subdivision of Firestone, primarily due to my wife's health challenges, which require a home with main floor living. My wife is also immunocompromised, and while we knew Weld County was pro-oil and gas, we were never told nor ever imagined an oil and fracking industrial site right in the middle of a residential and recreational area. I'd like to highlight why I'm asking you to deny this application. As I stated moments ago, my wife is immunocompromised. Multiple studies have shown that air pollutant concentrations increase with proximity to an oil and gas facility, as does health risks such as cancer. My wife has had to go through several intense detox procedures due to her exposure to previous poor water and air environments. It was rough, I'm not going to kid you, and I don't want to have her potentially go through a similar process if this application is approved. In fact, 2 of my wife's doctors recommended we move immediately if this application is approved. I also want to talk about the anecdotal evidence of the negative impacts of oil and fracking at other large pads, such as Collier's Hill and Erie, including diesel truck noise like engine brakes and backup warnings at all hours, and air quality, which is already poor many days on the Front Range. Residents at Collier's Hill are staying inside due to risks from poor air quality. You will hear from Mcgee representatives their plans for monitoring odor in air and their traffic plans. What you won't hear are their plans for mitigation. What will they do when particulate matter spikes, or if there's an oil spill, or if there's a severed flow line? You will hear Mcgee's plans for truck traffic leaving the pad site, but you won't hear about their plans for trucks coming to the pad site and needing to make a left-hand turn across oncoming traffic. You will also hear about Mcgee's commitments to public health, safety, welfare, and the environment. But what you won't hear is that similar pads in operation in Northeast Broomfield implemented best management practices Mcgee has refused to implement for the McGavin site. And even with those best practices, the Broomfield sites have resulted in a large number of complaints from people living nearby. Oil and drilling does have a place in Colorado, but an oil and fracking pad at this location is just not consistent nor complementary with the surroundings. It is too big, too close to a densely populated area, and degrades the quality of life of the citizens of Firestone, especially for the surrounding homes in Saddleback. Senate Bill 181 included a 2,000-foot setback rule and was designed to prevent this kind of neighborhood drilling. If this application is approved, then anything can be approved, rendering Bill 181 useless. Please do not approve this application, please. Thank you.
Well, thank you, Mr. Coffey. Appreciate you being with us this morning, and appreciate your testimony. Seeing no questions, we will continue down the list. We now have Kelsey Barnholt.
Hi there. Can you hear me?
We can hear you and we can see you. Good morning.
Okay, perfect. Thank you for the opportunity to give comment today about Mcgee's proposed Longs Peak site. Less than 12 months ago, I endured the hell that residents living anywhere near these proposed sites will experience. I live in Collier's Hill on the Weld County side of Erie and have 3 freshly fracked mega pads just 2,500 feet from my home, totaling 28 wells. Once the sound walls went up last February, around Mcgee, a pad of 12 wells, just 2,500 feet north, everything changed. There was a constant barrage of trucks in and out of the site, which meant loud jake braking during all hours of the night, exhaust fumes constantly hanging in the air, light disturbances for the people across the street, and more. Then the shaking and constant humming noise that sounds like it's coming from outer space started. I would spend my days filing complaints with CDPHE, Erie Police Department, the COGCC, and even speaking directly with the operator. None of it mattered. Neighbors and myself were experiencing asthma attacks, migraines, coughing fits, and sleepless nights from the incessant sound. When the sound walls came down, we have been left with rows of BTEX burners spewing toxic VOCs around the clock. It is jarring. Firestone's board states they are in favor of this agreement, but that's only because of a land swap deal with the operator. Erie did a similar dance with the devil in August of 2019, and now here we are enduring the impacts of 28 producing wells. I can assure you this is not in your residents' best interest, and this is much more than an aesthetic issue or a traffic issue. Even the planning committee recommended against this. Operators do not care about you or the well-being of your town and will greenwash however they need to drill. My family has spent $1,500 on air purifiers for our home and couldn't enjoy time outdoors for many months while the fracking and flowback was happening. I've spent countless hours advocating for air quality monitoring, which our town eventually got at a hefty price. And now I'm able to see the crazy spikes in VOC chemicals that we all knew were there. And the sad reality is that we're stuck with this for the next 20 years. I also want to point out that Mcgee has a long history of lawsuits due to their shoddy practices. The EPA sued Mcgee in 2020 for their failure to detect and repair leaks all over Weld County. And there's countless times that we see notifications in the Greeley Tribune of Mcgee legacy spills from battery tanks. These proposed sites are supposed to have 55 total 21,000 gallon tanks. I can assure you that these tanks will spill. There have been multiple leaks within a 1 mile radius of my home and even our elementary school. Additionally, lawsuits have been filed in 3 states about the environmental contamination from Mcgee facilities, causing cancer, childhood cancer, birth defects, respiratory illnesses, and more. And I just hope the COGCC will hold true to their promises made in SB 181. Thank you.
Thank you, Ms. Barnholt. You speak relevant to your experience with the operator of the Mcgee site, I think you just said?
Yeah, right? And that was Mcgee. That was accidental. Mcgee, Anadarko, all the same, I guess.
Okay, that's what I wanted clarification of, is who the operator was. Appreciate it.
Yeah, thank you.
All right, keeping on, let's do 1 or 2 more before we take a morning break. Emily Bear and then Jan Rose.
Good morning. Good morning. Thank you for this opportunity to speak with you. And thank you for engaging with Firestone residents and being curious with them. My name is Emily Bear. I'm an impacted resident in Erie. I've testified before this commission a dozen times at this point. I recognize the importance of sharing our experience with you of living near oil and gas development, of telling you the truth, and of bringing you back to your mandate, which is to protect public health, safety, and the environment. The truth is that fracking is dangerous. It's an industrial activity that cannot be conducted safely near people, homes, schools, parks, neighborhoods. Our experiences in places like Erie and Broomfield demonstrate that even with best management practices, we suffer health impacts, some severe. We, the impacted public, have told you the truth about these impacts for years. Cyclical vomiting, constant nausea, nosebleeds, headaches, migraines, throat irritation, eye irritation, asthma, and breathing issues. The CDPHE recognizes the hazardous threat of the Longs Peak OGDP and has recommended that this site be denied unless certain conditions are imposed. But Mcgee has refused CDPHE's conditions, demonstrating their disregard for the people living near these proposed pads. These conditions would only bring this operation up to the standards of current operations in Broomfield that continue to cause suffering for the people who live nearby. So even with these BMPs or substantially equivalent measures, we know the truth. The truth is that this site will cause negative health impacts. The truth is that this commission is mandated to protect public health and safety. We have to stop volunteering populations to suffer. Commissioners, you in your positions of power have the responsibility to protect the people of Firestone and deny the Longs Peak OGDP. Thank you.
Thank you, Ms. Baer. I appreciate you being with us this morning and for continued testimony with us. We're about halfway through the public comment for the morning, and we've been going at it for about an hour and 41 minutes. I suggest we perhaps take a 10-minute break, refill coffee cups, etc., and return back at 10:52. Continue down our list of public comment. Next up, we have Ms. Kate Merlin.
Thank you. Thank you, commissioners. First, I just wanted to take a brief issue with something you said to Mike Freeman earlier. The 2,000-foot setback is a setback. I was part of the mission change rulemaking. We always called it a setback. I have numerous news articles where Commissioner Robbins, you're quoted calling it a setback. After the setback was adopted, you called it a paradigm shift. And I can refer you back to those articles if you like. So far, the only OGDPs that have been approved with houses inside the setback have not had objection from those local residents. However, this OGDP does have a significant amount of community opposition from the local residents. And I think that if this OGDP is approved over the objection of these residents, that we really won't have moved from the pre-mission change rules. And I will say that the reason that 2,000-foot setback was adopted was largely due to a health study that was conducted by CDPHE, which showed health impacts extending at least up to 2,000 feet. And in fact, 2,000 feet was the cutoff for their study. I would also like to discuss briefly that I've had clients who lived 1,000 feet, almost exactly 1,000 feet from a 17 well megapad in Weld County. They had a second megapad that was almost exactly 2,000 feet from their home, which had been drilled first. These clients experienced all of the health impacts that we've been hearing so much about: the headaches, the nosebleeds, the dizziness. In fact, during mission change, you saw a video from their home of the heavy equipment which was run at their fence line, and you heard how noisy that was. It was just torturous for them to live through this process so close to their home. They were unable to be outside for many months at a time. One of their horses died. Their other horses became severely ill. They had oily residues falling on their property. The foundation of their home was destroyed due to the vibrations. And in fact, we know that it was due to the vibrations and not any other reason, because they had a home appraisal that was done just months before these activities began. They had cracks running up the entire walls of their home to the ceiling. I just, I again want to reiterate, this setback was a paradigm shift. It's a crucial health protection. There is no substantially equivalent protection when you have this number of homes, this number of impacted residents who are coming and asking you, begging you for help to not approve this. Please listen to those residents. Please do not create this new normal where off-ramps can be used without any showing by the operator of the type of, I think, substantially equivalent protections were contemplated as being something above and beyond the rules which you already require. And we just don't see that in this case. So I see my time is coming to an end. Thank you so much for listening to me, and please, please, please listen to the residents. Thank you.
Thank you, Ms. Merlin, for participating with us this morning and for your commentary. We now will move to Lois Vandercool.
Hi, commissioners. Can you hear me?
We can.
Oh, let me get my video on. Okay, now you can see me. Good. I'm an educated citizen who served on Broomfield's Oil and Gas Committee in 2017, advocated for 181 and city charter changes, and helped update our local regs. I read the director recommendations and CDPHE conditions of approval. The latter were largely based on Broomfield's inadequate best management practices. Mcgee's are worse, and it looks like they'll be able to easily re-drill and refrac given the 5 formations listed. Approving this application will set a dangerous precedent and neglect real impacts. There's no meaningful balance so far that establishes reasonable and necessary rules to prioritize and protect the public. This reminds me of how prior staff and directors aligned with industry, and it really breaks my heart. What struck me in dealing with extraction was their greenwashing kind of deceit, underlain by threats to sue. In 2017, they had the power given state rules, and our staff persuaded and pled for better setbacks, tankless operations, etc. When the operator agreement was vague, extraction refused some remedies. They took us to court multiple times and now have added a claim of malicious prosecution. We are left with no ability to enforce against emission exceedances measured by our expensive air monitoring program, and with no ability to protect against noise. Residents have made countless health complaints, and we are helpless to prevent those as operations proceed. We are also polluted by emissions from Weld County. Unlike Broomfield in 2017, you have the power to set clear health protecting rules, the floor. But staff seems aligned with Weld County and Mcgee's interest, as are you with your off-ramps, complex, hard to administer rules, and lack of good floor and definitions. What proof do you have for substantially equivalent? Why do you trust operators? They leave you with orphaned wells. The 2020 state audit showed lies or negligence in their reporting. They've spent millions to distort findings of climate science, emissions, and health impacts for decades. You need to ensure honesty and transparency. Don't trust and then try to verify. Believe the facts. You're not obligated to make things work for them. Your duty is to protect the public. Councilmember Anderson and I did an extensive review of our best management practices and compared them with Mcgee's. And if you'd be interested in that document, I'd be glad to somehow forward it to you.
Thank you very much. And we would appreciate, we always appreciate written statements or studies, and all of our emails are online at the COGCC website. So feel free to forward to us.
Okay, thanks. Thanks for listening.
Yeah, thanks for being with us this morning and bringing your perspective, having served on the Broomfield Advisory Board. We appreciate it.
Yeah, thanks.
We now will hear from Mr. Andrew Forks Goodwinson.
Good morning. Can you hear and see me?
Yes, and yes.
Great, thank you. My name is Andrew Forks Goodwinson. I'm the Deputy Director of Logic, and I'll just start by reiterating my support for everything that Mr. Freeman said in his comments, and urge you to read the document that he submitted this morning. As you all know, Logic works closely with impacted communities across the state of Colorado, including many of those that you've heard from and will hear from after me. Logic's experience with these communities is important in this consideration. We've seen the harm that locations like this one can cause up close and personally. I've sat on couches and at dining tables with oil rigs clearly visible through windows as residents tell me of bloody noses, headaches, sleep deprivation, and terrible illness. I cannot urge you strongly enough to listen to these people as they ask you to deny this application. The applicant may come on and tell you that this is a state-of-the-art proposal with the strongest, most protective BMPs possible. The CDPHE's consultation letter should tell you all you need to know about that. This application is harmful on its face and must be denied. Frankly, it's deeply frustrating that this application ever made it past any initial review. In their consultation letter, the CDPHE directly referenced extractions operational standards put in place prior to the passage of SB 181 on well pads in Broomfield. Those well pads which right now are causing harm to nearby residents. The applicant here, unfortunately, cannot even commit to bringing this application up to that pre-181 standard. CDPHE made a set of extremely reasonable requests and the applicant refused without providing any meaningful evidence and support to consent. Rather than interrogating the applicant's refusal, the staff seemingly has just agreed. You're here today, essentially, to decide what substantially equivalent as written into your 2,000-foot exception or 2,000-foot setback exception means to you. It cannot mean a polite request to the applicant to please bring their proposal up to a 4-year-old standard with whatever additional BMPs they consent to. The mayor of Firestone called this development beneficial consolidation. What it really is the creation of a sacrifice zone. SB 181 was passed to put an end to neighborhood drilling. The mission change rules were adopted to implement that end. You as a commission heard evidence during that rulemaking from impacted people, including some impacted people who have already spoken or will speak later today. And you adopted setbacks to make sure that no one else would be subject to those impacts without their direct, informed consent. That consent has not been given. I walked door to door in these neighborhoods and what I heard was troubling. Some within 2,000 feet of this application had never heard of it. Some thought it was already approved, and almost no one knew that they had any right to protest this application at all. Despite that lack of knowledge and lack of information, this application will undoubtedly cause harm to people who live and recreate near it. Therefore, I ask that you please protect their health, safety, and welfare and deny this application. And that includes both McGavin and Columbine, both of which have homes within 2,000 feet. Thank you so much for your consideration and best of luck.
Thank you, Mr. Goodwinson. Appreciate you being with us. I just want to clarify one thing you said that that Mr. Freeman, that Mr. Freeman had provided something in writing to us this morning. We do have a February 11th written document from Mr. Freeman. I just want to clarify that's what you were referring to.
That's what I meant. Sorry, Mr. Freeman speaking this morning and document from last week, I think.
Very good. And we appreciate Mr. Freeman speaking this morning, and we have in the record the written filing on behalf of Logic and Earth Justice on behalf of Mr. Freeman. So just want to clarify so that we're all looking at apples to apples.
Thank you very much.
Okay, I believe we now have Chris Escalante.
Hi, yes. Thank you for having me here today. I'm trying to get to my right up here. I'm having trouble getting my screen down here.
How about take your time?
Okay.
Tell
Thank
me
you
when
so
you're ready
much.
to go, and then we'll start the timer.
Great. My name is Chris Escalante, and I am within 2,000 feet of the proposed McGavin site. I'm in Saddleback Heights. And I want to thank you, commissioners, for asking some tough questions of the Firestone personnel in the meeting at the very beginning. There are numerous studies showing impacts on people's health if they live near an oil site, as you know, and I'm asking you to please follow Senate Bill 181 and prioritize public health and safety, and please reject this drilling application. I don't agree with the town members that spoke in this call regarding that residents are only caring about aesthetic issues. I believe that any knowledgeable person must have reasonable doubt that there is at least a potential for health impacts for the many nearby residents, as well the tens of thousands of people that drive by that location every day, golf on the 2 courses, or walk the trails within feet of the site. This proposed site is virtually in the middle of the towns of Firestone and Frederick. I'm angered that I will have my family's way of life ruined because of the health impacts, noise, vibration, smells, dust, and traffic. We are a multi-generational home, and we chose this home for the peaceful surroundings where my grandkids can play outside. We can walk that trail. We can open our windows and smell the fresh air. Literally, we planned that and hear nothing more than the occasional dog barking today. Now I'm faced with knowing that my family and I can't enjoy our yard nor open our windows without dangerous emissions, dust, noise, smells. And if this oil field gets approved, I feel that this commission will let me and my family down and left us unprotected for our health and unprotected for a peaceful life in the home that we've invested in, and we will have to move. As noted, the City of Firestone's own Planning and Zoning Commission recommended against approving the permit for this oil field, but the Firestone Town Council approved anyway. I implore you to please do even a few minutes of research and look at the political situation in Firestone. There are news stories on the internet where the 3 town officials that spoke are mentioned. There was an attempted recall of the mayor and trustees due to ethical concerns. Again, the speaking at the beginning of the call were involved. There's a lawsuit filed in the district court because the town clerk disallowed the recall due to a paperclip. Crazy things. Regarding that gifted piece of land from the oil company, I feel that even if there was no documented quid pro quo in that cooperative agreement, in my professional career at IBM, we were never allowed to accept gifts for ethical reasons. And I personally consider Firestone accepting that land, me personally, as nothing more than a bribe. Firestone is not protecting my family, so my hope is that this commission will please protect the health of my family for me. I want to say something about extreme flooding in Firestone that happened in 2013. That northwest location of McGavin is very near, if not exactly, in the spot where there was flooding. The land was underwater for months. If it floods again, the runoff will be even worse due to the additional homes that have been built since that flood and were built uphill and to the east of the area, because there will be nowhere for the water to go, nowhere to be absorbed, but down to that proposed site. There's even like a wildlife strip along the west side of that proposed site. So I beg you, please, please protect us.
Thank you, Ms. Escalante, for being with us this morning. Couple of follow-up questions. With regard to the flooding, can you provide us some more perspective about that, since you live near there and were aware of?
Yes, on Firestone Boulevard and Pinecone, that intersection was all underwater, and including a little bit further, even west of that. But that whole parcel of land was wet for months. People couldn't go through it, had to go around it. And then after even the road cleared of the water, there was still water sitting in that whole corner. I wondered if it would ever absorb. It finally looks like it's drier, but sure enough, you can see a lot of fog in that area, telling me, I'm not experienced, but it looks like there's a lot of underground water there. And if you want to see, there's a news report from Channel 7 that goes back to that September of 2013, where you can see they're standing in the road of Firestone Boulevard, right in front of the west side of the site, and you could see the flooding. So I'm not like making it up. It's out there. It's not just in my head. It's also kind of a little wetland area. There's a creek and such. And a lot of the flooding that happened in our town of Firestone and even Frederick came from like the silliest little slopes. That would be, a house would be just on a slope, or there'd be a farmer's land that would be right in front of a bunch of homes, and the water would just come down and just kind of slide down and hit the backs of homes, just like it would, I would think, slide right down this field, right into that site, if it were to rain like it did in 2013.
Okay, thank you. And then I think you mentioned in your testimony that your home is within 2,000 feet of the McGavin proposed location. Is
Correct.
that right? Is your opposition in opposition to both McGavin and the other location, the Columbine, or just McGavin?
Right now, I'm fearing the McGavin one because it's right out my back door. I could, if I'm sitting in my office right here, I could see it when it goes up.
Okay, thank you for allowing me to ask a clarifying question.
Thank you.
And thank you for being with us this morning. Okay, we'll go back one public commenter to Brent Goodlett. We determined that Mr. Goodlett was in our meeting under a pseudonym, and now we have him as himself, and so we look forward to hearing from him.
Hi there, can you hear me?
We can hear you and we can see you.
Yeah, great, thank you, and apologies for the little snafu there. Dear Commissioners, my name is Brent Goodlett. I'm a climate and environmental justice advocate for Colorado living in Denver. My comments today are on the Mcgee Longs Peak OGDP, specifically for the McGavin site in Firestone. Now, I know that others know and have probably thoroughly discussed the potential impact and the deadly impact of oil and gas development, knowing the history of this operator in Firestone and the incident that occurred in 2017. My focus for the time I have, though, pertains to another potential impact of allowing Mcgee to proceed with drilling some 26 wells within 2,000 feet of 87 homes in the Firestone area. This McGavin site is also destined for land whose current and final use is denoted as irrigated cropland, according to documents filed with the commission. So please excuse me if I'm concerned about the potential impact of groundwater contamination by benzene and other toxic hydrocarbons, as well as contamination from drilling and fracking chemicals that Mcgee and other operators keep hidden from the state and regulators under the guise of trade secrets. Specifically, this site is proposed within 584 feet of the nearest water well, within 157 feet of the nearest down gradient surface waters of the state, and upon soils described as fine sandy loam and loamy sand soils. All of these factors increase the risk of water contamination by secret drilling and fracking chemicals. But don't take my word for it. The draft financial rules of this commission doubled the estimated costs of reclamation required from not $25,000, but $50,000 of financial assurance per well for drilling on sandy soils. And that's without any consideration of the proximity of these wells to neighboring water wells, surface waters of the state, protected wildlife habitat, or residences. Dear commissioners, the risk of contamination from spills, from wellbore integrity failures, from migration of chemicals through sandy soils into the groundwater, into surface waters, is just too great. Of all the permit requests since SB 181 passed, if you can't find justification to deny this egregiously risky permit, then SB 181 might as well not exist, because this commission is not upholding the intent of that law. I urge the commission today to deny the McGavin site.
Thank you, Mr. Goodlett. Appreciate you being with us today and for providing your perspective. I believe we now have Rebecca Eastland.
Sorry, that's quite a system change. Hi, my name is Rebecca Eastland. I live at 1426 Whitehall Drive in Longmont. That's an 80504, and it's about a block into Boulder County on the west side of Firestone. I speak as someone concerned about the overall density of oil and gas drilling in Weld County, which is essentially a block away from me. And I'm also concerned for a host of friends who live in the neighborhoods close to the McGavin location. I come before you today to ask you as commissioners to uphold SB 181 to protect public health, safety, welfare, and the environment. In setting new priorities for the commission, that law tacitly acknowledges that oil and gas drilling harms people's health and wellness and the fragile ecosystems of our state. If the negative impact was not abundantly clear, the law would never have been passed. According to news reporting, Mcgee has already rejected half of the 13 safety and harms reduction measures that were recommended by the CDPHE. This isn't a scenario like the others where you have granted waivers. We're talking about many homes. I know there's only 87 within 2,000 feet, but there's recreational areas, many neighborhoods in that area, and fragile ecosystems. There's really no justification other than more profit for Mcgee, and it sounds like an unrelated real estate swap for the city that could ever justify drilling within 2,000 feet of homes, let alone the 763 feet of the closest one in this situation. Our state has already taken a stand. The McGavin location is the poster child for SB 181. It sits right at the center of all the things the law was intended to prevent. Drilling near wildlife areas and sensitive water resource areas, human recreation areas, residential areas, schools, etc. There is nothing about this location that should make it worthy of a waiver to Senate Bill 181. Absolutely nothing. This drilling plan and this location are what 181 was intended to avoid. This is not a special snowflake, to use your words, Commissioner McGowan. It is not unique and it does not deserve a waiver. I ask you to deny this application, and thank you to the commissioners for your time and your thoughtful consideration.
Thank you, Ms. Eastland, for taking time out of your day to present to us today. We do appreciate it. We now will turn to Alexis Schwartz.
Good morning, Commissioners. Thank you for the opportunity to speak today. My name is Alexis Schwartz. I'm a Coloradan speaking on my own behalf. I speak today too because a handful of people I spoke with who reside in the neighborhood of this drilling plan couldn't step away from work meetings or their responsibilities to their families or young children. They couldn't be here this morning to object to this commonplace spectacle wherein the oil and gas industry maintains that it's absolutely necessary for operators to turn every pocket of land inside out, to turn residential communities upside down, to shake loose ever more profit at the expense of the health and wellness of those residing there. It's worth mentioning that per Senate Bill 181, the COGCC's new mission is to protect public health, safety, welfare, the environment, and wildlife resources. The commission must deny this drilling plan because neither of the two well pads proposed in the Longs Peak plan comply with the requirement that pads must be at least 2,000 feet from residences and public institutions. These pads lie within 2,000 feet of nearly 90 homes. Residential setbacks were adopted because distance is the best, most effective way to reduce the health and environmental impacts of drilling. Operator Karen Mcgee is dismissively saying, "We'll counteract the odors with essential oils. We'll erect 32-foot walls to dampen the noise and block the light. We'll keep an eye on the air pollution and we'll take care of that added traffic." All this goes to say that oil and gas drilling simply doesn't belong in such a residential area. Furthermore, this pad's intended location is listed as a sensitive area for water resources. It is a mere 157 feet from a wetland. In recent years, our state has been suffering more intense, more frequent drought conditions. Is this how we want to allocate and impact our precious water resources? There is a real opportunity and a great need for changing these permitting activities to meet legal mandates. Thank you for hearing from me.
Thank you, Ms. Schwartz. I appreciate you being with us this morning and providing your perspective. Continuing down the list, flip the page, move to Kathleen Scott. Good morning, Ms. Scott. We see that you're with us. Can you unmute?
Yes, thank you. Okay, great, thank you. My name is Kathleen Scott. I live at 8865 Falcon Street, Firestone, Colorado. I'm here to comment about Karen Mcgee Longs Peak Development Plan. My house backs directly to the proposed McGavin pad. My husband and I purchased our home and moved here in December. We are extremely concerned with all the negative impacts it will have to us and the community. I don't think anyone would want this in their backyard. Please deny this application because there is a strong potential for adverse impacts to public health and the environment of the people who live near it. It is way too close to too many homes. There are nearly 100 homes within 2,000 feet of the proposed location, the closest being only 763 feet away. It is also within 2,000 feet of several outdoor recreation areas, including Firestone Trail and the Saddleback Golf Course. It is my understanding that the COGCC's regulation prohibit oil and gas development from being located within 2,000 feet of homes and schools. Distance is the best, most effective way to reduce health impacts of oil and gas drilling. Mcgee is trying to use an exception, claiming that their location has substantially equivalent protections to a location that is 2,000 feet away from homes. They have provided no evidence for that claim. It seems Mcgee has refused to accept the most protective of requirements the Department of Health requested as conditions of approval. Even with recommended protective measures, other developments with similar protective measures have caused severe impacts, including benzene emissions 20 times higher than health guidelines. It's just too dangerous to approve and a direct threat to everyone who lives near it. Even with harmful pollutants, even if harmful pollutants are monitored, monitoring does not prevent harm. Mcgee refused to commit to using zero VOC drilling mud. In other locations, drilling mud has been the source of serious odor complaints. Odor can be a sign of other harmful emissions, and odor masking agents cannot guarantee safety. I certainly don't want to breathe what is being emitted. Would you? Also, the oil and gas megapads are inconsistent with the town of Firestone's comprehensive plan. The increased truck traffic of nearly 50,000 truck trips through our quiet neighborhood is unacceptable risk to our safety. The noise impact from the trucks, the hydraulic fracturing, etc., will be very disturbing and stressful to all nearby residents. Again, I request that the development plan and application be denied. Please do not protect the industry's interest rather than fulfilling your mission under Senate Bill 181. Thank you for your time and opportunity and the opportunity for me to comment. Thank you.
Thank you, Ms. Scott. If I could, just a clarifying question. You mentioned that you live near the McGavin pad, I believe. Is that right?
Yes. Yes. My house backs to the McGavin pad.
Is your request that the commission deny both McGavin and the Columbine, which is the other pad that's associated with this OGDP, or just McGavin?
Primarily McGavin. The Columbine pad, I'm not, I'm concerned of that one as well because it is in our community, but I don't know as far as the how close it is to residential areas exactly. I haven't studied up on that, but primarily the McGavin.
Thank you very much.
That's more directly affects my community, my neighborhood.
Thank you very much. Appreciate your being with us and taking time out of your day to present. We now will hear from Deb Bjork.
Thank you.
Thank you. Thank you for taking testimony. I'm Deb Bjork. I'm asking you to deny both sites in the Longs Peak application. Your decision on this drilling application, which seeks to drill 26 wells within 2,000 feet of 87 homes, with the closest residents less than 800 feet, with well pads adjacent to wetlands, golf courses, and the Firestone Trail, should be denial. Winston Churchill said, "One ought to be just before one is generous." Just is following the intent of SB 19-181, protection of public health, safety, welfare of the environment and wildlife, and following your own setback and other regulations before you start being generous with the industry. The 2,000-foot setback is your regulation based on the CDPHE study and intending to meet the mandate to prioritize protection over promotion of oil and gas development. We cannot let the exception swallow the rule. Longs Peak is exactly the type of applications that should be denied. Not just check boxes here, bend the rules and intent there, disregard the rules criteria because an operator works with town leaders, nor allow an operator to decide what is equivalent protection. Winston Churchill also said, every man should ask himself each day whether he is not too readily accepting negative solutions. From an observer's perspective, the COGCC is sliding into this territory, accepting negative solutions in effort to be fair, But fair is not what mission change rulemaking was about. You must be just first. You must protect. This application cannot be patched here and there with false solutions under the rubric of substantially equivalent protections. High walls do not protect from the noise of 150 vehicle trips and 24/7 noise during fracturing, coiling, and tubing. Essential oils to cover smells do not protect from dangerous emissions like benzene, which can cause nosebleeds, headaches, breathing issues. In fact, essential oils could aggravate asthma attacks. I have asthma, I know. This application can't be patched, even if Mcgee decides to comply with the 7+ CDPHE recommendations that they have thus far refused. Winston Churchill also said, sometimes doing your best is not good enough. Sometimes you must do what is required. You may each consider your best to balance the industry's effort with the public's concerns, but it's not good enough. You must do what is required to live up to the protection intended by SB 19-181 and Mission Chain's 2,000-foot setback. Long's Peak is the poster child for neighborhood drilling and why the law was written. In my opinion, it's not hyperbole to draw upon World War II leaders for courage. This application, if allowed, could lead to thousands more applications within 2,000 feet of homes. You, the commissioners, need to stand for protection, given your mandate. I think it's also your moral duty. Thank you.
Thank you, Ms. Bjork, for presenting to us this morning. We do appreciate your being here. Moving down the list, we now have Kate Christensen.
Hello.
Hello.
My name is Kate Christensen. Thanks for taking the time to hear my comments today. Nowadays, I'm the oil and gas campaign director for 350 Colorado, but three years ago, I wasn't. This time, 3 years ago, I was volunteering for a lot of different groups and trying to support the passage of SB 19-181. My kids were 4 and 6 years old then. They're 7 and 9 now. I went down to the Capitol several times while that bill was moving through committees. I remember one time just being in tears on 36, driving down there because both my kids had fevers and I had to leave them with my mom to come down. It's hard to leave sick kids. And I was exhausted. And there were hundreds of people working on that bill and we were all exhausted. We were often at the Capitol from midday to midnight waiting for our turn to speak, but we thought we were doing something that would make a difference. We thought if we changed the mission of the COGCC from fostering oil and gas development to regulating, that if protecting public health, safety, welfare, and the environment was part of the law, that things might get better, that people might get safer. They might be able to say no to giant, dangerous industrial facilities in their neighborhoods. Now with the Longs Peak OGDP, we're going to find out if we made a difference at all. Did the work of so many people, so many volunteers over the past few years, getting the law passed and all the thousands of hours of rulemakings, mission change, financial assurances, did any of it matter? The CDPHE recommended denying the permit if Mcgee didn't meet the protective standards that Extraction Civitas is using in Broomfield. And we know from the experience of Broomfield residents, those standards are questionable at best. But regardless, the oil and gas company said no to the majority of the public health recommendations that the Colorado Department of Public Health put forth. So follow the recommendation of the CDPHE and deny the permit. Denying this permit would signal that the culture of the COGCC has shifted, even a little. It would show that the law is starting to be respected, that the legislators and people of Colorado are respected. If this permit were denied, we would know that the residents of Firestone, where we saw one of the worst oil and gas tragedies in Colorado, are finally being protected. And please listen to all the impacted residents. You're hearing mostly about the McGavin pad today because you have residents who live nearby. You're not hearing about people near the Columbine pad because many of those 40 homes that are planned within 2,000 feet of that proposed pad haven't been built yet. I'm hoping both pads will be denied. If they're approved, as soon as there are more impacted residents near Columbine, then you'll be hearing the same stories from them that you heard today, from Erie, from Broomfield, stories about health impact that you've been hearing for years. You can make a move today to stop a cycle of harm. Many people worked really hard to give you that tool in the form of SB 981 to do so. Thanks for your time.
Thank you, Ms. Christensen, for taking time out of your day and being with us today and for the testimony. We do appreciate it. We now will have Mr. Dana Bovey.
Okay, I'm here and I'm almost set up. Thank you for taking my comments today. Sorry it took a little bit. I can't find the video switch, so you're just going to hear me by audio. Mcgee has asked the commission to excuse it from complying with the 2,000 foot, and I will put the emphasis on setback by relying on a variety of BMPs and other mitigation measures addressing air pollution, odors, noise, and other impacts. Apologies for being repetitive. Great speakers before me. I'm glad to follow Kate. But notably absent from Mcgee's request is any discussion of how these proposed measures compare with locating the well pads more than 2,000 feet from homes. Mcgee submitted a 4-page document listing various measures, but did not actually assess the effectiveness. COGCC staff, without any supportive reasoning, has gone along with Mcgee's absent response. Mcgee's statements that it plans to monitor air pollution is irrelevant and meaningless. Rule 604B requires the commission to use the benefit of distance or avoid or minimize impacts to citizens of Colorado. In no way can that be achieved without evaluating whether measures proposed by Mcgee are equally or more effective than distance in avoiding or minimizing impacts. As Earth Justice and others have rightfully argued, Mcgee in examples at other locations has fallen well short of what mitigation measures the CDPHE believes are necessary for this location. On January 7, 2022, the CDPHE submitted comments that made it clear that Mcgee has not satisfied the substantially equivalent exception or the requirement to use necessary and reasonable protections to minimize impacts of public health, safety, welfare, and the environment. There was an addressing on alternative sites. I think that's well addressed in Earth Justice and Logic's written response. I plead with the commissioners to stop ignoring the will of Colorado residents as expressed in the vote for SB 181. The commission must deny Mcgee's application as it doesn't satisfy COGCC regulations and protect and minimize adverse impacts to public health, safety, welfare, and the environment. And last, speaking from our research group and advocacy group 513C, Front Range Nesting Bald Eagle Studies, we study the nesting eagles that have been mentioned to utilize habitat near the proposed site. Their habitat is dwindling. While the territorial pairs we study average about 60% of their daily time within 2 to 3 square kilometers of their territories. I just got 30 seconds left. They depend on other hunting and foraging sites like the one the commenter described near the proposed development sites. These same eagles no longer utilize a similar hunting site that's just 2 miles to the south in Dacono. The reason? Multi-well paths that were developed there in the last couple of years. And who owns the 2 square mile property directly underneath the Erie pair's nest? Occidental. And we know a multiple well pad plan on that property is currently on hold. And no doubt that will resurface again. Thank you for listening to my comments.
Thank you for being with us and presenting this morning. We will now turn to Joanne Hackus. You need to unmute.
Yes, just trying to do that. Thank you very much for letting me participate in today's meeting and to stand with the residents who are have expressed today their dismay over the impact of the decisions made by their city council and potentially by this organization. I urge you, first of all, to not to permit the Mcgee to go ahead with either the McGavin or the Columbine pad. As Kate Christensen noted, the reason we don't have people from the Columbine pad here today is because they haven't moved in yet. And they're within the 2,000-foot distance from this proposed well. It should be clear, I think, from a number of people who've testified that there are plenty of options for Mcgee to extract the oil and gas from areas beneath these locations. They have the possibility of existing sites that would allow them to drill horizontally into the location. So they have opportunities to extract the oil and gas without impacting the communities. But this is a situation in which the communities, the people living there, the people who will have these wells in their backyards are just going to be impossibly impacted. As everyone has said, that was the purpose of State Bill 181, was to protect people. And we really ask that you take that seriously and do that in every case and not surprise the people who are having their homes built in the Columbine area to find that as soon as they move in, there will be giant oil fracking operations going on right in their backyards. I think it's unacceptable that we continue in this state to drill oil wells in communities. I wonder, in fact, after the commission, the city council in Firestone approved this, if any of them have purchased homes in these areas, if any of them would be willing to live next to this industrial operation, if any of them care about the citizens whose lives they are impacting. So I urge you very much to refuse both of these applications and tell the oil company to find other ways to get at the resources that they think they need to produce. Thank you very much.
Thank you for the public comment. We appreciate you being with us. I note for the record that when you signed up, you were in Evergreen, is that right?
Yes, but I'm representing the Audubon, Colorado Council.
Thank you very much. I'd like to get those clarifying points on the record.
Okay.
Okay, we now have Ramesh Bhatt.
Thank you. My name is Ramesh Bhatt. I am the chair of the Conservation Committee of the Colorado Sierra Club, which has over 100,000 members and supporters in the state. I am here to urge you to deny the Long Peak OGDP, both locations. There's been a lot of eloquent testimony today, and I don't want to repeat all of that, but I just want to emphasize a couple of points. As you know, Senate Bill 181 was passed to prevent exactly this kind of highly polluting and dangerous activity in neighborhoods. You, the commissioners, COGCC staff, the industry, a number of lawyers, and a bunch of concerned citizens put in a great deal of effort to craft a 2,000-foot buffer rule. Yet, Mcgee is asking you to ignore this rule. It's relying on a concept of substantially equivalent to press its case. Actually, Mcgee is asking for an exemption without even making a serious attempt to show you that its activities will be as protective as the 2,000-foot buffer. As you've heard, they have rejected many of CDPH's recommendations. The rules that you passed last year built in consultation with CDPHE. CDPHE recommends rejection of this permit if their proposals are not adopted. I hope that you follow this recommendation seriously. Otherwise, I don't see what the point of consulting with CDPHE is. However, the Sierra Club believes that the proposal should be rejected even if the industry agrees to comply with the recommendations, the CDPHE recommendations. This is because the concept of substantially equivalent is nebulous to begin with. Substantially equivalent to what? The standards are not clear or well articulated. Moreover, practices such as those recommended by CDPHE have not protected people in other locations, as you've already heard, places like in Broomfield. Overall, your action today will set the stage for future oil and gas production activities in the state. Will it be protective of people's health and well-being as required by Senate Bill 181, or will it continue the practice of indiscriminate permitting of oil and gas productions in neighborhoods at all costs? The choice is clear here. Please deny the permit. Thank you.
Thank you for being with us and for testifying this morning. We do appreciate your taking time out of your day to testify. We now will hear from Bo Kickless.
Sorry about that, Chair. I was just trying to get my window set up there.
No problem.
All right. Good afternoon. My name is Bill Kickless. I'm the public lands advocate with Conservation Colorado. We're the state's largest conservation advocacy organization, and we're and have been heavily involved in the implementation of Senate Bill 181 and the legislation that was passed in 2019. And our involvement stems from our belief in the 181 process, to be able to deliver results that are going to be protective of public health and safety, welfare of the environment, and wildlife resources. And that's also what brings us here today. So plain and simple, I mean, we have major concerns with this proposal or urging a denial today. Our perspective is that this proposal would subvert the mission you've been charged with. And there's a multitude of reasons that this commission adopted a 2,000-foot setback standard in 2020. And mostly that's because it's the best defense against the negative impacts of drilling on public health and safety. And I want to go back and read a statement from Chair Robbins during the deliberation phase of the mission change rulemaking when the 2,000-foot setback standard was being deliberated and adopted. And to read that, quote, "If we look at our complaint logs at CDPHE and COGCC, there's evidence in the record." Continued, what really drives it home for me is the testimony from people that have presented to us. The Dr. Speeces of the world, the Butterfields of the world, the neighbors at the Anthem Ranch, these folks that have complained about the same things the CDPHE said those complaints would be. And I wanted to bring that up and share it because it was a powerful statement then. It is still a powerful statement today. And I think especially so after hearing from all the impacted residents this morning. I strongly urge you to consider this in your vote this afternoon, whether to allow development to occur within 2,000 feet of nearly 100 homes in the Firestone area. Because if it's approved, you're going to continue to see a lot of these same complaints come through. You also have additional considerations on the record for your consideration as well. Of course, the state's public health department provided substantial comment and review on this matter, particularly on the McGavin proposal, and is recommending denial if the operator is unable to implement their recommendation, stating the most protective conditions of approval are necessary and reasonable when proposing to drill within 2,000 feet. You have an operator that doesn't necessarily agree with implementing all of those conditions, however. You've heard from members of the public this morning and for years who have complained about neighborhood drilling, getting too close to homes, too close to schools, playgrounds, and floodplains. And you yourselves have also acknowledged their complaints line up with the health impact studies published by CDPHE. So you have the information you need to deny this proposal. And in closing, I'd like to say that this is the exact kind of development that 181 sought to end once and for all. We share that perspective with other concerned organizations and residents. If you approve this proposal, then you're essentially allowing most of anything to be approved hereafter. Your charge as a commission is to protect health and safety, first and foremost. And I urge you to do that today and uphold your mission. Thank you.
Thank you for being with us and for the presentation. We do appreciate it. We now will hear from Mike Foote.
All right, thank you very much, Mr. Chair, and good morning still, commissioners. My name is Mike Foote. I'm an environmental attorney, not representing anyone in this matter, but speaking to you as a member of the public, asking that you deny this OGDP. I'm sure that you'll hear many details from Mcgee about things like how many times they contacted residents and how many alternative location analyses they conducted and how opposed residents missed the protesting party deadline last November. Also about the informed consent given by just 3 of the 89 households within 2,000 feet of the McGavin pad, and supportive letters submitted from just 35 out of over 1,000 households within a mile radius. And all of that has happened, but I would respectfully submit to this commission that those details go to the form rather than the substance of the Longs Peak application. The main question here should be whether the Longs Peak OGDP is as protective of public health, safety, and welfare as the statute requires. And I would again respectfully submit to you that it clearly is not, for all the reasons stated in the Earth Justice letter submitted late last week, as well as the resident comments you have already heard today. From my perspective, it was most disappointing to hear the Firestone Board of Trustee comments at the beginning of all of this. No matter how much outreach the company has done or how many wells it says that it will plug that it's required to plug anyway, that information, frankly, is just like putting lipstick on the pig that the McGavin location is. This commission is in a good position to see that, since the state is thankfully not part of the land deal that influenced the Firestone position, to say the least. You also have the insight from your experience and collected data about how these operations truly affect those around them. You know it isn't just an aesthetic issue, as Firestone referenced, but about real and detrimental health and welfare impacts like noise and emissions. And you also have co-equal, not deferential, but co-equal authority to exercise your independent judgment about the true merits of this application. As you know, it's the applicant's burden to prove to you that its application complies with the statute. Mcgee cannot meet that burden with this OGDP. It cannot meet that burden because the McGavin location in particular is simply inconsistent with the protection of public health, safety, and welfare. Even if Mcgee were to accept all the CDPHE's recommended conditions, which so far it hasn't done, the experience of affected residents shows a neighborhood drilling operation like this will cause immense impacts and violate the statute. What it comes down to is some locations are just not conducive to oil and gas operations, and the non-production of minerals for public health, safety, and welfare reasons is explicitly allowed under the statute for that exact reason. Thank you very much for hearing my comments today, and please say no to this OGDP.
Thank you, Mr. Foote, for being with us. And I will reference your former life as Senator Foote and being a sponsor of SB 19181. And in that regard, I would like to ask a sort of clarifying question. I'm struggling with Firestone and sort of the local control and sort of their local approach versus our commission and our mandate to uphold the tenets of 181. Can you give me some perspective? I mean, we heard vigorously from the elected officials of the local government that has relevant jurisdiction here that this is a go, and it ought to be a go.
Yeah, thank you very much, Mr. Chair. I really appreciate that question. And I referenced that a little bit and when I talked about how under 181, as you know, you have co-equal authority to local governments. Co-equal authority does not mean deferential to local governments. It means you're, as I said, co-equal. You have independent judgment. Even if the local government says that it's a go, in their opinion, you have your statute, you have your standards, you have your independent judgment. And at the end of the day, you have to determine whether or not, regardless of what the local government says, if this is protective of public health, safety, welfare, the environment, and wildlife under the statute. And there were a number of factors, of course, that the sponsors and legislators were considering with local control. One possibility, I should say, is that a local government would say no, in which case the permit would not go forward. But it was acknowledged and thought about that a local government could say yes, but that local government may have much less restrictive measures or much less protective regulations in place than the state. If that's the case, then the state should use its judgment and protect the residents as the local government, in this case, in my opinion, has declined to do. So I would again urge that just because a local government says yes, that really is not something that you should defer to. That really is something that you can listen to and, of course, hear their opinion. But at the end of the day, it's about whether or not you're complying with your mission and Senate Bill 181 and the statute as a whole.
Okay, thank you very much. I wanted to hear around the corner on that question, given your involvement with 181. So I appreciate you being with us this morning and providing that clarification, as well as
thank you for the opportunity.
Okay, we've got a few more people that have signed up, but I don't believe we're finding them in the hearing. Perhaps we have Karen Speed next. Is that right, Ms. Larson?
That is correct.
A quick process question, if I could, Mr. Chair.
Go ahead, Commissioner Hackett.
Thank you, Chair Robbins. Just wanted to note that there's some questions in the chat about whether the commission intends to hold a vote on this today. And I think folks might be wanting to leave if they don't expect a vote to happen today. And is it safe to say that's the goal, is we do hope to, or the voting commissioners do hope to make a decision today, depending on how long it takes to get through the testimony, of course?
Yeah, I mean, I think that's, our normal course is we're holding a hearing on the OGDP and we go through the process. We hear from public. We're going to hear from the applicant. We're going to have staff available for questions and answers. And at the end of the day, under Rule 308, we can either approve, deny, or stay. And we don't know what's going to happen, but that is, we're going to proceed logically through that process under our rules. So thanks for recognizing that point, Commissioner Hackett. And that is our proposed approach. I see we have Karen Speed in the panel, but she's not unmuted. Hey there.
Can you hear me now?
And we can hear you and we can see you.
Excellent, excellent, excellent. Let me flip up here. Okay. All right. My name is Karen Speed, and I would like to review a well currently operated by Mcgee. This facility is the Miracle Pad and is located on Colorado Boulevard, Johnstown, and is in Larimer County. On October 6, 2021, a release of unknown volume of produced water was discovered during a routine inspection of the Miracle Production Facility / tank battery. On October 15, 2021, a hydro excavation and site assessment activities were initiated and 5 soil samples were collected. I hope you can see this, at depths of both 6 feet and 5 feet below ground surface. A long list of tests were performed on the samples with preliminary test results indicating that benzene, 1,3,5-trimethylbenzene, and naphthalene concentrations in all 5 soil samples tested well above the accepted values in the COGCC table 915-1 for protection of groundwater soil screening level concentration. Also, there was visible hydrocarbon staining of the soil and strong hydrocarbon odors as expected. I was unable to locate any final lab analysis test results in that file. Additional excavation and assessment activities were ongoing with a Form 19 supplemental report due in 90 days of the spill on October 6th. After reviewing the file, I did not locate any manifest sheets to reveal how much contaminated soil was removed, nor did I find any documentation addressing where the soil was disposed. The last report I could find was submitted for a November 30th, 2021 site inspection that stated the excavation at the separator was still open with exposed dump lines. I hope you can see that. The operator has submitted a work plan to remove an additional separator to facilitate remedial excavation and plan to remove the produced water vessel. It is my assumption that these tasks were completed, as I did not see any other documentation to confirm they were ever accomplished. The reason for this spill is equipment failure. That is a fact of this industry. No matter how much goes correctly, it only takes one incident of equipment failure to lead to a large swath of contamination or worse, as Firestone is fully aware. Current wells on that pad, 5 plugged and abandoned, 7 abandoned locations, 2 shut in, 2 temporarily abandoned, and only one producing well. And from what I can determine from the production sheets, the wells on this pad started to produce around the first part of 2011 with what looks like a collection of lower producing wells with some resembling stripper well status. So is it really worth it? The volume from this spill remains unknown. This is not compatible to be close to residential areas. The accountability for failures that impact the environment, the health of citizens, and the air we breathe is a responsibility of our state government. Please consider the possibilities of equipment failures with Mcgee, and I request that you deny both of these applications. Thank you. I'm open for questions.
Thank you, Ms. Speed. Anybody have questions?
I would like to add one quote. I love the Churchill quotes. They were great. I want to quote Mike Tyson. Everyone has a plan until they get punched in the face. And that's exactly what happened in Windsor on December 22nd, 2017. That was quite the punch in the face.
Okay, thank you very much. Thanks for being with us this morning and providing your testimony. We do appreciate it. Commissioners, I believe we now have made it through public comment for docket number 2107-00114. It is about noon. I would suggest that now is an appropriate time to take a break for a quick lunch. We had on our agenda a 30-minute break. I'm comfortable with that. Is everybody else okay? Take 30 minutes. So why don't we come back at 12:30, and then at that point we would hear from Mcgee. Okay. Okay, recording in progress. We are back live. This is the Colorado Oil and Gas Conservation Commission. We have gone through public comment, and next on our agenda is an opportunity to hear from Mcgee. In its presentation, I would note that myself and Commissioner McGowan are still involved in trying to get some food. And so I will likely unvideo myself, but I will be here listening intently and taking notes. And there's Commissioner McGowan, same thing. So with that, we recognize Ms. Wazelinski to make a presentation to us.
Thank you very much, Chair Robbins. I just want to take a moment to make sure we've got the team on. I believe Jamie Jost still needs to be added to the panel, if not already.
Ms. Wazelinski, we're adding folks. Some of the Oxy folks have been declining my invitation, so it's just taking a little while to get them in.
Okay, thank you.
Sure.
While we give them just a moment, I'm going to share my screen. All right, can you all see the full PowerPoint here?
Well, you can see the first page of it.
Wonderful. Okay. Let me see here. Just confirming that we've got the Mcgee team on. I think we're pretty well set, but maybe Ms. Larson, I'll reach out to you if we're still missing folks. So I'm going to go ahead and get started. Good afternoon, commissioners. My name is Kelsey Wazelinski. I'm a shareholder at Jost Energy Law, and I, along with my partner Jamie Jost, represent Mcgee in the Longs Peak Oil and Gas Development Plan before you today in docket 2107-00114. We have a number of Mcgee representatives with us who will be presenting the Longs Peak OGDP to you and available for questions. Before we get started, I would like to take a moment to address the public comments received this morning on the Longs Peak OGDP, as well as the written public comment that was e-filed just this past Friday, February 11th, from the Earth Justice and Logic groups. As you will hear from the Mcgee team, Mcgee prioritizes safety in all aspects of its development and made a tremendous effort to listen to and respond to all comments received on this development plan, and particularly those received from residents within 2,000 feet of each proposed pad location. Mcgee filed the OGDP in July of last year, and the public comment period closed on October 30th. No petitions were filed. Despite the later submittal of the Earth Justice and Logic comments this past Friday, all of the concerns raised have and will continue to be addressed by Mcgee in furtherance of the standard to avoid, minimize, and mitigate all potential adverse impacts to public health, safety, welfare, the environment, and wildlife resources. It is also important to note that the director's recommendation, which contains a thorough analysis of the Longs Peak OGDP development and compliance standards by the director and her staff, who have extensive expertise in these areas, concludes that the Longs Peak OGDP complies with all COGCC rules. Before I turn it over to Mcgee, as you listen to today's presentation and undertake deliberations, I implore you all to consider the fact that Mcgee's development plan is equally as protective of one residential building unit as it is to multiple residential building units within 2,000 feet of the proposed oil and gas locations and beyond. As you will hear from the subject matter experts today, Mcgee meets and exceeds the substantial equivalence standards set forth in Rule 604B4. I'd now like to introduce Shay Marshall with Mcgee, who is the first presenter this morning. Afternoon now. Following Mcgee's presentation, we're happy to take additional questions from you all. And with that, I will turn it over to Shay.
Thank you, Kelsey. Good afternoon, commissioners. My name is Shay Marshall, and I'm a regulatory advisor at OXI. Thank you for having us here this afternoon and listening to our presentation. I will run through the permitting timeline, project overview, and the 604B4 slides, and then hand it off to Julie Coleman, who will go over our community outreach slides. As Kelsey mentioned, we have a group of subject matter experts on the call, and we're happy to answer any questions after the presentation. Next slide, please. Mcgee is a subsidiary of OXI USA Incorporated, and we've been operating in the DJ Basin for 30 years. In the past 5 years, we have drilled over 1,000 horizontal wells, and although the slide says 1,960, we have actually plugged 2,600 wells. We have also achieved zero routine flaring in our DJ operations. Next slide. The Longs Peak OGDP includes 2 well pads, the McGavin and the Columbine. Both pads are within Firestone town boundaries, with Weld County and Frederick as proximate local governments. The McGavin pad is 26 wells with 1 production facility and will capture approximately 3,600 acres. The Columbine pad is 7 wells with 1 production facility and will capture approximately 640 acres. You can see here on the graphic to the right, the McGavin is on the west and the Columbine is on the right. Next slide. You can see our permitting timeline here on this slide. We started working with the Firestone staff on this project back in 2019, when they suggested entering into a cooperative development agreement. After working with the town on the agreement for over a year, the Board of Trustees approved it in April of 2021. We held a formal pre-application meeting with Firestone and COGCC to review the alternative location analysis in May of 2021, and we submitted the permit shortly afterwards in July. In November, the OGDP petition deadline expired, and it's very important to note that no protests were filed. And finally, we received approval from the Board of Trustees on both projects in January of this year. Next slide. Now I will run through the 604B4 standards, letters A through G, starting with the director's recommendation. The director has determined that the Longs Peak OGDP application complies with the commission's rules and should be considered by the commission, but leaves the decision to the discretion of the commission. Next slide, please. In regards to geology for this OGDP, we really focused our efforts on consolidating service locations and minimizing disturbance. You can see on the picture to the right that we're developing 4,240 acres with only 2 pads. This is all due to our large drilling step outs and long horizontal wells. Next slide. In regards to technology, we use modified natural gas drilling rigs with sound reduction upgrades. Chris Honus will go over this technology in more detail later. We have a state-of-the-art water on demand system, which is a water pipeline system for our completions phase. This system eliminates approximately 147,000 truck trips for both pads. We also use a technology we call the tankless design, which eliminates oil tanks on our production facilities, which significantly reduces emissions and truck traffic. Next slide. Topography was carefully assessed and accounted for during the planning of both of these locations. Drainage and stormwater designs were vetted and approved by Firestone and the COGCC staff. Next slide. You can see on this slide, we have two cultural features maps. McGavin is on the left and the Columbine is on the right. There are 3 buffers around the working pad surfaces. The first is a 500-foot buffer, the second 1,000, and the last is the 2,000-foot buffer. It is important to note that there are no residential building units within the 500-foot buffer. The McGavin location has 89 residential building units within 2,000 feet, but no high occupancy building units, childcare centers, or schools within 2,000 feet. The Columbine has 8 residential building units within 2,000, but no high occupancy building units, childcare centers, or schools within 2,000 feet. Next slide. As far as our phases of operations go, after several conversations with the Firestone staff, one of our main goals is to get in and get out as quickly and as safely as possible so that future development can occur. We would like to start construction on both pads in May of this year. After construction, we will drill and complete the wells and then reclaim the locations back. We plan to reclaim the Columbine in May of next year and the McGavin in October of next year. One more slide, please. Thank you. We thought it was important to show you how long we've been working with the town of Firestone on this project and run through the local permitting milestones. As I mentioned before, the cooperative development agreement was approved in April of 2021. In December, the staff recommended approval on both special review use permits. On January 6th, we presented both locations to the Planning Commission, and they recommended approval on the Columbine, but denial of the McGavin. As the staff mentioned earlier, the Planning Commission recommended denial on the McGavin because of 2 general concerns. The first was compatibility and the second was traffic. We disagree with the Planning Commission's compatibility comments because the town's master plan and development code allow for oil and gas development in all zoning districts through its special review use process. We worked closely with the town staff on the permits and are in compliance with all of the standards in their development code. At the Board of Trustees hearing, we presented Columbine and received approval, but then asked for a continuance on the McGavin. The reason we asked for a continuance was because we wanted to take the feedback we heard from both the public and the Planning Commission and focus on solutions. Over the 2-week continuance, we came up with 5 additional best management practices regarding traffic and agreed to landscaping around portions of the McGavin. We then presented McGavin to the Board of Trustees on January 26th and received approval. It is important to note that the Board of Trustees also disagreed with the Planning Commission's denial recommendation when they approved the special review use permits. Next slide. In regards to the McGavin alternative location analysis, we wanted to start with the director's recommendation. The director determined that the ALA demonstrates that the proposed location would present fewer potential adverse impacts than the alternatives analyzed. Next slide. We put a lot of thought and consideration into our alternative location analysis for the McGavin pad. We considered 5 locations prior to proceeding with the current pad. You can see on the map here that majority of the alternatives are either closer to residential building units within a higher density of residential building units overall, or closer to schools. 3 of these alternatives would require an entire new pad to develop the rest of the acreage. The only location that would be further away from building units while being able to access the same minerals is to the south of the property. We evaluated this location during our ALA and eliminated it because it is located within the floodplain, wetlands, and portions of the high subsidence boundary. We do our best to avoid these areas when we can. We also had several conversations with the town of Frederick about this parcel, and they are currently in conversations with the surface owner on potential future commercial development. We still feel that the McGavin location is in the best location to capture the 3,600 acres. Next slide, please. In regards to the Columbine alternative location analysis, we also wanted to start with the director's recommendation, which states that the director determined that the Columbine ALA demonstrates that the proposed location would present fewer potential adverse impacts than the alternatives analyzed. Next slide. We also put a lot of thought and consideration into the Columbine ALA. We considered 6 locations prior to proceeding with a proposed pad. You can see on the map here that the alternatives are labeled 5 through 9. This is because the McGavin pad are labeled, the McGavin alternatives are labeled 1 through 4, and we did the analysis based on each 2A. Majority of the alternatives shown are either closer to existing residential building units, within higher density of residential building units overall, or would require additional pads to develop the overall acreage. We feel that the Columbine is in the best location to capture the 640 acres. Next slide. For 604B4E, we plan to continue relying on our strong access to existing infrastructure and design. In addition to the tankless design and water on demand system, the Integrated Operations Center in Platteville provides 24/7 monitoring and control of the facilities in the field. It has remote shut-in capabilities, and it decreases the number of visits to our locations, which ultimately decreases emissions and traffic. Excuse me, I'm getting over a cold here. Next slide, please. You can see from this slide that one of our main goals is to reduce our overall cumulative impact. The green dots are wells to be plugged and abandoned, and are spread throughout the Firestone, Frederick, and Weld County areas. It is important to note that 6 of these wells have already been plugged since the evaluation was done for the permits. We also will be removing 10 facilities associated with these wells. One of these facilities that will be removed is actually on the McGavin parcel near the gravel trail, which was spoken about in the public comment. When comparing the total acreage for the existing wells and facilities to our new development, it's approximately 37 acres compared to 10 for the McGavin and Columbine, which will significantly reduce the overall impact. Next slide, please. Our first choice is to always avoid the temporary impacts from operations to our communities. I have already touched on our tankless design, our water on demand system, and our integrated operations center and all of their benefits. On the right, you will see a graph showing the decrease in our tank VOC emissions over the last 10 years. Production is shown in the blue bars and the VOC emissions by the orange line. We've already achieved a significant reduction in emissions in the DJ Basin, and the new facility designs are continuing that trend. Next slide, please. Here we have our tankless facility video, which I believe you saw on our first OGDP hearing. I will skip over the video for now, but we are happy to show it later if you'd like us to. In addition to the tankless design, we minimize impacts from our operations through design improvements and best management practices in other areas. A couple of examples are using a closed loop system to minimize emissions during completions and using temporary ECDs to minimize emissions from the temporary produced water tanks. We also significantly reduce our pad size after interim reclamation. The Columbine will be reduced to approximately 2.7 acres and the McGavin around 7 acres. Next slide. To mitigate impacts to residential building units and tenants, we will install sound walls on all 4 sides of the McGavin pad and 3 sides of the Columbine pad during drilling and completions. We will also utilize our quiet completions fleet. We also submitted a specific lighting plan to the COGCC and Firestone, which mitigates light pollution throughout operations. Next slide. We also plan to mitigate impacts from odor, traffic, dust, and stormwater. For odor mitigation, we use an odor neutralizer that has an excellent track record. We have a specific database to record all of the feedback we get around our own gas locations to optimize our mitigation strategy and identify areas of improvement. Since we started using this neutralizer at the second quarter of 2018, we saw a significant decrease in the number of grievances we received. The grievance number was in the teens in 2017 and has decreased to an average of 2 to 3 per year from 2019 to 2021. We also worked very closely with a third-party traffic expert during the local permitting process to come up with specific best management practices, including reducing traffic during peak hours and using flaggers and pilot cars during rig, mob, and demob. We are also doing a traffic study on certain sections of Pinecone near the McGavin to see if further mitigations are needed. Next slide. We will have continuous air monitors around both locations. Monthly reports will be generated from the monitors and sent to CDPHE, COGCC, Firestone, and the proximate local governments. We also upload summaries of these reports to our stakeholder website. I will now hand it off to Julie Coleman, who will touch on our community outreach slides.
Thanks, Shay. Good afternoon, commissioners. My name is Julie Coleman, and I'm the Stakeholder Relations Manager at OXI. Our team was created for one purpose: to open communication channels between our company and the residents who live in our operations. Today, I'll share a bit about our community engagement efforts, including what we heard from our neighbors and our ongoing commitment. We regularly share information about our operations, including descriptions of our work, timelines, and health, safety, and environmental data. By prioritizing community engagement, we not only disseminate information, we listen. We've had over 4,000 contacts with stakeholders living and working near our operations in the past 8 years. Their feedback has given us valuable insight that has improved our operations to meet the unique needs of developing and operating oil and gas in the suburban environment. Our team's commitment to residents lasts throughout the entire life cycle of all of our wells, from the planning stages until the wells are permanently retired and the land is reclaimed. In the following slides, I'll describe the specific actions we took to listen to the community and how we responded to their questions and concerns for the Longs Peak OGDP. Next slide. Here you can see a timeline of our community outreach efforts. I will highlight only a few. In June 2020, we sent invitations for a neighborhood meeting, but eventually canceled the meeting due to a lack of interest as demonstrated by 2 RSVPs. Although the meeting wasn't held, we stayed in touch with these stakeholders over the next year, providing information and answering questions. After the cooperative development agreement was signed in mid-2021, we proactively reached out to homeowners associations and home builders, shared project information, and offered to meet with residents to seek their input and to answer questions. To ensure that homebuyers knew of our proposed plans, we also posted signs on our properties facing the new home developments. Next slide. In August 2021, we held a neighborhood meeting that was well attended and had great community participation. Over the next couple of months, we kept the conversations going by following up with everyone who registered for the neighborhood meeting to ensure everyone had several opportunities to provide their feedback and ask their questions. We sent a detailed 16-page completeness packet to all interested parties in the OGDP in October and also posted it to our website. In December, we conducted a door-to-door to all homes within 2,000 feet of the proposed locations. Next slide. During our door-to-door in December, several neighbors told us that they support our project, but were nervously to publicly support oil and gas. However, we did receive several written letters of support and informed consent, which I'll touch on later. Please keep in mind that this engagement timeline is still a work in progress. We've had dozens of conversations with stakeholders in February, and we'll continue to have conversations with our neighbors as these projects move forward. Next slide. In this engagement summary, I'll point out a few statistics we didn't cover in the timeline. As you see here, we invited 162 owners and residents, which is more than reside within 2,000 feet. We also invited residents who live within proximity to the parcel boundaries, surface owners, and commercial tenants. We also shared the invitation with HOAs who were kind enough to forward it. It's interesting that only 11 of the 162 owners and residents nearest to the locations registered to attend the neighborhood meeting, and only 3 of those attended. Most neighborhood meeting attendees live more than a half mile from the development areas. In total, our team has had over 300 individual contacts with community members via phone, email, and in-person meetings. Of those conversations, the most interesting to me were the conversations we had on the doorsteps of those that live nearest our proposed developments, those within 2,000 feet. During the door-to-door in December, our neighbors asked great questions about timing, traffic, and location, and appreciated the information we shared. After these conversations with over 40 residents who live within 2,000 feet, most didn't express any opposition to our project, 14 stakeholders expressed their support, and 4 said they'd prefer the land to remain open space. Of those in support, some said they'd prefer oil and gas near their home rather than a big box store or another subdivision, because once we're done developing, the traffic and other nuisance impacts are significantly less than the alternatives. Next slide. Here I'll share with you the questions and concerns we heard from the community over the past year and a half, and how we've modified our development and operational plans in direct response to this feedback. This summary includes what we heard from the OGDP public comment and a change.org petition called Keep Firestone Beautiful. Although the petition has hundreds of signatures, we're unsure how many of those who signed the petition live in the area. However, we frequently monitor the comments received from the community, as well as the online petition, to ensure that our development plan incorporates solutions to our neighbors' concerns. The first issue that they brought up was compatibility. As we've talked about recently, these locations were chosen after careful consideration with the town of Firestone and nearby stakeholders and make it possible for us to reduce our cumulative impact in the area. We've responded to community concerns about visual impact by including landscaping and a masonry wall around a portion of the McGavin facility and using fencing and berming at both locations. In the next slides, I'll show some 3D visualizations of what the final locations will look like. We heard from neighbors about road improvements and how essential the trail system is. Our neighbors near Columbine are thrilled to learn that a section of County Road 18 will be paved after our development. Residents near McGavin are happy that we'll keep the existing trails open during our development and operations. Furthermore, we'll work with the town to add a 10-foot wide sidewalk that will connect the Falcon Point neighborhood with the Firestone Trail. We answered neighbors' questions about the permitting process and continue to provide up-to-date information, including our operational timeline on our website. The final community concerns of traffic, safety, and floodplain were covered in the previous slides when we addressed our best management practices. Next slide. Here are a few 3D visualizations that show the steps we've taken to listen to the community and visually mitigate these sites. This is the Columbine location, and it shows how berming and distance make it difficult, if not impossible, to see the proposed location from County Road 18, let alone from existing homes further away. Next slide. In this slide, the proposed wells and facility is on the right, and it is difficult to make out given the distance. Next slide. As you see here, the distance and extensive use of berming make it difficult to see the proposed wells and facility while looking west. Next slide. For those that live to the north in the McGavin pad, you can see here that our use of berming effectively screens the wells and equipment. Next slide. I mentioned earlier that during the door-to-door, the majority of residents we spoke to had no opposition to our project, and several shared that they were concerned with publicly supporting oil and gas. However, over the past few weeks in our ongoing engagement, we've been able to get 3 letters of informed consent, 3 letters of support from those that live within 2,000 feet, and another 34 letters from nearby residents. That's slightly higher than what's shown here on the slide because we continue to have conversations with our neighbors. We value the input of the community and believe our permit reflects many substantive changes as a direct result of their feedback. Next slide. Before I turn it over to Shay, here's a picture of 4 signs we've posted facing the new home development near Columbine to ensure that homebuyers are aware of our development plans. We've spoken to the builder several times and provided materials and resources for future homebuyers. The builder shared with us that they plan to start construction on the homes in the northern portion of the subdivision at the end of 2022 and will start closing homes in early 2023. The stakeholder relations team's sole purpose is to maintain a connection between Oxy and our neighbors. We will hold another community meeting prior to beginning pad construction for these locations, and will continue to keep residents up to date through mailed and emailed notices and website updates. We are committed to being a good neighbor by continuing to seek feedback, sharing information about our operations, including descriptions of our work, timelines, and health, safety, and environmental data. Finally, we appreciate the 8 comments today from those that live in the area, including Mrs. Scott, who lives within 2,000 feet. Also, I'd be happy to answer any questions about our development in Erie. Thank you. Shay.
Thanks, Julie. To wrap up the community engagement slides, we wanted to touch on the director's recommendation, which is shown on this slide. Staff recognizes that the dialogue established between Mcgee and the surrounding community shows substantial engagement and a significant amount of information provided. Based on these findings, staff has determined that Mcgee has provided sufficient opportunity for residential building unit owners to engage in this permitting process. Next slide. As a result of the McGavin CDPHE consultation, they sent us recommendations on January 7th. We spent weeks evaluating these recommendations and have committed to several additional best management practices, which I will touch on here in a minute. We wanted to start with the director's recommendation. COGCC has addressed each recommendation from CDPHE and Mcgee and finds that the BMPs reflect reasonable, necessary reductions in impact. COGCC recommended not implementing some COAs that are not feasible or that create unintended safety concerns. Next slide. After receiving CDPHE's recommendations, we have committed to the following items on the slide. To touch on a few, we will provide access for the CDPHE Camel air quality equipment. We are evaluating options to pipe produced water, and we will utilize a natural gas rig, which Chris Honus will touch on in more details now. Chris?
Yeah, my name is Chris Honus, and I'm the drilling manager for KMOG. I wanted to kind of really touch in a little more detail on our desire to try to use a natural gas drilling rig as opposed to an electric drilling rig in the area. It was 2017, I believe. We recognized that definitely compared to what a market rig has to offer, which is tier 2 diesel generators, that there was a huge opportunity to try to figure out a way to reduce emissions coming from the drilling rig. So in 2017, we did a deep dive into the options available to do this. One of the options, of course, was an electric drilling rig. And the other option that we evaluated in detail was natural gas generators. The natural gas generators have the advantage of a 30% reduction in CO2 compared to those tier 2 diesel generators, 50% less sulfur oxides compared to diesel, and 75% less nitrogen oxides compared to diesel. So obviously, something we thought we should consider when we're evaluating getting away from those tier 2 diesels. But the most important stat that we found, and a big deciding factor for us, was that natural gas power generation creates 50% less CO2 compared to coal. And the reason I bring coal up is that 36% of Colorado's electricity is still derived from coal. And that comes from the US Energy Information Administration. And if you can see the chart on the bottom right here, it shows the makeup of the electric power in Colorado and where it comes from. Coal-fired power is still the dominant source for Colorado, and that's followed up by natural gas and then renewables. But because of that dominant coal-fired power, we lean much more towards wanting to go towards natural gas to avoid that step backwards from diesel and having to rely on coal power. So with that, we made the decision to modify all of our drilling rigs in the Rockies to natural gas power generation. There's other advantages to this as well. The big advantage to this is that the electrical grid in many areas within the DJ Basin are unable to supply the amount of power needed to get the 3 megawatts that a drilling rig requires. So the advantage to natural gas on our drilling rigs is we don't have to switch back and forth between electric rigs on some pads and then running the tier 2 diesel generators on other rigs. We've standardized across the board to be able to have the lowest emissions that we can for all of our DJ operations for all residents that we operate anywhere nearby. One thing that does come up is the noise side of things. So we did recognize that by running the generators, we needed to do something to reduce the noise to be able to compete with what electricity offers. To do that, we engineered aftermarket sound dampening baffles on all of our air intake and radiator fans. And additionally, we added aftermarket exhaust mufflers to the exhaust coming from these gas generators. By doing that, we very much stay well within any noise requirements that the COGCC has in place. Jumping to the next slide here. What I'm really excited about, though, is the next step that we're about to take. Starting in April, we've gone out and found battery energy storage systems to add to our drilling rigs. And what we're going to do is create essentially a hybrid drilling rig that runs partially off of natural gas power and partially off of battery power. So the reason that this is so exciting is that we're going to significantly further reduce our emissions on the rig and actually completely eliminate one of the generators that the rig needs to supply power. The way that will work is this battery will essentially kick on when the rig needs a lot of power and provide up to 1 megawatt of power to the rig. And then when the rig is in a low power mode, the generators will recharge the battery. Now, the advantage of this recharging mode is that when the generators ramp down and they're under low engine load, that's when you get the worst emissions from any engine. If you think about like your car driving down the road at 55 miles per hour, at 55 miles per hour, you get fantastic fuel economy and you get very good emissions. Then when you drop down to an idle or stop and go traffic, that's when your emissions are terrible. And so what this battery will do is allow us to stay in those optimal engine loads for the generators without ramping up and ramping down. It'll keep them in that optimal range where we have low emissions and we have optimal fuel efficiency. So we're excited to install these in April. These will be available and be used on the McGavin and Columbine pads coming up. So this is really the next step. And overall, the reason that we want to go this route as opposed to that electricity route for the rigs is we think we can get to very low emissions. We think that we can be better than going electric and having to rely on that coal power that still is so inefficient from an emission standpoint. I think that's it, Shay, back to you.
Thanks, Chris. To summarize our presentation, there were no petitions filed to the OGDP, and the director has determined that the OGDP complies with COGCC regulations. The Firestone Board of Trustees has approved both the Columbine and the McGavin special review use permits. We focused our efforts on consolidating operations and minimizing disturbance to capture 4,240 acres. We will also be plugging and abandoning 39 wells and 10 facilities with this new development, which significantly reduces our overall impact. That concludes our presentation. Thank you so much for listening. As I mentioned, we have a group of subject matter experts here to answer any questions that you might have.
Okay, thank you very much for the presentation. Commissioners, do folks have questions? Commissioner McGowan.
Thank you, Mr. Chair, and thank you for your presentation today. So just to kick off, and I'm guessing a lot of commissioners have a similar question, trying to figure out what substantially equivalent might mean and showing that not just through narrative, but with data is an important consideration for me. And I guess I have two questions that I don't feel like I'm quite getting the answers in your application, which was when you were showing your substantially equivalent, I feel like the comparison was between natural gas, which is what you want to use engines, and diesel engines, instead of comparing electric engines to natural gas engines with the inclusion of this battery energy storage unit. And so I feel like it's difficult for me to understand what the substantial equivalent might be in the consultation letter from CDPHE, which says electric is the most protective, and you all are choosing natural gas, but you're using the comparison to a diesel engine. And so I'm wondering if you could address that a little bit and talk about that. And then part two of that, no, we'll start there. Thanks.
Thank you, Commissioner McGowan. I think Chris would definitely have the answer on the specifics of the rig in electric versus natural gas. I do just want to, if I may, just take a moment on substantial equivalence, because I do think, and then I'll let Chris follow up. I do think it's important to understand what that means in relation to the rules and the Oil and Gas Act. And in the context of considering substantial equivalence, I just want to point you to some language in the statement of basis and purpose for the mission change rules. And that makes it very clear, for example, that distance is only one way to protect public health, safety, welfare, and the environment. And that by setting a substantially equivalent standard, the commission does not intend to set a standard that requires the commission to compare potential impacts of a proposed oil and gas location to an identical oil and gas location 2,000 feet from all residential building units, and that such a standard may be unachievable and would elevate distance as the sole predominant regulatory tool to protect and minimize adverse impacts. So I know, Commissioner McGowan, you weren't necessarily asking about this comparison, but I think when we're thinking about substantial equivalence, I just wanted to make sure we're aware of what that means. And I think the language in the statement of basis and purpose is really helpful. So I'll turn it over to you now, Chris.
So from an emission standpoint, the one stat that I definitely can share is that natural gas compared to coal in particular, which is 36% of the electrical grid, you're 50% less on the CO2 emissions compared to coal. I'll be honest, in front of me right now, I don't have the natural gas numbers for all the other emissions, but I don't know that I would get any argument though that natural gas is definitely going to be better across the board for all of the emissions that you have compared to coal. The other big majority of the electrical grid is made up of natural gas as well, and then renewables in combination with coal dominating. So when we took a look at it and we saw coal and how much worse coal is compared to natural gas, we basically steered ourselves away and said that for the state of Colorado, the best step forward isn't to try to find areas where electricity works and areas where you have to revert back to the diesel generators, but rather to take that huge step forward and try to add the battery and combine it with natural gas and try to get those emissions as low as you can across the board. I do have some numbers I can share with the amount of emissions that we've reduced in our program in Colorado since we've switched over to these natural gas generators. And that amount, and this is what we reported to the EPA in the subpart W for greenhouse gas reporting. So we have reported at this point in time since 2017 when we started switching over 101,274 metric tons of reduced CO2 equivalent that we've emitted into the atmosphere since trying to take this a proactive approach to reducing emissions.
Commissioner McGowan.
Thank you, Mr. Chair. And so I've been thinking a lot about two things. One is, the other part of our rules say that we include consultation from CDPHE. And as a commissioner, I don't know how I don't try to weave in what CDPHE has said is the most protective and then figure out if something else that's being proposed is substantially equivalent. And so, if you have thoughts about that, and I don't know how I figure out that if that is occurring just through a narrative of these are best management practices, it's really good, it's better than coal, when CDPHE is asking for something that's not either of those two things. And so if you have thoughts about that, I'd like to hear them. The second piece is, when we're kind of talking about cumulative impacts, I don't see operators saying, well, I'm using natural gas, which is a reduction of coal, like for the whole region or the whole state. Cumulative impacts has been focused on the area that is kind of directly impacted. And so while I'm appreciative that there's a reduction in emissions by using natural gas instead of electricity, which might be coal powered, I'm not sure how that feeds into the cumulative impacts for this particular community. And so if you'd like to address that as well, I'd be interested in hearing.
Yeah, we did get a chance to sit down with the CDPHE and kind of talk back and forth about the pluses and minuses of electricity versus natural gas. I mean, just being blunt about it, there are pluses and minuses to both. You're right, there are still going to be some emissions with the natural gas generators in the area. And for the state of Colorado, of course, overall lower emissions, but right locally, it will not be zero emissions, certainly. But we do have this robust air monitoring plan that indicates that the emissions that we have shouldn't be of concern. And then when you look at the overall advantage of going to all natural gas from the CDPHE's, from the COGCC standpoint, we really feel that it would be a step backwards to try to go back to running electric and diesel back and forth, and making that small sacrifice of a little bit of emissions coming from the rig that are substantially improved over going electric, but then sometimes diesel, that the best option really is to move forward with this natural gas. And it's the reason why back in 2017, after lots of deliberation internally, we wanted to just basically go all in and say natural gas is the right answer. Let's move forward this route. I hope that helps to kind of answer.
Additional follow-up, Commissioner McGowan.
Thank you, Mr. Chair. So I guess at some point there probably needs to be a discussion with the Department of Public Health and Environment about the benefits of natural gas and battery storage. because I have a feeling we're going to continue to get consultation letters that recommend electrification for these engines. And as a commissioner, you know, I feel like I really need to defer to the expertise of CDPHE and what they think has lower emissions and is most protective of public health. And so I'm struggling to try to figure out what that balance is and how I quantify or how I figure out what to do about that kind of this. So sorry. I'm wondering, sorry, I'm switching subjects here. I'm wondering if you all considered, and this is for the McGavin pad, a different location that would have impacted fewer residents within 2,000 feet, but would have stranded minerals, because I do think that Senate Bill 181 allows us to leave some minerals in the ground if it is more protective of public health and the environment. And so you potentially could move the McGavin pad. You own all that middle property in the middle, further away from the RBUs, but you would leave some minerals stranded. And I'm also wondering how many minerals would be stranded if we did contemplate this avenue or this questioning.
Shay, do you want me to take that one just from a feasibility and the drilling standpoint?
Sure, Chris, why don't you start, and then I can add to it.
You bet. So the majority of the alternative locations that have kind of been brought to light, even outside of the ones that we looked at as alternative locations, they're significant distances away from the minerals that we're trying to target. And the one topic that repeatedly comes up is that many operators, including us, are now doing 3-mile laterals. The problem with the 3-mile lateral and the misconception that comes up frequently is that that means you can have your surface location 3 miles away from the minerals you're trying to target. And that's unfortunately not quite right. Your surface location to be able to do a 3-mile lateral needs to be roughly in the 2,500 to 3,000 foot away distance from the minerals you're trying to target. Then you can land in the target and then do your horizontal up to 3 miles. But if you're not in that 2,500 to 3,000 foot distance away from the minerals you're targeting, it's just not really feasible or possible to drill those wells. And the alternative locations that have been looked at are all really over like a section away, a mile away. And so you can increase that distance of your surface location, but the lateral length you're trying to drill needs to shorten as well. So if you were to try to get more than a mile away, you'd be limited to very, very short laterals that you would be able to drill. You would see a massive increase in the number of wells it would take to develop this location. And you'd also see a massive increase in the number of pads that you would need to have to drill this location. So when I go through the alternative locations that we did look at, the 2 locations that we've picked are by far the most optimal and minimize the number of residents that are being affected. The ones that do have fewer residents are either too far away or they're in a wetland and coal mining subsidence risk area. So they're, honestly, I mean, if we could move this away, we would. These are the only 2 locations that really fit the possibility of being able to develop this acreage.
Thanks, Chris. If I could just touch on one quick thing here, and thank you, Commissioner McGowan, for your question. So as Chris mentioned, we did really focus on consolidation and minimizing our surface disturbance for this overall development. And I think it's really important to note that we will be equally protective, whether there's one home within 2,000 feet or 100. And then we also, as you saw in the slides, we worked with the town of Firestone for years on this development plan, and we're able to come up with something that they were okay with as well.
I'm not entirely sure that my question was answered, which was, I'm not asking of the alternative locations that you put in your proposal. Is there a location within the footprint that you all own where the 2 wells are located that you could move the McGavin location to that are 2,000 feet away? So you'd have to move it over and maybe leave some minerals stranded.
And to put a point on that, if you If you don't know the answer, tell us that too, because that would be helpful as we deliberate on this.
I do know on the Columbine pad, if the further over to the east that we were to move the location, the back builds and the step out that you need to be able to reach the minerals increases substantially. The current Columbine location, it's at the extreme of any back build and step out that we've ever done in our program, and not just a little bit of an increase, like a twofold step change in anything we've done before. So where the pad is at right now is really at our technical capability. And if we were to try to move to the east, which would move away, it wouldn't help at all. Obviously, moving to the south wouldn't work because that's where the development is coming. And moving to the north would also further increase those back builds beyond our technical capability. The McGavin pad, you have the wetlands to the southwest, so we wouldn't want to go that route. And then the further you move to the west, you get closer and closer to the subdivision that's over there. So we tried to balance between the wetlands and the subdivision, and this is kind of the middle of the road ground that we could find for that particular location.
Commissioner McGowan, if I may, Chair Robbins.
Go ahead.
Thank you. I also want to point out, and Shay could maybe shed some more light on this, that the McGavin location does actually strand a portion of minerals. I believe Mcgee evaluated several alternatives to capture 100% of the minerals in the DSU from that McGavin pad, and ultimately would have had to add a third location to get to 100%. And so certainly understand the definition of waste in the context of SB 181, and the McGavin pad does in fact leave some minerals in the ground. I also want to just, when we're talking about ALA, just want to make it clear that Rule 304B 2C, which is the ALA rule, does require that all locations, all potential alternative locations from which the targeted minerals can be accessed. So in order for a location to be within an ALA, by the rule, it does have to target those minerals.
Thank you, Kelsey. Yeah, and just to clarify a little further on the stranded mineral portion on the McGavin side. So near alternative location number 1, I don't know if you guys have that map up in front of you, but we're stranding approximately 480 acres of its portions of section 24 and 25.
Thank you, Mr. Chair. That's all I have right now.
Commissioner Nanchapa.
Thank you, Mr. Chair. I think with the additional comments, my specific question I think got answered, and that was just to really make sure that Commissioner McGowan's question on leaving some of the minerals that are targeted unaccessed. And I think, you know, both Ms. Wozlinski and Ms. Marshall addressed that, but what I'm, I guess, wondering, and I understand what you just noted regarding the rule, Ms. Wozlinski, that it is talking about the targeted minerals. If there was, knowing that you already are not accessing 100% of the minerals that you intended, so you've already made a choice to not access or be able to target 100% of the minerals, what would be the difference in percentage if you moved it further? You know, so in other words, are we at what, 90% now, 80%? And if you moved it further, what would that go down to?
Thank you, Commissioner Nanjapa. I'm going to probably let the team think about this a little bit. I'm not sure we've analyzed a percentage difference between, you know, pursuing the proposed plan before you and alternatives that would strand minerals. So perhaps someone on the team has an analysis on that. I just want to make sure we all understand your question.
Mr. Honest?
I can not probably give you exact percentages just because I haven't looked at it in every single scenario as you move the pads in different directions. But if you look at the existing pads and you try to move them within the parcels that we have, The Columbine pad is already at our limit. So if you moved that pad within the parcel, you would lose 100% of the acreage that you're trying to capture with that current pad. On the McGavin pad, if we stay within our parcel that we own, you can't really move it much without making things worse, I think, on being closer and pulling in more occupied buildings. So I would say if you stay within the parcels, you basically don't have any other options. If you try to go to the alternative locations, based on the distance, the step outs, and again, I apologize, I can't give exact percentages, but it would be significant amounts that you would lose. That step out distance that you would need to get from the alternative locations to land the wells in the target and then try to drill very long laterals, it would only be possible to get a small percentage of the wells that we're currently permitting, unfortunately.
Commissioner Joplin.
Thank you. Just to follow up, I'm sure this is probably in the materials, and I apologize that I don't remember this exactly, but what proportion of the pooling area did you have leased? I mean, I know our requirement, I don't know if I hope I'm making sense with that. I know our requirement is 45, at least 45%, but I'm just curious how much you were able to secure.
Mr. Miller.
Yes, thank you. This is Corey Miller. I'm the land manager for the DJ Basin, and we have an 88%, just above 88% of the area leased.
Okay. And then, so with that and with some of these questions that we're sort of asking, or minimizing the distance, or maximizing the distance, I guess, from the RBUs, from the residential building units, would there be a possibility of modifying the drilling and spacing unit in order to sort of access more within that drilling and spacing unit and move the pad further away from the number of receptors?
I'm not sure who to call on.
Yeah, I think what you're trying to get at is that 88% interest for Kerr-McGee is kind of spread out throughout the unit. So a change in the DSU wouldn't significantly change that interest. Does that help?
It's spread out through the unit that both pads cover, is that?
Yeah. Yes, ma'am.
Okay. Would it be possible to separate the DSU into one that's associated with the minerals that the Columbine pad would access and one that the McGavin pad would access? Would that be something that you would consider? Or what would, and maybe what would be the problems with doing that, if any?
Sure. We do have the setbacks from the DSU boundaries that we would have to take into account if we were to create two different DSUs in these areas. And we'd need to, that would leave an area that wouldn't be developed as efficiently as it is with one big DSU.
Thank you. I think that's all my questions for right now.
Commissioner Gonzalez.
Thanks, Chair, and thanks to all the Kerr-McGee representatives and to Ms. Wozlenki for the presentation today. I've got a question about some of the engagement pieces that we talked about. So my first question is I appreciate, I guess I'll start with a comment. I appreciate kind of the outline in the presentation and some of the materials about all the engagement pieces or points of communication that occurred. And that doesn't tell me exactly what I'm looking for, which is of the 89 RBUs that currently exist within 2,000 feet of McGavin, how many of those residents received or participated in more of a two-way communication between Kerr-McGee and the resident, meaning an actual back and forth and not just a one-way mailing or postcard?
Thank you for your question, Commissioner Gonzalez. I would say out of the 89 building units, we went and knocked on all of those doors, and we spoke to approximately 40 of those directly, door-to-door, face-to-face. In addition to that, and I can't get you an exact number right now, we had phone conversations with many people after the community meeting, many conversations with residents after the door-to-door, on the phone, in email, and in text of those RDBUs. Like I said, we've had over 300 points of contact with people over the past year and a half, individual points of contact. Many of those RBUs, most of those conversations were with people within 2,000 feet. However, many of them were also with people outside. So we sent approximately 800 pieces of mail to the people who live and own property within the 2,000 feet. And then we had over 300 conversations with everybody that's generally interested in the conversation within the area. Does that answer your question?
Kind of, Ms. Colvin, I appreciate the attempt there. Maybe it's just not sorted in your data, in a way that makes it easy to answer my question. But really what I'm just trying to get at is that it's really important that with these 604B4 type applications that we receive, that the communication has some substance to it, right? And I understand there's substance in the content of what's being provided, and that there's all these points of contact that people have the opportunity to discuss with you, and they may not take that opportunity. So I'm just trying to understand how much actual, back and forth engagement occurred. And it sounds like you may not have that number off the top. If you come up with it during these, deliberations or Q&A, don't hesitate to chime in and let me know about that. But that's really what I was trying to get an idea of. 40 of the 89 in the door-to-door campaign is, that's a substantial number. It's still, not everybody.
Yeah.
I don't anticipate, that everybody is the reasonable threshold there. I don't know if there is a reasonable threshold there, but I'm just trying to understand what that is.
If I can, Commissioner Gonzalez, follow up on that. I would say, like I said, we had 40 individual face-to-face conversations at the door-to-door. My guess would be we had at least 15 to 20 more conversations one-on-one with people that are within 2,000 feet. I feel comfortable with the number in the area of about 60 individual conversations, and not just one, multiple conversations with people who live within the 2,000 feet.
Thanks, Ms. Coleman. That's helpful.
Mm-hmm.
Chair, I've got another question along those same lines. In your engagement with the residents within 2,000 feet, I think it's significant that no protests were received as part of this application. At the same time, I'm not quite sure if those residents understood their ability to protest. So I'm curious what in your literature and in your communications was provided that gave those residents an opportunity to understand what their rights are and participate in this process from a petition perspective, as well as from a public comment perspective, because obviously there were no protests, but we did hear from a number of stakeholders within 2,000 feet in our public comment today.
Certainly, Commissioner Gonzalez, thank you for the question. We're happy to answer it. We actually had a couple of residents say to us on the door-to-door, well, I guess there's, what is the permitting process? I guess it's already approved. And we explicitly told them it wasn't approved, told them when the Planning Commission hearing was, when the Board of Trustees meeting was. We've updated our website to let people know when the COGCC hearing was. But in addition to that, we also educated stakeholders on how to work through the COGCC website. We provided the info fact sheets on how to provide OGDP public comment. And we had several conversations with residents about how that works. I think that, as you saw, many residents who live outside the 2,000 foot even had that information. We made sure it was available and publicly accessible for everybody that lived in the community area. We were very transparent when people told us it looks like this is already a done deal. We told them it wasn't, and that there was going to be several public hearings to decide the ultimate outcome. So we appreciate the information fact sheets that COGCC was created. It's made it easier for us to make sure that we educate people in the way that you would like us to make sure that they have access to provide their feedback through the public portal.
Commissioner Gonzalez?
No, that's all for now, Chair. Thank you.
Ms. Wozlinski, did you want to add?
Thank you, Chair Robbins. I just wanted to, as you all know, there's two phases of notice with oil and gas development plans. The first is the completeness packet, which is the detailed letter of development, and that contains the Commission's information sheets on participation. And then the second phase would be the notice of hearing, which has a link to the hearing portfolio and information on how to file a petition within that notice. So both of those did occur in addition to all of the outreach that Julie described. I just wanted to clarify those two additional phases of notice.
Okay, Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you again for your responses to all these questions. So of the 3 individual informed consent that you received, are any of them mineral rights owners?
Commissioner Nanjapa, thank you for the question. I don't believe any of them are. In fact, maybe Corey Miller could get on and say, but I think we reviewed the mineral owner map before we did our door-to-door, and we identified that there were 0 that were mineral owners in that area.
In both McGavin and Columbine, or just in McGavin?
We didn't have any informed consents around Columbine. They were just around McGavin, and none of them were mineral owners. Corey shaking his head yes. So I think we're good there.
And I'm sorry, just to make sure that I fully understood that. So you're saying none of the informed consent were mineral rights owner, or none of the residents within that 2,000 foot of McGavin are mineral rights owners?
None of the people who signed the informed consent letters were mineral owners.
How many of the residents within that 2,000 foot buffer of either location are mineral rights owners?
Corey, do you want to answer that? I believe we talked and it was 0.
Yeah, and Julie, I think you are correct. I think the answer is 0.
Okay, and that is for both, just to be absolutely clear.
Yes, that is for both.
What do we know about the ownership of the new development that is platted nearer to the Columbine location? Is it still owned by the developer, or have the parcels been sold? What's the kind of overall status?
Thank you.
I looked into. Oh, sorry, I'll take care of that, Julie. So, but
for the development near Columbine.
Yes.
Okay.
So that area to the south of that Columbine location, where that platted area is, kind of in the southwest quarter of Section 29 there, it does not appear that the surface owner owns the minerals there right now. There's about 27 different mineral owners in that area, and none of them looked like they were corporations. A lot of them looked individual, a couple corporations, but not significant.
And Commissioner Nanjapa, if you were speaking about the homes that are platted to the south of the Columbine location, we have reached out to the builders several times. We've been to their sales office. We've talked to their corporate office multiple times to seek information about their development timing, as well as when and what we can do to provide resources for their potential home buyers. As you may have seen in the presentation, we have posted signs on the southern portion of that property to make sure that people who are interested in buying homes there are well aware of our intentions to develop that location. We have committed to the builder to stay in touch with them, to provide our business cards, our information fact sheets, and to have a community meeting before we start pad construction, and additional meetings if we need to with the HOA and any other individuals to make sure that residents understand as they move in what our operations might look like and how that will impact their home behind their home.
Okay, thank you very much. And so that was a great segue, because I was going to ask that about the timeline, if there was anything more new that was known, as I know that was not known at the time of the director's recommendation. So we still don't know what the time frame is for building, because they just haven't responded.
We actually got in touch with them. We did a little bit of stalking. We got a hold of them, and we did receive a phasing map from them as well. So they have said that in the northern portion of their subdivision, which is on our southern property line, they'll begin, they're still putting in utilities and streets in that area, and they plan to have homes starting construction in late 2022 and start home sales in early 2023.
Okay, and so then if I remember from your slides, completions were going to be in March 2023, and it would be in full production at what point?
Correct. Shay can have to help me on the production time. We are planning on having completions in March. What we're trying to do right now, Commissioner Nanjapa, is find a way that we could move the completions phase up in our schedule to try and get there before those homes are sold. We're not 100% sure we can do that, which is why we're taking all of the steps that we can necessary to make sure that people are informed and knowledgeable and have a way to reach out to us. We will still investigate all possible opportunities to move the completions phase to before those homes are sold. But I don't know if at this point we can make that commitment. What we will do is make sure we stay 100% in touch with the builder and provide them with our timelines, continue to get updates from them, because their timeline could shift honestly forward or backward depending on supply chain issues. Probably it'll move out. So what we'll do is do everything we can to coordinate with them, provide information for them, and make sure that the residents, before they purchase their homes, if at all possible, see those signs and receive information from the builder.
Okay, appreciate that. I think, and so it sounds like if they were to move up their time frame, you would be willing to delay certain operations?
I don't know if delaying would help, because if we delay, then they'll be living there. What we're trying to do is move in before they move in. And we're trying to stay on touch of their timeline with the build out to make sure we understand that, to see if we can, if at all possible, move up our location. So I don't know if it makes any sense to delay at this point, but we'll certainly make our best efforts to move it up. Certainly we would like to cut down on the number of residents that are within 2,000 feet before we finish our project.
Okay, thank you, and I appreciate that clarification. I did mean,
of course,
maybe to see if they would even be willing to delay their construction. Okay. The last question, this is really minor, but I just happened to notice that the photo you had of the number that you posted differed from the number that you had in the text. So I was just curious which one was the correct number.
I'll check on that, and if there's a mistake, we'll correct it immediately. So I apologize for that. I'm not sure. You might be right. We might have, we were in a hurry to get those signs up, to get things moving. So we'll check the slides and our information. But we do have business cards, flyers, website, multiple ways for people to contact us. So we'll make sure that we are available and accessible. Thank you for that comment.
Thank you.
Ms. Wazelinki, one of the points that your clients have been making is the sort of extent of the planning that has gone into this. Can you, or can someone tell me when the company purchased the parcels that are the subject of McGavin and Columbine?
Thank you, Chair Robbins. I'm going to turn that over to Shay. Do you know the answer to that question?
Yes, thank you for the question. We purchased the properties in 2015, and we have a landman on the call that can answer any specific questions about the purchase.
So 2015?
Correct, yes.
Thank you. Commissioner Messner.
Thank you, Mr. Chair. So I've got a few questions here, but I'll start with the community engagement and some questions around that. So understanding that I've read all of the information in your community engagement plan, and while I acknowledge that in your application you indicate that it is not a required element of the rules, it is an important part of the review under 604B, and so I would consider that a requirement. The engagement, at least the one-way engagement, seems like a lot, and I appreciate the list of engagement that has gone out there. I think where I'm missing and trying to understand, somewhat similar to what Commissioner Gonzalez was indicating, is like any kind of transcripts, recording of community meetings, understanding of what the concerns that the residents had, what that depth of communication that would go into a community engagement dialogue that would help me understand that two-way communication and what was happening between the operator and the community in that engagement. Is there anything like that available, or is what I'm reading and what's been submitted the extent of what you're willing to offer on that?
So we've done our best to have a lot of two-way communication with the residents, both inside 2,000 feet and outside 2,000 feet from the beginning. So as you know, we invited people to community meetings, we sent the required notices, we sent introduction postcards. But you're right, we want to have that two-way conversation with people, because you can't learn a lot just by sending things out. So after the community meeting, we had everybody who registered their email addresses and most of their phone numbers. We made calls and emails to every single one of those people with an offer to meet individually with them. We left messages. We tried to just stop right just short of stalking. We called people, we emailed them, we asked them to reach out to us to have an individual one-on-one meeting to make sure that we heard their feedback and answered their questions. As we talked about earlier, we sent the completeness packet and encouraged people to talk to us, to reach out to us. We asked HOA managers and presidents if we could come and meet with the HOAs to listen to feedback, answer questions, talk to people. We followed up with everybody on the door-to-door that we had conversations with and that we didn't. We left notes, handwritten notes on their doorstep asking them to reach out to us, and did our best to try and make sure that it was a conversation instead of an information sending opportunity. So I'm trying to think if there's anything else that I'm missing here.
So
but
I guess what I'm missing is perhaps you can shed some light on it just from a anecdotal basis. What was the feedback you received? What were the concerns that you heard? What was the major points of contention, you know, from who and from where, and you know, how did you choose to address those? I mean, to me, that's that two-way communication, right? And that's what I'm not seeing is that second piece, that response, so that I understand better concerns of residents and how that got addressed.
So a couple of great examples of how we responded are specifically to the visual impacts to the trail and the traffic. And I'll address each of those. So at the community meeting and before the community meeting, we heard a lot from the community that it was very essential that their trail system remained open. We went back and talked to our operational team, made sure that we could keep the trail system open during our development, during our operations, and we listened to them about screening. We, instead of just having fencing, we incorporated the use of a masonry wall. We added some different fencing along the trail system so that it would be aesthetically pleasing to people. We conducted 3D visualization so that people could understand what the locations would look like with the berming and the recommendations with the landscaping from their homes.
That would be great for me to see. Just FYI.
And the visualizations, we can go back to the slide deck. They're in there. Those visualizations.
Was it the ones that I saw? So it wasn't with the drill rigs and stuff. It was just
it's what it will look like. Yeah, what it'll look like after we're done. The other things that we really heard from the community and we acted on were the traffic, where we took their concerns about traffic and we showed them the best management practices we were going to do, what the total traffic per day during each phase looked like, and provided that information to them as well. I think that I touched on most of them. So I would say that we incorporated a lot of the feedback that we heard from the community directly into our plans, making many changes based on what we heard from residents both inside 2,000 feet and outside 2,000 feet. Does that help you? Does that help show that we heard what the community said and responded to their concerns?
Yeah, I mean, it's a snippet, right? And so, I mean, just for me, just for future reference, like that understanding of what that community feedback was in some sort of way that isn't anecdotal, right? So is helpful for me, whether that's transcripts, reports, recordings, minutes, whatever that may be, right? So I want to, as we continue along the community engagement piece, so to me, the 40 undeveloped lots at the Columbine site are significant. And while not currently having residents, to me, there is no question that they will eventually become residents in the near future. And so in my mind, I'm treating them as RBUs. And so that, I mean, when I initially, so the question bases on my initial review of your application, which was you weren't able to contact the developer. Now it sounds like you've got some communication going on between the developer, but what kind of certainty can I have as a commissioner that that level of communication, that level of engagement that you've engaged with existing RBUs on the McGavin pad and the Columbine pad are going to occur with the RBUs associated with the Columbine pad that have not yet been built? I mean, it's fine to hand out business cards and say, hey, let me know. I mean, if I was the developer, I may or may not want to let folks know that are buying those houses that there's going to be an oil and gas operation happening in the backyard. And so I'm a little, I guess I'm looking for certainty that that level of engagement is going to happen with that particular situation as well. Any comment on that?
Of course. One thing I just want to back up Commissioner Messner and tell you that we do hand out the slide decks of all of our community meetings and all the materials and post them on our website, so they are readily available. Just one more thing to make sure that there's some transparency there of what's going on there. And then as far as those 40 lots near Columbine, we're absolutely focused on those, laser focused. We have planned our engagement plan considering that those will be RBUs, as you've said. We did reach out to the builder in August, stopped by their sales office, spoke to them, invited them to the community meeting. They did not attend. We stopped by their sales office several times since, and they've been closed. And that's why we've continued to reach out to them until we found a contact at their corporate office who will speak to us. And I think we have a very good relationship and understanding with them now to make sure that we are doing everything we can to provide them with additional details and information. As far as the concern that the builder doesn't pass along the information, it's a concern we share, and that is why we've posted these giant 8 foot by 10 foot-ish signs on the property on the southern side, letting people know there's proposed oil and gas development with our website, our phone number, our email address, so that there is no surprise when people come to the neighborhood that we have oil and gas on the location in that area.
Okay. I'm going to jump around here a little bit, so I apologize in advance, but I'm going to jump over to the ALA, and I appreciate some of the questions that have already been asked around the alternative location analysis. In a particular situation like this, for this commissioner, that's an incredibly important process, and it's not, to me, it has to be comprehensive in its analysis of different options, including consideration of properties that are not currently under the ownership of a particular operator or have the potential to come under the ownership or may or may not strand minerals. I mean, I think to me, particularly in a situation like this where there are a significant number of receptors associated with this, that alternative location analysis becomes critical. There was one point that was brought up today, I think in your presentation, that indicated that potentially there was a site, and maybe it wasn't in your presentation, maybe it was in what I read, but there was a site that is owned by the town of Firestone that was a potential site that could be considered, that the town of Firestone decided that maybe they just didn't want to let you use, or it was a little confusing. Maybe talk a little bit more about that site, whether that was considered in the ALA analysis, why or why not, besides what I have heard, which is the town of Firestone decided that they would rather see that commercial.
Yes, thank you for the question, Commissioner Messner. I believe you're referring to maybe something that was brought up with the town staff in the very beginning. We didn't have anything particular or specific to that in our presentation, but there is a portion on the McGavin ALA in section, I believe it's 19, which is to the north, about a mile to the north, that is owned by the town of Firestone. And you can see it's bound by, on 3 different sides, by residential development. And so we had a conversation with the town early on about this location because it would be further from residential building units. However, they have their central park plan covers that entire northern section. And so early on, we rolled that out and decided to eliminate it from our ALA. So on our ALA maps, you can see it's kind of in a red area, which was eliminated on way early on because of the town.
That's good. I think I read it in your ALA then, as I had it in my notes, and so I appreciate that. I wanted to talk then a little bit about produced water and the understanding that in this particular application that produced water would be stored on site and be trucked off site. resulting in a pretty significant number of truck traffic, a significant amount of truck traffic and potential impacts to neighbors and surrounding communities due to that. While in your application, you indicated that maybe there was an opportunity to pipe it 3 miles off site. You weren't going to commit to that. To me, that truck traffic, and I believe anticipated around 7,900 additional truck traffic trips for produced water over some initial amount of time, and then a decline curve going from there. Maybe talk just a little bit more of that, and make sure that I'm clear on the amount of truck traffic anticipated by the produced water operations by not piping the produced water off-site, and how you plan to mitigate those impacts of that truck traffic.
Beth, were you able to join as a panelist? Hoping you can answer this one.
Yes, I can join. We estimate it's about 7,800 truck trips over 3 years. We have a lot of stuff in place that helps us minimize that truck traffic. We use an app called Engage that it's basically Uber for water trucks. So you're not doing partial loads. You're not sending out unnecessary trucks. We are constantly monitoring those water levels so that we only haul when absolutely necessary. They are looking into the potential to pipe the water. We can't fully commit until we look into the full scope of that. So that's why there's not a full commitment yet. Our facilities team is still looking into that.
And are you making that determination of whether or not to pipe it to an offsite location on a financial consideration?
My understanding is it's more of a feasibility issue with the right-of-ways. Can we get to a saltwater disposal? Does the saltwater disposal have capacity for that water? We don't have anywhere we can pipe water to that it's like a tank facility or something. It would have to be piped to a saltwater disposal facility. So we would have to make sure that that facility is set up to receive our water.
Why is that, Beth? In other
Why
words,
is what?
Why is it that there's not the potential for consideration of pumping the water to a location that is not a saltwater disposal facility, but that then could have tanks, and then the trucks could leave from there, which is much further away from the RBUs?
We just don't have a facility like that. Like, we don't have water storage facilities in the basin.
But you are creating a water storage facility in the basin in this proposal. So I think the question that Chairman Robbins is asking is, if you've got these 10 tanks on site that has the potential of bringing truck traffic to site, what makes it infeasible to pipe this produced water to another site that doesn't have the receptors associated with it, that has these same 10 tanks that then the trucks can go pick up this water from?
Bingo. Thank you, Commissioner Messner.
We just don't have a site set up like that. You're just kind of moving the problem somewhere else. So it's if we had a location where we already have tanks set up, that'd be an easy answer, but we just don't have facilities like that. You're just moving the traffic to another community then. We wouldn't be able to pipe it. I mean, building pipeline to get this really, really, really far from communities would be an enormous amount of pipeline under many roads through many communities.
All right, I want to move on.
Commissioner Mesner, if I may, I'm so sorry to interrupt.
Sure.
I do have some clarity, and thank you very much, Beth, for the answer on that. I did get some clarity from Mcgee that it is only a right-of-way issue, and that if the right-of-ways are secured, which is looking very positive, they would, absolutely consider piping that produced water. I just wanted to jump in and make that statement that it appears to be only a right-of-way issue that is looking positive in terms of resolving itself.
Okay, thank you. So again, I apologize, I'm jumping all over the place here, but I want to talk a little bit about VOCs and odor versus potential health impacts. And I mean, VOCs can have two different things. I mean, certainly VOCs is a characteristic of odor. It also has the potential to have compounds that are associated with public health. In your plan, you're suggesting the utilization of an odor neutralizer, but I believe, and this is partially a question to you, Commissioner Hackett, as well. There was a request from CDPHE to have zero VOC drilling mud, both for the public health impacts as well as the odor impacts. And so while I think that you addressed in your application how you are proposing to address the odor neutralization piece, and not hearing anything about the potential public health impacts of VOCs and how you're addressing that.
Yeah, I can jump in and take this one. So definitely two very separate issues, odor and then health effects. So odor, I think you guys know our solution for that with the odor neutralizer. So I won't dive into that too much unless you have further questions. The health effects side, we definitely have done two things to make sure that we're absolutely safe for the public in this area where we're trying to drill. The first one, we have people that work on location. They live on location 24 hours a day, 7 days a week. They work rotational work where they're on location for 2 weeks at a time, their entire time there. So we definitely wanted to verify that our workers on location were safe. So we've done studies to study the health effects to our workers who live there more than half their life. They end up on location. And according to OSHA exposure limits, we are orders of magnitude below any PEL exposure limits for our personnel on location for the concerns that you have there. Now, of course, your concerns, though, I know aren't the workers on location. They choose to be there. Your concerns for the public off site. About a year and a half, 2 years ago, roughly, we started our monitoring program off location, where we monitor both VOCs, and then we use carbon sorbent tubes around our drilling locations, and honestly all locations, but our drilling locations in particular. We set up these VOC monitors and then the carbon sorbent tubes 165 feet away from our pad location, so much closer than any of the residences that we'll be drilling around on these pads. We have nearly 900 samples now that we've sent off for lab testing to evaluate. And all of those lab results are public record and available, but they all indicate that there are no reasons for concern for any of the emissions that would be coming from our drilling mud. Hopefully that helps, and I can keep answering more if you have it, or Chad, if you have anything to add.
Yeah, this is Chad Fletcher. I'm the environmental manager with Oxy, 1099 18th Street. Yeah, we have an air monitoring program that's been approved by CDPHE, and actually as part of the consultation that the COGCC has got an opportunity to comment on too. And kind of, I guess, to Chris's point on the comfort level that we have with the public health is that we've done monitoring about 20 pre-production sites, and all these sites have similar designs and emissions, and all the samples that we've taken there for benzene have been well below the health guidance value established by CDPHE. So we think, given we're going to be doing similar type operations with Gavin, like Chris said, most of our monitoring is done at 165 feet away from the walls, and as you move out further, the impacts are going to decrease. That we feel very confident we're going to protect public health with the system we have set up.
So to take it another step, so you are proposing the utilization of oil-based drilling muds and the utilization of an odor neutralizer. Is there a drilling mud that has zero VOC available? And why not utilize that?
There is. From a logistics standpoint, the blend that we do use is readily available from multiple suppliers. And when you move into the type 3 drilling fluids that are the very, very, very minimal VOC fluids, it starts to limit us. So in theory, could we use a type 3 drilling fluid? Yes, we could, but based on all the data that we have, there's no benefit that would come from doing that. So we haven't decided to go down that route at this point because the data from the significant monitoring program that we have just doesn't show that it's necessary for either the workers on location and then obviously especially for occupied buildings off location. I will add one thing too. We have the carbon sorbent tubes that you have to send off to a lab, but the VOC monitors are really the check that give you the good filling because they are a live active monitoring system that sends out immediate texts and emails to the people in our operation that if they were to see a VOC spike off a location, we would immediately get alerted so that we can immediately figure out what the source of that spike would be. We set the level on those spikes extremely low, way before what would be a concern from a health standpoint. And we've had very, very few even of those spikes. And so we just haven't seen any data over many pads now with lots and lots of this real-time data coming on the VOCs that said there's a reason to drive ourselves to the type 3 drilling fluid.
What were the situations that caused the spikes in the few times that did occur?
Honestly, and Chad, you may jump in on this because you're the one who really monitors this, but usually it was,
I can handle this one.
Yeah, go for it, Chad.
It seems like that usually when we're drilling the lateral is when we see the higher emissions, but I would say generally it becomes the right atmospheric conditions that we see that kind of causes whether we got kind of real cold conditions, we may have an inversion kind of hanging up there where all the emissions kind of just hang out in the area. For drilling and stuff, I guess since we've started a program in 2020, we've had one alert that basically, as Chris has described, with our VOC monitors, we've established 3 alert levels. All alerts are based on historical operations and shown to be protective of public health. But what they are is an indication there's a change in operation. So we have a level 1, level 2, and a level 3. All this is coordinated through our integrated operations center, and they watch it 24 hours a day. So if this happens in the middle of the night, they get an email alert and they dispatch people to the location, whether it be our IR team, Chris's team, whoever it may be, to basically investigate what's going on there so we can make changes to the operations as necessary. The one incident we did have was during completions. We ran into an abnormal condition where we had some hydrates forming in the well. We quickly addressed the issue. We took benzene samples all during that deal. While we triggered an alert, our benzene concentrations were still well below the health guidance values. At the end of that result, we went back and did basically cause of the situation. In that case, we came up with a new operating scenario that we utilized at wells since that time and has resulted in no alerts. So we believe our program is very effective in monitoring emissions, not only for protecting public health, but also measuring the performance of our facilities.
Oh, go ahead.
I just saw Commissioner Hackett has raised his hand, so I don't know if he wants to segue into this before you move to a different topic, Commissioner Messner.
Sure.
Thank you, Mr. Chair. And Commissioner Messner had asked a question and partially directed that to CDPHE. So I wanted to take this opportunity to respond. And first, thank you for the question. And with respect to odor neutralizers, while odor neutralizers may be helpful in addressing odor concerns, in and of themselves, they do not necessarily reduce the level of benzene and other VOCs that may be emitted from drilling mud. In their response to the CDPHE consultation, Mcgee didn't provide any justification for why they weren't able to use Group 3 muds, and I think they did so again today. And as Crestone on the Lone Tree North pad, they did agree to those. So at this point, I can only assume that Mcgee is capable of using these types of mud. And then also importantly, although Mcgee has provided information to help demonstrate why their drilling fluids help to reduce odors, and they have so far, fortunately, not resulted in any emissions that exceed health guideline values, Mcgee has not provided information to suggest that the benzene content or other VOC content or even the polycyclomatic aromatic hydrocarbon content in their fluids provide the same or substantially equivalent protections as if they were using Group 3 low VOC drilling muds. And I think this is relevant also to the questions about the air monitoring program that Mcgee has. And that is a program that has been approved by the Air Pollution Control Division. And I did want to note that CDPHE is encouraged that there is more widespread adoption of air quality monitoring by the oil and gas industry. And we do commend operators like Mcgee who were early adopters of monitoring technology, even before it was a requirement in an air commission rule. And we look forward at CDPHE to partner with COGCC to share the lessons that we learned through this expanded air quality monitoring. That's useful data. We're eager to put it to use. And although it is good to hear that the monitoring Mcgee has done so far has not resulted in any samples that exceed a 9 parts per billion health guideline value for benzene. And while it is true that, again, Mcgee's monitoring program for McGavin has been approved by the Air Division, air monitoring results, while useful, they only provide one piece of the cumulative impacts puzzle. So specifically the conclusion that there has not been an exceedance of a health guideline value, that only applies to the compounds that have been measured and at the locations at which they were measured. Modeling, on the other hand, though not without limitations, as Mcgee has pointed out in their response, it's useful because it greatly expands the number of locations and conditions far beyond the number of samples that can reasonably be collected. So although we know quite a bit about potential health impacts from exposure to pollutants above health guideline values, such as benzene, for example, the main risk driver for CDPHE community investigations, there's still a lot we don't know about the impacts of being exposed to multiple pollutants combined, or about the health effects we hear about most frequently for people, things like headaches and nosebleeds. So again, although this emissions data is useful, it does not account for the combined effects from other cumulative impacts people living near oil and gas facilities may experience, such as the impacts from odor, noise, light, traffic, stress, et cetera. And so because of this, although this monitoring data will result in useful data that will help us better regulate emissions from the industry and understand and minimize cumulative impacts, there are a lot more pieces to the cumulative impacts puzzle that must be considered beyond just these air monitoring results. So thank you for the opportunity to respond to that.
Commissioner Messmer, I think the floor is back to you.
Thank you, Mr. Chair. Thank you, Commissioner Hackett. That was super helpful for me, and kind of goes to my next question, which was around the modeling piece. I think CDPHE in their consultation indicated a desire to see some modeling done on this. I think Mcgee has determined that they are unwilling to do that modeling, and I'm wondering why that is.
Yeah, I think we responded that, this is Chaz Flechtemeyer again, and our response was that we're definitely willing to work with the division. We actually reached out to CDPHE after we got the letter requesting a meeting. A meeting hasn't been set up, and that's not related to Mcgee. Once again, I talked about our air monitoring program. We have a very robust air monitoring program, and I think our preference is that actual emissions monitoring is more representative of what the impact is going to be than modeling would be. So we're definitely willing to go to the table with CDPHE and discuss modeling, but we strongly think that looking at actual data is more representative than any model will show us.
Or you could do both too, right?
And we could definitely talk about that for sure.
And Commissioner Messner, if I could also respond to that.
Sure.
Did want to say, and thank you, Mr. Schlichtemeyer, for that. And thank you, Oxy, or Mcgee, for the openness to having those discussions. And you'll notice in the CDPHE recommendations, we deliberately took this modeling recommendation out of the conditions of approval pieces. So we had recommended specific conditions of approval. If those aren't implemented, we would recommend denial. And then we pulled this modeling piece away from that and kind of included that as more of a softer recommendation for some of the uncertainty and some of the additional discussions that we need to have around that. So yeah, that's just wanted to explain the thinking there and why, you know, there's some further discussions that we need to have with operators about how modeling might help inform this substantially equivalent protections piece.
Okay. Well, I'm going to ask the question to both Mcgee and Commissioner Hackett again on another topic around the camel. And I appreciate the CDPHE's desire to include air monitoring with the camel unit. As a check and a balance or another set of data points, which I think is always helpful. I think that at least in what I've read from Mcgee, that they're okay with that being available or having that on site. Although it sounds like there's still a problem with access to power or some sort of failure to communicate as far as different opportunities to create an opportunity for this camel to have power to get set up. Can someone from Mcgee explain to me what the issue with the power is? And perhaps Commissioner Hackett, I mean, I'm just making an assumption that the camel takes 220 power, but maybe I'm wrong.
Can I, sorry to interrupt, can I respectfully ask to go first and then give Mcgee the opportunity to respond? Is
Sure.
that okay? Okay. Thank you, Commissioner Messner. So CDPHE, we do appreciate Mcgee's willingness to provide access for the camel, but merely providing access without also providing electricity doesn't really provide us with what we need to find a suitable location and collect high quality data. So yes, the camel is capable of running off of a generator. However, CDPHE does not own, and we're not funded for a whisper generator, as Mcgee suggested in their response to the CDPHE consultation. So unless we're able to secure electricity, we're only able to run the camel off of a diesel generator. And of course, electricity is preferred to diesel because of the noise and emissions from the generator. They could potentially impact nearby residents. Operating off of a diesel generator limits our deployment time to only 5 days, and the diesel exhaust could potentially contaminate our measurements. So because electricity is critical, I did ask Mcgee after they submitted the response to the consultation, I asked them to respectfully reconsider our request to provide electricity. One option that I suggested was something that Great Western was able to do for CDPHE at their Ivy pad in Adams County. In that case, Great Western laid a high voltage line on the ground during drilling to allow us to operate the camel. And Mcgee has, expressed that they have some safety concerns with laying high voltage lines. So they're not really open to that opportunity or to that option. So another option that I suggested was for them to fund the installation of the necessary electrical work at a nearby residence property, if they're open to hosting the camel. And this is something that we're thankful that Weld County was able to do for us on a recent monitoring effort. Mcgee, to their credit, they have expressed their openness to this option, so long as CDPHE kind of initiates the discussions and reaches out to the homeowners and discusses electrical needs and what a camel deployment might look like. And I do believe Mcgee's also committed to sharing some of the contact information with the stakeholders they've reached out to sort of help facilitate CDPHE's outreach efforts here. So we do really very much appreciate their assistance in this, but the reality is as of today, we don't have a suitable monitoring location and we don't have electricity. I'm hopeful that we'll ultimately be able to get there. And I will, I've been taking notes from the public comment session this morning of folks who live nearby. And if this location is ultimately approved, I do plan on reaching out to those homeowners to see if they may be able to provide a suitable location. So just wanted to provide that. And then not sure if you have any more questions, Commissioner Messner, or if we should hand it back to Mcgee for their response.
I'm happy to hear from Mcgee on this one. Thank you.
Yeah, this is Chad Schlichtenmeyer again. Yeah, as Sean mentioned, that, we've examined this, providing power for the camel. We definitely support, the CDPHE monitoring out there. We've partnered with them at other locations, and we welcome to come in there to, verify, validate kind of what we're doing. We think it's good for everybody to see their equipment come out in the locations. When it comes to things, safety, is definitely a #1 priority. And, we evaluated laying a power line on top of the ground, and our people looked at it and said they thought that was not a safe thing to do, a high voltage type power line to put it out there. So at this point, we've kind of determined that that's not an option. We are committed to working with Sean and his team. Julie Coleman and I will be setting a meeting up with Sean here in the near future to go over the stakeholders and help them in trying to secure a residence in the nearby that we could potentially put the camel by. One thing that, you know, we're trying to look at is there's lots of activity in the area when it comes to other emission sources too, that you know will have to be taken into consideration when we try to find a nearby source.
Okay, well, thank you for that. I've got a couple other questions. Can it be reasonably assumed that on either of these locations that at some point in the future there could be recompletion activities associated with them?
Corey, are you online? Is that something you can help answer?
Yeah, I'm trying to get connected. Sorry about that. Can you hear me?
Yes.
So based on the development proposal, we're planning on capturing all of that acreage with the proposed development plan. So there would be no plans to come in and recomplete following these operations.
Would Mcgee consider including that as a BMP, that there would be no recompletions?
Yeah, I think that would be something that we would consider.
Okay. Thank you for that. If another commissioner wants to go here for a second, I'm a little bit all over in my notes, and so I can take a pause and kind of regroup here.
I can follow up on a similar vein with regard to sort of completion, et cetera. So from your narrative and from the slides and from the application, I've noted that there is a period of going in and with the rig and doing the initial work, and then there's a 5-month delay, and it's significant enough that you're taking down the sound walls, and then there's a go back in and complete. And so having, I guess my point is that it seems to me that this would be better if you could just go in and do this in one slug and just get in, get it done, get out, as opposed to going in, leaving, making people with the assumption of, they must be done. We're done with this. And then all of a sudden you're showing back up. And it seemed that that was based upon just sort of your schedule. So I just throw it out there for consideration by Mcgee and or explanation as to why that approach is necessary.
Thank you.
Similar to what you had mentioned earlier, I think we're looking at optimizing our schedules as best as possible. We have to take things like SIMOPS into consideration with Columbine offset to McGavin. So we're taking a closer look at that and trying to accelerate things as much as possible and compress those gaps wherever we can.
Chair Robbins.
Was Linky.
Thank you. I just had a quick point to make. I think as we're talking about these various operational standards and meeting substantial equivalence, there's obviously multiple ways to get there. And this, I at least and the entire Mcgee team appreciates the dialogue. I did circle back with the group on the Group 3 drilling mud, and I believe you all have the authority to add COAs to an OGDP. And so if there is an opportunity to have a dialogue, and while Mcgee, stands by its original proposal here, I think they would be open to adding a COA for Group 3 drilling mud if that's where the commissioners would like to see this go.
Okay, thank you for that clarification. I think I saw Commissioner Nanjapa's hand go up, Commissioner Messner, when you were yielding the floor.
Thank you, Mr. Chair. Yeah, along the lines of that sort of, getting in and getting out, I was curious if your estimates of truck trips included the construction or deconstruction of the sound walls and reconstruction thereof. And if not, how many additional truck trips would that take?
Yes, thank you for the question, Commissioner Nanjapa. The way that our traffic consultant broke down each phase, the construction of the walls for both pads was included in the actual construction phase. So those numbers were accounted for.
I'm sorry, so that's the construction phase, but what about the removal of the sound wall and the reconstruction thereof?
Yes, so the removal would be included in the drilling phase. The removal and the reinstall for the completions.
Okay, so those truck trip estimates is inclusive of all of that.
Yes, correct.
Okay. The other question I just wanted, this was more about just a clarification. I think I saw that while the wetland, it is within 157 feet of the working pad surface, it is not going to be in close proximity to the storage tanks. Is that correct? And I know you have a CPW waiver, but I just wanted to confirm that it's actually located further away from that edge of the working pad surface that is the closest to the wetland.
Yes, thank you for the question. Joseph, are you on? And can you
Yes,
help answer?
thank you for your question, Commissioner Nanjapa. The delineated wetland is located to the west of the proposed development, and our facility is going to be on the southern side of the location. So the wellheads will be the closest permanent equipment to that delineated wetland.
And what is the distance? I know the working pad surface is like 157 feet, I believe. But what is the distance to the wellheads?
I will have to get that measurement for you, Commissioner Nanjapa.
Do you know roughly, is it greater than 500 feet or?
I could jump in here, Joseph. I actually do have that here in my notes. It looks like the wetland is approximately 662 feet from the wellheads.
From the wellheads. And then there's no storage tanks that are within that distance either, is that correct?
So I believe the production equipment is going to be even further because it's further south. It looks like the nearest piece of production equipment to the wetland is about 674 feet.
Okay, thank you.
Commissioner McGowan, then Commissioner Messner.
Thank you, Mr. Chair. And I think this question might be more towards CDPHE and one of the conditions of approval, which was the tankless recommendation. And from what I understand, I'm trying to understand if that's more about the truck traffic or the VOCs that might be coming off the water tanks. And I'm wondering, because my understanding is that emissions from produced water are pretty minimal compared to what we might see from an oil tank. And so I'm wondering if the concern is about the tanks. So from understanding, we're going tankless for the oil. We have tanks for produced water, which is the conversation around, is it possible to have pipeline, do it at a different site? Is from CDP's perspective, is the concern about the VOC emissions that possibly could be coming from the tank or the truck traffic that's involved with taking the produced water off site?
Thank you, Commissioner. Oh, thank you, Commissioner McGowan and Chair Robbins. The short answer is both. I mean, we are concerned with emissions off the produced water storage tanks, but they are not believed to be significant sources of emissions. But we're more concerned with the truck traffic and the associated diesel emissions.
Okay, thank you. Oh, sorry.
Go ahead.
So also, I guess for CDPHE, when we have requests for conditions of approval where the operator says it actually isn't feasible or there's a safety concern, and they're offering up an alternative, have you looked at those alternatives, and does CDPHE have any thoughts about those? I think there's a couple of conditions of approval where the operator has says we have safety concerns about those, but we're going to do this. This is what we're doing.
So I don't know which one you're referring to specifically, or thank you for the question. I don't know which one you're referring to specifically, but the one I think you're referring to is condition of approval number 10. CDPHE recommends for odor mitigation, operator will use enclosed shale shakers to contain fumes from exposed mud. And that's one where I don't think they actually offered an alternative to that. They just noted that they have some safety concerns there. And that's one, after additional discussions with Air Division staff and folks at CDPHE, that's a recommendation that I don't think CDPHE will be making going forward on consultations because of these safety concerns. And a little bit of background on that, the reason why we made this recommendation is in part because of the experience from the Broomfield community. Their monitoring seems to suggest, or there's some potential that open top shale shakers are a significant source of emissions. So, we wanted to explore what opportunities there might be for enclosing that or for somehow offsetting or minimizing those emissions. But it sounds like putting a hood or some sort of enclosure on those shale shakers is probably a safety issue, and we don't want to force that upon folks. But we would, acknowledging that there is a potential source of emissions there, we do encourage operators to pursue every possible opportunity they can to minimize emissions from those shale shakers.
Thank you, Commissioner Hackett. I think I'm gonna have to look at my notes, but I think another one of the issues was using actual people at night instead of the backup noise that the truck makes, and that was also a safety concern.
Thank you for that question and the reminder. Yeah, the recommendation there was, well, first so the recommendation was we recommend that Mcgee use an observer or signal person when backing up trucks during nighttime activities. The use of an observer signal person to safely back up trucks is consistent with OSHA standards and would help reduce potential noise impacts to people who are living near this facility. I don't believe Mcgee's response actually provided an alternative to what they would be doing there. They did mention that they don't think they can safely turn off those alarms. But I guess I don't really have much of a leg to stand on to say that we should force them to do that. It's just, my understanding is that using a signal person or an observer instead of these noisy truck backup alarms, I believe that is consistent and allowed by OSHA standards.
Okay, so then to the operator, is that allowed under OSHA standards?
So I can jump in and talk a little bit about what we do on location. For any large truck traffic, trailers or tankers, things like that, even during the day, we do have backup spotters all the time for any backup operations. But from what we've found, and additionally with the third parties that we use, for safety reasons, they won't turn the backup beepers off on loaders and any trucks that do have them. Since we've put sound walls up around locations though, and honestly, our stakeholder relation team, they can jump in if they need to, but backup beepers haven't been a source of complaint in our operations. So we haven't seen that as something that would give a big benefit to turn them off, but it would create a huge safety risk. And so from our standpoint, I think it'd be a bad idea to do that with the amount of activity that is on location, and especially at night. I just don't feel it would be safe to turn those off. And like I said, a lot of our third parties won't do it for us.
Thank you.
Commissioners, I want to sort of throw out here that it's been 2 hours since we came back. Are we feel close to getting done with questions, then we can keep going, or do we want to take 10 minutes? I also would like to take a few minutes and go through all of my notes before we close Q&A. So I would suggest we take 10, go through our notes, summarize our final questions, and then come back. Is that okay? All right, let's do that. Let's come back at 2:43. All right, commissioners, we're back. It's 2:42. Can the rest of the parties re-present themselves, show back up on video, and we will see what further questions there may be from commissioners. Commissioner Messner, I think you have the floor if you have questions.
Thank you, Mr. Chair. Yeah, I do have a couple. I think we heard testimony and public comment mostly. A discussion on some of the BMPs that were incorporated 4 or 5 years ago by extraction into some of the oil and gas locations in Broomfield. And the public comment at least indicated that they were different BMPs than Mcgee is suggesting in this particular location. I think some of the public comments indicated that what Mcgee is suggesting is potentially less protective than some of the BMPs that were utilized in the operator agreement with extraction in Broomfield. I'm going to give Mcgee just an opportunity to comment on what's being proposed in this particular location by this particular operator versus what is being utilized or had been promoted as kind of best in class BMPs associated with the extraction site in Broomfield 4 years ago.
Thank you, Commissioner Messner. I'm going to let Mcgee also have an opportunity to respond. I think this is going to hit at some of your question because I believe electric drilling rigs were, part of this discussion on enhanced BMPs, and I do have authority to represent that that Mcgee has approved 3 COAs to be added to this OGDP if that will get to the finding of substantial equivalence. We already talked about the Group 3 drilling mud. We also have approval on using an electric drilling rig. There was a long discussion, and again, we've got a lot of data on natural gas versus electric, but that has been approved. And then also piping the produced water. We are confident on acquiring that right of way and actively working on that. Also the camel, Mcgee has agreed to utilize that camel that Commissioner Hackett was discussing, however, would prefer CDPHE to do that outreach to those residents. So I'm sort of doing this on the fly, but did want to relay that we are taking in feedback actively right now and willing to have a discussion of COAs on this OGDP. And to Commissioner Messner, I know you asked specifics on the Broomfield BMPs, so I may let somebody else from Mcgee take that specific question.
Thank you for the question, Commissioner Messner. Can you be specific in what BMPs you're referring to? Off the top of my head, I don't have that agreement in front of me, but I know electric rigs was one of the topics which we just addressed, but anything else?
I don't have the operator agreement in front of me either. I'm responding to public comment that was provided this morning on this particular topic and indicating that the operator agreement associated with extraction was at that time considered potentially best in class as far as BMPs, and some concern that Mcgee's proposal didn't meet or exceed that. I'm not making a judgment on that. I'm just offering you the opportunity to comment. If you're uncomfortable commenting, you can say that as well. But I think that there were some things incorporated in the operator agreement with Broomfield that that were suggested by CDPHE in their recommendation as well.
Yeah, this time I don't feel comfortable commenting on what Broomfield had in their agreement, but if anyone else, Kelsey, I don't know if you have anything on that either.
Thank you, Shay. I agree. I mean, I think right now we're responding directly to the CDPHE recommendations. I feel confident that the BMPs that Mcgee is proposing in the Longs Peak OGDP are using the most up-to-date technology and standards in addition to the COAs we discussed and are currently discussing here. So maybe I'll leave it at that for now. If I may, just want to clarify one of the points on use of the camel, just to make sure I'm expressing this point from Mcgee correctly, is that Mcgee will agree to provide all costs associated with that camel. They just want CDPHE to select the location and work with the homeowner.
Thank you for that. Perhaps my last question. So I think as part of your proposal, you're indicating a potential way of addressing cumulative impacts to plug and abandon. And I'm not looking at it right now, but I believe 39 wells and some associated facilities. How much of that is done due to communication with existing operations or proposed operations by this application with the existing wells potentially communicating with the proposed horizontal wells? And how much of that is separate from the proposal?
Corey, can you help answer that question, please?
Yeah, sorry, I'm just trying to get my video back up, and I didn't introduce myself before. I'm Corey Altenberg, the completions manager for Oxy. We work very closely with a regulatory group and well services group to ensure that any associated COAs are prepped appropriately if they're not going to be plugged and abandoned, and then also with our well service group to make sure that the appropriate or any request, any requests have been performed prior to commencing with frac operations. So I think regardless of whether, the wells are plugged or not, we still prep them very high standard and don't commence operations until they satisfy Oxy standards and meet state regulations.
Yeah, I apologize, Mr. Altenberg. I maybe wasn't clear with my question. So I think that one of the mitigation measures that you're proposing in your application is that you're going to plug and abandon some number of wells and decommission some number of facilities. And you've indicated in your testimony and in your application that that is that could be considered an offset to cumulative impacts. My question to you is, was that something you were going to do anyway because these wells potentially interfere with the new operations that are being proposed in this application, or are they separate wells and facilities from this particular application?
I'll let someone else comment on that. I thought your question was specifically addressing frac communication from to the offset wells.
Yeah, so I can step in here. Thank you for the question, Commissioner Messner. So the 39 wells and 10 facilities that we did identify will be prioritized to be plugged and abandoned, but to answer your question, yes, they will eventually be plugged. It's just a matter of prioritizing them. And we do our best to prioritize plugging them prior to completions, which I think you saw in the presentation was in March of 2023 for both pads.
And Shay,
for that. I'm going to take one more shot at this because I'm not getting the answer that I think I'm asking the question for, but it's perhaps because I'm not answering the question correctly. So as part of drilling, a new array of horizontal wells, there's potential vertical wells that are in the way that have the possibility of communicating, or perhaps they're just nuisances or liabilities in the drilling and spacing unit, and operators often come in and plug and abandon, reclamate and remediate those sites as part of a new horizontal drilling application. I think what Kerr Mcgee is suggesting in this particular application is that they're going to plug and abandon 39 wells and 10 facilities as part of this particular application. My question is are these 39 wells directly in this drilling and spacing unit and would have been done anyway because they could potentially communicate, or are liabilities associated for this drilling and spacing unit and new operations that are occurring here, or are these locations offsite other places? That's my last attempt at that one. Yeah,
I can jump in here. So some of them, absolutely, we are plugging them for offset frac activity, but that is not all of them. We are choosing to plug the others. As you all know, we have a very aggressive P&A program right now, making sure that we're plugging all the wells that we can and that are not economic or that we've already moved in with horizontal development. So while some of them will be P&A'd for, that's specifically for offset frac, that is not all of them. We are voluntarily choosing to plug others.
okay, thank you. That was the answer I was looking for. Thanks.
Third time's turn, Commissioner Messner. Commissioner Hackett.
Thank you, Chair Robbins. And I didn't quite catch the whole discussion about electric drill rigs. Did you all say that you've agreed to use electric drill rigs? And if so, is that going to be an enforceable permit condition?
That's what I heard them say.
That's correct, Commissioner Hackett, Chair Robbins.
Thank you for that.
Commissioner Nanjapa.
Thank you, Mr. Chair. And thank you all. Just a couple more quick questions. I was curious, and I appreciated the comment. One of the public commenters, I think it was Ms. Escalante, mentioned about the 2013 floods and how this area was inundated at that time. And understanding that, you know, generally those types of floods are not expected with frequency, I would suggest that probably they're going to happen more frequently. And I'm curious what kind of, I didn't really notice, other than kind of general rain events in your stormwater management plan, I didn't notice anything to address kind of a large flood event. And I'm curious what you would do in that instance, or what your plan is, if any.
Thank you for the question. Joseph, can you address that one, please?
Just environmental specialist with Oxy. So first off, the McGavin location has been located outside the 100-year floodplain, as recently mapped by FEMA, I believe in 2020. Shay or someone on the call, please feel free to correct me if I'm wrong there. As far as large stormwater events on our location, we will comply with all our CDPHE area permits and the SPCC regulations for managing stormwater discharge from our locations.
And sorry, Mr. Reamer, you kind of broke up just at the last part there. I wonder, could you just repeat that last part about major flood events?
Yes, sorry, Commissioner Najapa. We will comply with all our CDPHE area permits for our stormwater discharge requirements as it relates to large rain events.
Thank you. And then I'm having visited your IOC, I'm assuming that if there was a threat to the facility with rising floodwaters, for example, there are measures to be able to shut in the wells. Is that correct?
Absolutely. We have remote capabilities for all our facilities. So we can monitor that, and that's something we can do remotely without even having to go to the site. We also have 24/7 ops out in the field. So we have night operators, day operators. So if there is something that came up, we would also be able to deploy people to that facility.
And what about the storage tanks in the off chance that there is a major event like that, again, where it goes beyond the 100-year floodplain and is threatening the pad location?
The storage tanks meet all of the stormwater requirements after the 2013 floods. So we're in compliance with all of those. They'll have the necessary containment, anchoring, all of that. Anything that's required for the regulations.
Okay, thank you so much. Just a couple last questions. So when I was asking about the accessibility of the minerals, and there was mention that if the McGavin pad was moved, that a lot fewer of the targeted minerals will be able to be accessed, but they're currently less than 100%. However, if the Columbine pad was moved, there would be a loss. It would be 100% inaccessible, I think is what Mr. Honus, you said. What I wanted to understand, is that just simply due to the surface ownership of where you currently have available to drill, or are there other locations where those minerals could be accessed?
I can clarify some of that. So after I looked and kind of thought about your question a little bit more, I think it's probably location 6 as an alternate location that you may be thinking of the most. If you were to try to move to location 6 and eliminate the McGavin pad, you would lose at a minimum at least 2 1/4 sections probably a little bit more than that of acreage that you just couldn't access from that location. Location 6 is the one to the east of the golf course, basically. And that's probably the only location that really has any even remote potential viability. But like I said, you'd be losing section 12, section 7, section 13, section 18, and the quarter in section 36 for a total of at least 2.5 acres that you wouldn't be able to get to from that location. Does that help? Did I catch your question right and answer?
Yes,
that?
I think so. And knowing that those are the locations you specifically looked at, are there potentially other locations outside of what you already looked at for an ALA where either more minerals can be accessed, or
the other locations either add more occupied buildings or are too far of a step out to even make it able to get hardly any of the minerals. So even if you went to location 6 and then you added some of the other locations, it would not be a net benefit. You'd still lose lots and lots of minerals, and some of the locations that are viable, especially to the north, you'd be adding occupied buildings compared to McGavin.
Okay.
Commissioner McGowan.
Thank you, Mr. Chair. So I'm just going to finish running through the requested conditions of approval in the CDPHE consultation letter. I think we have not covered vapor recovery units, which I think Mcgee did not agree to, but said that it wasn't actually clear that it was necessary to put in VRUs. I'm wondering if you could talk about that a little bit more.
Absolutely. So with our old design, what the facilities you see VRUs on are typically lower pressure sites, and you'll see them attached to VRTs, so those really tall towers. You see them sometimes attached to a tank, but those are attached to oil tanks, and those are tanks with a lot of vapor, that there's a lot of vapor, there's a lot of off-gassing from the oil to actually capture that and put it down a pipeline. Our design is all high pressure, so we're keeping all of our vessels at high pressure, so there's a VRU is not necessary. We really have nothing to attach it to because all of our gas is kept at high pressure, whereas other producers in the basin, you'll see them drop the pressure of each vessel down to maybe 10 to 15 PSI. And when you drop it that low, you can't get the gas in the pipeline. So you have to set a compressor to get it in the pipeline. Our vessels are never dropped that low because we work with Western Midstream and they have a central oil stabilization facility. So we send high pressure oil down a pipeline, removing the need for a VRU. The VRUs you see attached to tanks, those are to oil tanks again. I haven't in this basin seen somebody attach that to a water tank. There's just not a lot of entrained gas in your water by the time it gets to that tank. And as you guys said earlier, there's just not a lot of emissions associated with that water. So there's not an opportunity there. So it's because of our design that VRUs are they're very much so not necessary.
Thank you. I think number 4, shutting in the location if pipeline doesn't become available, which I think you all said wouldn't be necessary anyway because we don't allow flaring of any kind. So I think shutting the pipeline down would require flaring. So either way that we go, it looks to me like that might be covered. You can just shake yes or no, or if I'm misunderstanding.
That's correct. Yeah,
okay.
We currently on our sites when we don't have takeaway, we shut in. So that will continue to be a practice at this pad.
You've agreed to the enhanced notification. Looks like we've agreed to support the camel and supplying it some sort of power source. And the odor mitigation, it looks like you're open to a condition of approval to the 0 VOC mud, which makes number 8, chilling the mud, unnecessary. Stop me if I'm wrong, okay? You agreed to covering the trucks with the drill cuttings. It sounds like enclosing the shale shaker as a safety issue. Looks like you all are agreeable to participating in the ozone mitigation measures on ozone days. You all have said that the COA to not have PFAS and fracking fluid is not necessary because you don't use them. And then the last one is the signal person at night, which I'm understanding is a safety issue. Just want to make sure I've covered them all. Okay.
Commissioner McGowan, I'm sorry.
Yes.
I wanted to just clarify, as we're running through the CDPHE recommendations, I wanted to just take a moment on the electric rigs. Mcgee is still actively discussing United Power's capability for the Columbine site. So while we can commit to adding a COA on the use of an electric rig for McGavin, at this point, we're unable to make that commitment on Columbine based on United Power's capabilities. Still sort of a work in progress.
Okay.
Ms. Linky, can I ask a follow-up on that?
Yes.
They're not that far apart, are they?
I would need to confer with the team here on the exact
Can you jump in,
distance.
Kelsey?
Thank you.
We've been very committed to the natural gas drilling rig. And so we haven't looked on with United Power and kind of paid them to do the engineering study on these. When we got the CDPHE's recommendations, we dove into getting with United Power as quickly as we could. We tried to figure out what we could do. McGavin, we have confirmed and gotten feedback from United that we can get power to McGavin. We haven't gotten info back yet on Columbine from United Power. And we kind of end up a little bit at their mercy, kind of waiting for them to do their engineering study and then give us the feedback back. They are close together. There's probably a good chance, but you just never know the way the grid's set up.
Okay, thanks for that clarification.
If I may, I'm sorry.
Go ahead. I was going
Thank
to
you.
recognize Commissioner McGowan again, but if you want to follow up.
Thank you, Chair Robbins. I just wanted to follow up that the CDPHE consultation was directed at the McGavin location, not the Columbine location.
Okay, thank you. Commissioner McGowan.
I feel like this is probably my last question. Did you all say that you had reached out to talk to CDPHE about its consultation letter, but you all haven't had a chance to confer yet on this location?
We did have a meeting with the CDPHE and kind of talked all through their recommendations. I think they saw a lot of where we were coming from, but I think some of their recommendations they still held strong to. And I'm sure Sean would be willing to jump in and kind of share some of that info with you if you ask him.
Yeah, I mean, I think I would definitely like CDPHE's thoughts about, now that we've run through some of this and where we're at, where CDPHE is at. I would definitely be curious to know and would like some feedback.
Thank you, Commissioner. Oh, thank you, Commissioner McGowan and Chair Robbins. And this is definitely a rapidly evolving situation, so kind of some new information here. And just to kind of state where CDPHE is at with this, after reviewing the Mcgee response to the consultation, the director's recommendation, listening to today's testimony, as well as the additional protective measures Mcgee has agreed to today, we honestly do still have concerns about potential impacts, given the sheer number of people nearby, as well as the fact that they'll be surrounding the pad to the north, west, and east, and probably to the south too, if they're using the nearby golf courses and the trail. So, and frankly, we will always have concerns over drilling proposals in dense residential areas. During the mission change rulemaking, COGCC's decision to adopt the setbacks and siting requirements in Rule 604, the statement of basis and purpose noted that the body of peer-reviewed scientific literature documenting potential health impacts that are likely attributable to proximity to oil and gas development is robust and growing. So in light of those potential impacts, anytime there's a well pad proposed within 2,000 feet of a home, that's going to raise alarm bells for CDPHE. The more people that you have surrounding the pad, the louder CDPHE's alarm bells will be, because it increases the potential for them to experience worst case conditions, not just from air emissions, but from all of the other cumulative and combined impacts that they may be exposed to. And so here for McGavin, Mcgee has proposed a relatively clean facility, and to their credit, I appreciate their openness to these additional measures. They have a robust stakeholder engagement process. They were one of the early adopters of air monitoring. And I also appreciate how open Mcgee staff has been to discussing their facility designs with us. However, what they've proposed, I don't know that that is the cleanest facility that's possible. For example, it is encouraging today to hear that they've committed to using Group 3 muds, but they are not committing to use a chiller to cool drilling fluid as it's piped through the recirculation system before routing it to the suction tanks. And for comparison, the Crestone Lone Tree North facility that we may take up later today, they're using both Group 3 muds and a chiller. And again, while this is a tankless facility in that it doesn't have storage tanks on sites, CDPHE remains concerned about the produced water storage on site and the potential truck traffic that may result from that. At this point, it sounds like they intend to transport produced water via a pipeline, and they're making efforts to do so. But as I understand it, as of right now, there's no guarantee that that's absolutely going to happen. So, CDPHE's position is that when there is such a large number of people within 2,000 feet, then there's a higher potential for adverse impacts, not just from air emissions, but other cumulative impacts. And in order to minimize those impacts, the most protective measures are necessary and reasonable. And one thing to keep in mind, I think we've heard some pretty compelling testimony today from public commenters encouraging the commission to take an even more protective approach and saying that CDPHE's recommendations don't go far enough. So, just wanted to put that out there. And then also just say, with all of that being said, a guiding principle for CDPHE's approach to consultations pursuant to Rule 309F is that our role is limited to making recommendations for COGCC staff and commissioners to consider. And because COGCC is ultimately responsible for creating, administering, and enforcing the rules governing oil and gas operations under the Oil and Gas Conservation Act and the emission change rules, you ultimately determine how these rules are applied, and based on your interpretation of your statutory and regulatory authority. So while we do still have concerns, we're mindful of the fact that COGCC is tasked with making the ultimate decision. So wanted to provide that comment.
Thank you, Commissioner Hackett. If I could follow up with Ms. Wozlinski, I thought I heard a commitment for a COA that the water would be piped.
That's right, Chair Robbins. I think Mcgee would be willing to add a COA that the water would be piped.
Okay, so that the water would not be placed into tanks and then trucked off the facility. Is
Correct.
that right?
That's correct.
Okay, and so Commissioner Hackett, just to follow up with you then just ever so briefly, it appears to me that from the 13 conditions of approval that you had advocated for, the only ones that have not been dealt with are the backup and noise, the vapor, which they say is unsafe, the vapor recovery because it's not needed, and then the chiller. I just want to make sure we're all on the same page. And I still understand your perspective. I'm just trying to get a sense of what was asked for and where we're at. You're right. This is, changing fairly quickly.
Thank you, Chair Robbins. I think you've captured that accurately.
Okay. Commissioner Messner, you had raised your hand.
Thank you, Mr. Chair. Just a, I guess a question, point of order question. And I'm not sure where we're at in the deliberation process and or whether we're getting close to shifting to deliberations, but I will let you know or let the commission know that while I had maybe this commissioner's belief that the application as presented currently may not meet the requirements associated with 604B. I think there's been enough dialogue going on right here that potentially changes the application. So I'm concerned that at this point, this application isn't necessarily ripe for decision making. I think it's probably inappropriate for this commission to throw a ton of COAs on there because the applicant ultimately has the burden of proof in this particular situation to present an application that meets the standards associated with the act and our rules. And so I think, I guess at some point here, I'm going to be a little bit uncomfortable with this commission, or at least this commissioner, trying to place conditions of approval on something that ultimately the applicant has the burden of proof to address. And so while I would consider a continuance of this particular hearing to allow the operator to actually modify their application and present something that is complete and ripe for review, I'm not sure we're there right now.
Spoken like a true former county commissioner. Thank you, Commissioner Messner. I would tend to, so I'm happy to sort of follow that with my thoughts, but I don't want to truncate if there's any additional questions from commissioners, because I think we are kind of morphing into a deliberative stage. So before I follow with my thoughts, Commissioner Messner, are there other particular questions from commissioners for the applicant? Okay, I'm not seeing any. Commissioner Messner, I tend to agree with your thought. Under Rule 307, we have an opportunity to approve, to deny, or to stay an application for further consideration. And I believe that staying this and giving direction to the applicant as well as staff to, I'd rather it not be COAs, I'd rather be BMPs that the applicant proposes. And they should be drafted in concert with staff and then brought back to us for consideration. I also came into this hearing with a legitimate concern about the, as Commissioner Hackett pointed out, the sheer number of residential building units, in particular with regard to McGavin, that are within 2,000 feet. And I had questioned earlier, and I think Commissioner McGowan had done this as well, and perhaps a little bit from Commissioner Nanjapa, of really refocusing the alternative location analysis on looking for locations. So a couple of different things. One is, this is a very, very large location near people. And I wondered if, from an alternate location analysis, a couple of smaller locations that still got to the mineral estate, or that got to some of the mineral estate, perhaps stranding some of the mineral estate, would be appropriate for us to see. And then that sort of gets to that other component of it, is there are a couple of locations that have been identified that have other problems, such as wetlands, coal subsidence. And I'm wondering about the balancing of those issues and engineering around that versus being as close to people. So those are sort of my thoughts about, kind of where we were in this process today. I was considering a motion to stay, not to approve or deny, and to allow the applicant the opportunity to peer around the corners on those sorts of topics. I think at a minimum, I would be comfortable with a motion to stay, to allow the applicant and staff to come up with BMPs as the applicant has agreed to consider today. So those are my sort of initial thoughts as to where we might be. Other commissioners with thoughts? Commissioner Nanjapa?
Thank you, Mr. Chair, and Commissioner Messner as well for those thoughts. I understand some of the concerns that are being raised, and agree to a certain extent that it feels like we're now changing the application in a lot of ways. However, I think based on some of the questions that we all have asked, to me, it feels as though there aren't as many options with the McGavin location that would reduce receptors and other concerns, but perhaps for the Columbine location. And so I'm not sure from this commissioner's perspective that it makes sense to stay the whole thing. And I'd be curious if folks would be, I appreciate also the considerations that have been brought forward by Karen Mcgee about, certain COAs that they'd be willing to address. But I think I still agree with what you noted, that the largest location is near the largest number of receptors. And from what I heard, it doesn't seem that there is a better location for that particular pad, but perhaps there may be other locations for the Columbine pad that could potentially reduce the number of receptors, although may not access all of the minerals. And I guess from this commissioner's perspective, I would be more concerned about the overall location than I am about the total targeted minerals that are able to be accessed.
Commissioner Gonzalez.
Thank you, Chair. Thank you, Commissioner Nanjapa, Commissioner Messner. You know, I don't disagree with the option to issue a stay at this point. I don't see this as a new application, right? I see the application as pretty much the same as the way we've seen it in terms of the OGDP in general. I think what we're talking about here are some COAs that have developed and perhaps have been agreed to here in our discussions. And I think it's probably a good idea for staff and the operator to make sure that there is a complete understanding of what those COAs are and will be, and how they will be implemented and how they will be documented. And so, you know, I'm comfortable with issuing a stay. I'm comfortable with participating in deliberations otherwise. So I wanted to kind of throw that out there. You know, in regards to 604B4 and the way we consider it, specific to the McGavin pad is one of the things that I'm looking at, is that there's no magic number or threshold as to the number of receptors that trigger the importance of a substantially equivalent determination. And I do agree with the concept that what's protective of one owner nearby is protective of every owner nearby. I think what we've heard here is the operator come up with a number of operational practices that are far beyond what's required in the rules. And I think that this leaves us with the potential for a future deliberation, if it doesn't occur today, on what this substantially equivalent tether is, right? What are we saying is substantially equivalent to? Is it substantially equivalent to the COAs and the protections that are being asked for by CDPHE in their consultation? Is it substantially equivalent to an offsetting or an alternative operation that is 2,000 feet and 1 inch away, that is the bare minimum of the rules that we put in place? I think that's going to be open for discussion when we start applying 604B4 in this deliberation or others. So that's kind of just setting the stage for where I think this conversation is going and where my mind is. But for where we're at right now, I am comfortable with issuing a stay for the operator and staff to dial in these COAs that have been agreed to here, along with the other COAs and BMPs that have been applied in the application itself. So just kind of a long rambling way of me saying that I agree with your position, Chair, and I'd like to set the stage for where these deliberations go as a next step when we do, if we hear back from this operator in a second iteration of this.
Thank you, Commissioner Gonzalez. Others with thoughts? Commissioner McGowan.
Thank you, Mr. Chair. And so I think I'm comfortable, you know, with a stay as well. I really would like to see the operator see if there is an alternative location for that McGavin site. Let me just start with, I'm super appreciative of the fact that the operator is responding to CDPHE's consultation letter and what they've requested. And personally, I'm a little frustrated that there has been a type of response from the operator, but now the response from the department, our sister agency, is no matter what you do, this is not safe. And if that's the case, the consultation letter needs to be, this is within this many receptors, it's not okay from a public health and safety perspective. So that, I mean, me as a commissioner, I guess I was trying to figure out, like, how do we get the operator to meet these conditions that were put forth by our sister agency, but over concerns for health and environment. And so I'm a little frustrated right now. And I feel like there's potentially a no-win situation here. That being said, this is close to a lot of people, and I really want to know if there's an alternative location, even if it leaves some minerals stranded. And I do think that that's allowed under Senate Bill 181 and under the rules. So I guess I'm okay with the stay. And I think I would like more conversation with the operator and CDPHE about what's going on with these consultations, or maybe with us, and what these consultations ultimately mean or don't mean. If what our sister agency is saying is this location as presented is not safe, then I'm in a situation where I would feel like I need to honor what they're saying and their expertise. So sorry, once again, I'm the wishy-washy commissioner all over the place. But for right now, I think I need to stay. I'm not prepared to vote on anything today.
Thank you, Commissioner McGowan. And I think that second to last point about CDPHE and COGCC, and you mentioned CDPHE and the operator need to have some discussions. I frankly think it's us and CDPHE that need to have some discussions, because I echo somewhat the frustrations that are existent. But I do think that we've now heard from at least two commissioners, myself and Commissioner McGowan, that we would like this stay to not only accommodate a discussion of the points into BMPs with staff, but also I think there's at least two of us that would like additional information around how it is that the McGavin is the only location that is workable. And that discussion should also come back to us with some thought about mineral estate development, mineral estate non-development, that alternative 3 location, which has other issues. And there was a point that it would not allow for full mineral estate development. Well, I'd like to know what the percentage is. So I still would like to have that, at least myself, if we're going to do a stay, let's accommodate that issue as well, so that we are fully informed on all aspects of the ALA when we reconvene to have final discussion about this. And I look to my other 3 commissioners to see if you're comfortable with that as a component of the stay. And I saw Commissioner Messner first, and then Commissioner Nanjaka.
Thank you, Mr. Chair. I would agree with you. I think that, I mean, I'm not convinced based on testimony, discussion, and information provided that all considerations have been given in an alternative location analysis. Again, I'm a strong believer that the applicant has the burden of proof, and if the applicant would like this commission to make a decision based on the application that's presented, then I will do that. I think that the McGavin, well, I think both locations have potential issues and potential problems with being able to comply with 604B. I appreciate that the applicant is considering BMPs. I think those need to be fully fleshed out. I noticed that in the application, a lot of the BMPs will do the best that we can, or we'll try to do this. For me, BMPs, I need to say we will and shall, and time certains and things like that. And so for me, in reviewing applications, these are really important to me. And the consideration of we'll do the best we can is not good enough. And so so I agree with Chairman Robbins that that certainly further analysis on ALA to ensure that the applicant is presenting the application that they want us to make a decision on, and a location that they want us to make a decision on. And then consideration of not just the BMPs or COAs that were discussed today, but maybe reevaluate an approach to this and looking at BMPs. And because as I initially indicated, at this point, after these deliberations, it's my opinion that this application is not ripe for this commission review, and additional work needs to happen before we should be put in a position to make a decision on this unless the applicant wants us to make a decision on it, which at that point, I'm happy to make a decision on that today. So a stay is fine with me, or if the applicant wants to propel us to make a decision today, I'm happy to do that.
Commissioner Nanjapa, you had raised your hand.
Thank you, Mr. Chair. No, I agree and believe I also stated that I think an additional consideration of alternate locations, regardless of the proportion of the mineral estate that can be accessed. And I totally agree with you. I'd like to know what that proportion would be in different scenarios. As I understand it, the areas that are being contemplated right now are due to Mcgee having surface ownership and being able to access those minerals from the surface. But I, would like to see some additional locations that are analyzed that take both, that are apart from Mcgee ownership, as well as, considering a smaller proportion of the mineral estate being accessed. One thing I've said in the past is that one thing about the industry is that it's innovative. And so if there are minerals that are not accessed with a different location, I'm sure that at some point in the future, technology will arrive that will allow for that. And so I feel pretty confident about that. And so I think that we need to really think about this from the perspective of how we can minimize impacts to the receptors. I totally agree with Commissioner Messner's comments on BMPs not being, we'll try, but more we will. So I appreciate those comments as well. And the other thing I just wanted to kind of kick this out in the questions, but would like Mcgee to consider is modifying the drilling and spacing unit potentially to address, some of these considerations, and especially if an alternate location is proposed. But I agree again with the other comments of other commissioners and Commissioner Messner in particular, that I feel that right now we're not really in a good position to evaluate this application. Though I also would, if Mcgee would like us to vote, I will vote.
Commissioner Gonzalez.
Thank you, Chair. I don't have any objections to adding into our stay a request of additional looks at the alternative location analysis. Now, it seems to me, based on the director's recommendation, the information provided by Mcgee, is that this is, at least at this blush, is the best location out there. Now, I am all for finding that best location out there, and if there is another alternative location that does work better, that's our goal, is to get to that spot, right? We want to make sure that we are approving and permitting the least impactful locations as best we can. One thing I would add to that, since we are going down that road now, is that there were several alternative locations that noted the need for additional pads, and I think Chair Robbins alluded to this a little bit in his comments. I'd like to know what the total footprint and impact for what the alternative looks like with more pads, if that's part of that alternative location analysis. And I think he mentioned alternative location number 3, and that's one that stood out in my mind in my review of the materials as well. I think it suggested that an additional 2 locations would be needed to access the minerals. I'd like to know where those locations would be, how big they're going to be, what kind of traffic and impact and proximity to receptors will exist there. And then we have a more of a side-by-side comparison to really understand if this proposed location, as we've heard it today, is or is not the best alternative. So I'd like to add a little bit of that color to your request, Chair Robbins, then just generally give my support to a second look. That sounds like the way we're going, and I don't think there's anything wrong with that.
Thank you, Commissioner Gonzalez, and I appreciate all the additional color you added to the direction that we were presenting. I also would note that I don't think we're articulating an undoable ask here, or that it should take an extreme amount of time. I have a feeling that since they've been working on this since 2015, that this information is out there, and so getting it back to us is something that I think we would like to see. I would like to call upon Ms. Wazelinski. You've heard a lot from us. Are you getting clear direction about the direction we'd like to see? Do you have any questions of us? And is your client in favor of this direction as opposed to what I think all of us are also saying is that we could take a vote today if you want us to take a vote?
Thank you, Chair Robbins, and thank you to the commissioners. We really do appreciate the dialogue today. I know it's been a long day on this ODDP, and Mcgee did work very hard to put a protective plan together that meets and exceeds the rule requirements to respond to the CDPHE recommendations. And so with that, Mcgee does agree to continue this and discuss BMPs, discuss ALA, respond to the questions that have been raised today. We've all been taking notes, and I think Mcgee is willing to continue those conversations. I think really the only question on my end would be some certainty around when we come back to you. I agree, Chair Robbins, that I don't think this will take too much time to put this together and work through some BMP and ALA analysis. So I would just respectfully request that perhaps we think about coming back at a date certain. I know you're heading into more financial assurance rulemaking and have a lot on your plates, but I would just ask that we, consider a date that's not too far ahead in the future.
I think commissioners would probably be fine to consider whatever date you want to propose. It's
Great.
really, the work is on, the homework's on you and your client. So if you want to huddle for a minute or two and get a sense of timing with your client, we can take a quick break and then we can get back together. Or if you have a date in mind, throw it out there.
Sure. I think I could say 2 weeks. I'm getting some conferral from Mcgee right now that 2 weeks we think is reasonable to come back to you. I haven't looked at the agenda to see what's happening 2 weeks from today, but I think we can get the information together and have a good dialogue between now and 2 weeks from now.
Okay. I guess I also want to be clear to our staff or to the staff of the Colorado Oil and Gas Commission that at least from this commissioner's perspective, this is not requesting you to, redo this permit or otherwise sort of like go back through all of it from my perspective. I think the direction is we would love to lean on staff's expertise on the implementation of BMP language. And that is around the electrification, the piping, and the tier 3 MUDs. I think I've got that right. But it's what I think the commission is suggesting to Mcgee is you guys need to be responsive to the discussions we've had, the direction we've given on the ALA. And I don't know that I necessarily need staff to spend a lot of time reanalyzing the ALA, et cetera. I think this is, at this point, it's become a discussion between the commission and Mcgee with staff in a support role. So that's just me talking, and we're talking out loud because we've never done this before. But I did not want there to be the perception from staff that this is a ton of additional go back redo work on their part. Director Murphy, thank you for showing up. Do you have any comments about my comments?
It's helpful. I think given a couple of things, given the robust nature of the dialogue around both Mcgee's commitments and the asks from commissioners, it would be great to get a recitation of what's on the table so that everybody leaves this meeting with the same expectations, starting with me, because I think I even got, I know I got lost in them. So that would be one ask. The second one is, given that it's a pretty short timeline, this is incredibly important to get finished and decided. I think that staff's happy to kind of take a look at and provide comments back and on BMPs and then move it forward. But there isn't going to be a time for, a huge lengthy dialogue about different components. And so we would want to keep that very, very focused and recognizing that we have a number of other OGDPs coming up that we're also trying to get out the door kind of simultaneously. So I think with those two clarifications and understanding that I think we can take a look at the ALA, but to some degree, whether it achieves your objectives is going to be within the commission's purview more than staff's.
That's why I made those statements, is that I think the staff has done its work, and I think the direction to Mcgee about the additional information around the alternative location analysis is, that's homework for Mcgee, and they'll bring it back to us. Certainly would love it if staff wanted to, think about it, but there's not a requirement to go back through sort of that robust analysis that you've already done. Understood? Does that make sense?
That does, thank you. And that's right.
Just with regard to the specifics on what I think we are asking is that we've received a commitment from Mcgee that they would have conditions of approval, which we have decided we would rather them see as BMPs. And the distinction there is a BMP is something that they put together and present to us as an enforceable part of the permit, as opposed to a condition of approval is something we are putting on the approved permit. And so that is, again, around the electrification, the piping of the water, and the tier 3 mud. And I'm now looking for other commissioners if they want to provide additional guidance. Commissioner Messner.
Thank you, Mr. Chair. I think it's important for us to understand as a commission that, again, the operator has the burden of proof, the applicant has the burden of proof. And so while we can say that certainly the considerations that were brought forward today by Mcgee could potentially be included in a revised application, I think, again, the applicant needs to be able to interpret the discussion and deliberations that have occurred today and revise their application to the best of their ability in order to do what they think they need to do to meet the obligations put forward in 604B. And so while certainly a lot of COAs and BMPs were discussed today, I'm not willing to limit it to that, nor am I willing to provide a list to the applicant of exactly what they need to do, because the burden of proof is on the applicant.
Good point, Commissioner Messner. Commissioner Gonzalez.
Yeah, Chair, thank you. Just a fourth thing to add to your list that was memorialized in this conversation is Mcgee's commitment to funding the Camel electrification, assuming that CDPHE does the legwork on securing the location for it and working with that homeowner or landowner.
Good point. Thank you, Commissioner Gonzalez. And let me clarify just for the 244 people that are listening in. The BMP COA. BMP is a best management practice. And traditionally, those are developed and tendered to us by the operator. And it's an enforceable condition. A condition of approval is something that we develop up at staff or amongst ourselves, and it also is enforceable, but both are equally enforceable. We're just suggesting that because we've got agreement, let's make them all be BMPs, which means that staff and the operator are going to work together. So hopefully that clarifies that point. Commissioner Nanjapa, did you have your hand raised? No. Okay. All right. Any further discussion? Oh, yes, you did. Okay, go ahead.
I just had another thought, process question more than anything. When this would come back to us, would the public have another opportunity to comment on revised documents, or how would that work? Do we just, at this point, is it just, as you kind of said, between us and the operator?
My preference would be that it's between us and the operator. I think what we've done here today in the discussion, et cetera, is listen to the public and had a robust discussion with the operator that potentially, could bring back something for further evaluation by commissioners. But I'm just one vote, and I would listen to my fellow commissioners if they had other thoughts. Commissioner Messner.
Thank you, Mr. Chair. Because this is a revised application, I would recommend that we allow for public comment on the next revision, limiting the public comments specifically to the application and the deliberations that will have to happen. But I think there are potentially enough changes incorporated with the application that I think it's fair to give the public an opportunity to comment.
And Commissioner Messner, your would put parameters that the public comment would be as to the changes in the application?
Correct. Yeah, I mean, I think we've heard their comments associated with the existing application. And so there's potentially some elements of the existing application that would remain, although I don't know ultimately what we'll see in a revised application. But if that's the case, I think I would focus those public comments on revisions. And although, I mean, I'm not super hung up on whether or not to limit it. I mean, there's 3 minutes of public comment, and I think we can anticipate that there'll be public comment on a revised application.
Okay. Commissioner McGowan.
Thank you, Mr. Chair. I'm really not trying to kick the can down the road, but this commissioner probably needs some leeway time to read what gets submitted. And I think and we should invite the public to comment as well, especially those who might be affected by the revised application. We've kind of tried to set a rule that we give people a week ahead of time to read what's put before the commission. So I don't know if we want to move this conversation out to week 3 and the operator submits something in 2 weeks, or if the operator wants to submit something within a week and then there's a week for people to read. And so I just want to put that out there. I think that we need to give people time to digest and read and be able to give comments back.
I appreciate that point, Commissioner McGowan, and I would like to call upon Hearings Manager Larson, who is very good with all things dates and times and scheduling. You heard the throw out of 2 weeks. Now there's a third week. If, in particular, if we're going to be doing either limited or full-on public comment, that sort of expands the scope of the hearing. Do you have thoughts, Hearings Manager Larson, about the most appropriate date for this stay to?
I do, Mr. Chair. Recognizing that there appears to be the desire to allow public comment on this revised application, I would recommend either March 10th, that is a Thursday. We could set aside time on that day for this to be heard. Alternatively, we could also look at March the 24th.
I'd rather pick the earlier date, March 10th, if that's okay with everybody. And if Ms. Wazelinski, you and your client feel that that is acceptable.
Thank you. We'd certainly be available earlier, but March 10th, at least as of now, works for us.
Okay. Any further discussion? Okay, thank you all. Thank you to the public that was involved. Thank you to our staff that was involved in the review of this application. I believe at this time we are looking for a motion to stay further consideration of this docket number 210700114 until March, what'd you say, 10th at 9 a.m.
March the 10th at 9 a.m. Yes.
Mr. Chair.
Commissioner or AG Davenport.
Thank you. I just want to chime in to see if the commission has desire to include in the motion a deadline for Mcgee to actually submit the required information.
Fine with me. Commissioner Messner.
I will make the motion to stay the docket that you had indicated, Chairman Robbins, with the stay date of the next hearing to be March 10th at 9 a.m. with a submittal requirement by the applicant 1 week prior to that to allow for review prior to the hearing, which I believe would be March 3rd, if I'm not looking at a calendar.
Your math is correct. I'm looking at a calendar. We have a motion. Do we have a second?
Second.
We have a motion and a second. Do we have discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Very good. Okay, why don't we take 5 minutes and get the next OGDP up for consideration? And before we do that though, Hearings Manager Larson, can you reappear?
Yes.
Can you inform, what are we doing with the last two OGDPs that we may not get to late today? Or do you have ideas about that?
I do. I've reached out to counsel for Laramie and Vecta. They've also been monitoring the hearing and recognize that we are going far longer than we had anticipated. Laramie and Vecta are available on Thursday, the 24th. So that would be a week from tomorrow to come and have their OGDPs heard. They would need to have them heard in the morning due to conflicts that they have in the afternoon. So
February 24th.
Yes, apologies if I said March.
You did.
February
You just
24th.
said 24. I want to make sure. That's fine with me, and I appreciate that and appreciate the willingness of council to be flexible with us. So at the conclusion of the hearing today, we will move to continue those two matters to, or Davenport, can we do that right now? Can we just go ahead and move to continue those to Thursday, the 24th?
You can do that right now.
Okay, what time on the 24th?
That would be at 9 a.m.
Okay. Could we have a motion to continue the, hold on. Continue 2106-00096 and 2108-00138 to the 24th February at 9 a.m.
So moved. Second.
Motion and a second. All those in favor signify by saying aye.
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 Aye. Any opposed? Okay, so that has taken care of that. We now have on our agenda one last OGDP. It's 2104-00033 Crestone Peak Resources. And why don't we take a short break and get that dialed up so that we'll be ready for that. So let's come back at 4 o'clock. All right, welcome back, commissioners. We now will take up docket number 2104-00033, Crestone Peak Resources Operating LLC. I see we have Ms. Jost with us. Good morning or good afternoon. It's been a long day, apologies. And I also note that we would start this with City of Aurora comments. And I see that we have Jeffrey Moore available with us as well. Good to see you again, Mr. Moore. We will start with your public comment on this docket.
Very good. Thank you, Chair Robbins and Commissioners. Thank you for the opportunity to present comments to you this afternoon. Let me share my screen and I will begin. Let's see. It looks like I'm unable to share at the moment.
Wait, hold on. Let's get you shareable.
Very good. Thank you.
And just give us one moment, Mr. Moore. Ms. Amaro, I can keep time, so you don't need to worry about sharing your screen.
All right, very good. Thank you so much. My name is Jeffrey Moore. I am the manager of the Oil and Gas Division for the City of Aurora, and Aurora is the relevant local government for the Lone Tree North OGDP, which is under review today. My comments will be brief. I hope to provide some context for the discussion today, and I'll be available to answer any questions that you may have. First, my executive summary, which is to say that the Lone Tree North well site is fully permitted by the City of Aurora as of March 9th, 2021, and Crestone Peak Resources remains in full compliance with all regulations and best management practices specified in the operator agreement between the city and Crestone Peak Resources. I'll show you two maps here just to provide context. In this first base map, the city of Aurora is shown in the pale yellow. You can see I-70 there running east and west, and E-470 running north and south. The Lone Tree North well site is labeled with the arrow there in the center of the screen. And I'll zoom in on that location. On this map, the Lone Tree North location, which is phase 1 and 2, I'll describe that in just a moment, is in the middle with the blue. You'll see that it's accessed through an Arapahoe County Road, which is Hayesmount Road, that is shown in white at the top of the screen. And then from the end of Hayesmount Road, there is a private access road, which is shown in orange, which continues south for a half mile, accessing both the Prosper Farm site in Arapahoe County and the Lone Tree North site in the city of Aurora. Two other things to note on this map. You'll note the location of First Creek, which is both south and west of the Lone Tree North site. It flows to the northwest. And then finally, the Lone Tree South site was a site that was originally included in the operator agreement between the city and the operator. In 2021, it was consolidated to the Lone Tree North and will not be developed, and I will describe that a little further here next. So some background from our perspective, what we call phase 1 was approved by the city in 2017, constructed in 2018. A single well, the Lone Tree 3BH, was drilled there in May of 2018 and has been producing since then continuously. What we call phase 2 was submitted to the city in October of 2017, originally for 9 additional wells. That expansion of phase 2 was included in the operator agreement between the parties in June of 2019. And then in January of 2021, City Council unanimously approved consolidating the wells that were originally scheduled for the Lone Tree South into the Lone Tree North site. And there were some specific reasons for doing that. First was to reduce surface disturbance. Second was to avoid crossing First Creek. And third was to a reduction in truck traffic associated with the construction. I would note that had the Lone Tree South site continued to be developed as was originally planned, it would have been accessed from the same access road that currently serves Lone Tree North. So that access road would have been the same. And it was determined that it made more sense from the city's perspective. We agreed with the operator to consolidate the wells onto one site, which is the Lone Tree North. So the new well count of 14 additional wells was approved on March 9th, 2021, after a full review by city staff and a public comment period. Again, one more zoom in here just to refresh what I just said. You see here the situation as it appeared in 2014. The Prosper Farm site was drilled. It was utilizing the access road, which is shown in orange on the map. You can see the 2 residential building units there at the top of the map. And then in 2018, Lone Tree North Phase 1, the single well was drilled. And of course, the purpose of today's docket is to review the expansion, which we call Phase 2 of the Lone Tree North well site. And that was approved by the city in March of 2021 for 14 additional wells. After the approval by the city in March of last year, there was some additional recommendation from a resident of an additional or a change in the access road, an alternative access route. What was proposed was to eliminate the current access route and create a new access route from the west, from an existing paved road. It would be 2 miles over currently undeveloped acreage to the Lone Tree North site. The city engaged in extensive review of that request. We met with the operator, with the surface owner and developer, with multiple departments within the city, including Aurora Water, Public Works, and the Traffic Department. And our final review of that and the decision of our summary was that we determined that the route, a new route, would impact a larger number of community members than the current route. It would also require a crossing over First Creek. So because of these things, our decision was to allow the current access road to remain in place as was part of the approval in March of 2021. Finally, the summary, the City of Aurora, which is the relevant local government, supports the expansion of the Lone Tree North well site, which we call Phase 2, to include 14 additional wells. The expanded well site is fully permitted through the City of Aurora, and Crestone Peak Resources remains in full compliance with all city regulations and all BMPs of the operator agreement. And this concludes my prepared remarks. I would be happy to answer any questions that you might have.
Thank you, Mr. Moore. Are there questions for Mr. Moore from commissioners? Seeing no questions, we want to thank you for bearing with and presenting to us this afternoon. It's helpful to gain the perspective of the city of Aurora on this matter.
Thank you.
Okay, Ms. Larson, do we have any further public commenters for this docket?
We did have one individual sign up, Mr. William McEwen. He is not in the meeting at the moment.
Okay, why don't we go ahead and move to the Crestone presentation, and then if Mr. McGee shows up, we can hear him at that time in the future. Ms. Jost, good afternoon.
Good afternoon. Thank you. Let me go ahead and share my PowerPoint. And can everyone see the slideshow?
We can.
Okay, excellent. Well, Chair Robbins, thank you. And good afternoon, commissioners, Director Murphy, COGCC staff, council, and members of the public. My name is Jamie Jost, and I'm with Jost Energy Law. I, along with my partner, Kelsey Barnholt, represent Crestone Peak Resources Operating LLC on the Lone Tree North Oil and Gas Development Plan before you this afternoon. This OGDP is being presented to you under Rule 604B1, as Crestone has obtained the informed consents from the residential building unit owners within 2,000 feet, and there are only 2 of them, and we have obtained both informed consents. We do thank you for the opportunity to present this OGDP to you today. Crestone will be presenting on a variety of topics as shown in this slide on the screen. And we will have 3 main presenters. Nathan Bennett, Dan Harrington, and Kathy Stearman will provide the presentation today. But before we get to the core presentation, Brian Kane, the Chief Sustainability Officer for Civitas, would like to make a brief statement. So thank you, and I will turn it over to Brian.
Thanks, Jamie. Good afternoon, Chairman Robbins, Honorable Commissioners, Director Murphy, and COGCC staff. My name is Brian Kane, and I am Chief Sustainability Officer for Civitas Resources. And today, I'm delighted to provide you with a brief introduction to Civitas. Civitas Resources is the largest DJ Basin-only operator in Colorado and was formed on November 1st of 2021 with the merger of 4 Colorado-focused operators: Bonanza Creek Energy, Crestone Peak Resources, Extraction Oil and Gas, and High Point Resources. Crestone, which is the permitting entity that is before you today, is a wholly owned subsidiary of Civitas. Civitas is also Colorado's first and only net zero oil and natural gas producers. And what that means is we achieve this by reducing operational emissions as a foremost priority, and then offsetting the residual emissions using only certified emission offsets procured through the 4 largest and most credible voluntary offset registries. Through our legacy companies, Civitas has a demonstrated competency in achieving peer-leading emissions reductions by utilizing a suite of best practices, many of which you'll hear about today. And though we must all do much more to address the effects of climate change, we consider this commitment to immediate carbon neutrality on a Scope 1 and Scope 2 basis to be an important example of climate leadership within our peer group and our industry. We've also kicked off comprehensive data analysis initiatives to calculate our internal cost of carbon, which is effectively a hurdle rate that helps us to understand where the lowest hanging fruit exists within our portfolio to undertake meaningful emissions reduction projects. You're likely aware that we recently announced, in coordination with the COGCC and Project Canary, that we've committed to plugging the existing orphan wells throughout our operating area, which effectively amounts to every orphan well in the greater Denver area and northern Front Range of Colorado that was known to the COGCC as of January 1 of this year. Responsible operatorship is a pillar for Civitas's development, and through these initiatives, we hope to set a new standard for operators in our state. We also believe in demonstrating our commitment to our communities, and as such, we'll be launching our Civitas Community Fund later this year. And this fund will be designed to not only return tangible value to the communities where we operate through scholarships and community project grants, but will include special dispensation to those community members living closest to our operations. Another example of this commitment to our communities was the recent donation we made to the Boulder Community Foundation for the Marshall Fire Relief effort. Civitas's commitment to responsible operatorship began at our inception as a mandate from our board of directors, and it is understood throughout our organization. This demonstrated focus from the highest levels of our executive management ensures our commitment to the protection of public health, safety, welfare, wildlife, and the environment are at the forefront of all our new development. This is our commitment to this commission and to the state of Colorado. I thank you for the opportunity to introduce Civitas today. We look forward to continuing to serve the state of Colorado by safely providing affordable and dependable energy that we all use each day. And with that, I'll turn it over to Dan Harrington to continue our presentation. Thank you.
Thank you, Mr. Kane. We appreciate your being here and providing that introduction to us of the company that is before us. Thanks again. Mr. Harrington.
Hello, good afternoon, commissioners. My name is Dan Harrington, and I'm the asset development lead for this part of Civitas's position. I wanted to start today by providing a general overview of the Lone Tree North location. It's an existing location with one producing well located in eastern Aurora. We're looking to expand it to include 14 new horizontal wells. These wells will drill east and west from the pad and will complete development of two 1280-acre DSUs. As Jamie noted, we do have informed consent from the 4 proximal RBU owners, and we also have an approved permit from the city of Aurora for this expansion. By way of a brief background and timeline, Crestone received approval of its local government permit on March 9th, 2021, as Mr. Moore noted, and we filed the OGDP application in April 2021. We received our completeness determination in September, mailed the required notices in September and October, and after a few continuances are happy to be here today. Crestone has a long history with the city of Aurora and appreciates the strong working relationship. The Lone Tree North location expansion was originally cited in June 2019 within the City of Aurora operator agreement, which does include this specific location. On January 25th, 2021, the City of Aurora operator agreement was amended to eliminate a nearby approved well site in exchange for adding additional well slots to the Lone Tree North without adding any disturbance footprint to the pad. This amendment was approved unanimously by the Aurora City Council as it significantly reduced overall surface disturbance in the city and was deemed to better protect public health, safety, welfare, environment, and wildlife resources. On March 9th, 2021, as I said, the city of Aurora did approve the current Lone Tree North well site permit. Crestone would like to take a moment to thank Mr. Jeffrey Moore and his staff for their work on this OGDP and local government permit with Crestone, the COGCC, and the Hurd family. We appreciate Mr. Moore's comments today and his January 31st letter provided to the commission. As a reminder, we are proceeding with this application under Rule 604B1, which is to say that we have obtained informed consent from all RBU owners and tenants within 2,000 feet of the working pad surface. And as shown on this slide, the Hurd family, again, the only RBU owners within 2,000 feet, provided Crestone with their informed consent on January 30th, 2022. This map illustrates the Hurd family homes in relation to the Lone Tree North existing pad site and proposed expansion. The Hurd estate comprises 2 dwellings and 3 outbuildings, which are shown in white in the northeast part of the map. The closest Hurd home is 1,108 feet from the edge of the Lone Tree North proposed working pad surface, which is outlined in solid red. And you can also see the existing pad site in the aerial photo. As a result of almost a year of discussions with the Hurd family, Crestone and the Hurds were able to agree to add numerous site-specific BMPs on top of the almost 50 BMPs required by the City of Aurora operating agreement. This side and the next outline the 12 additional BMPs specifically agreed to with the Hurds. They include, among other things, enhanced notifications, including quarterly meetings and direct lines of communication with Crestone staff, as well as fencing, road, and traffic measures. Before I move on, I would like to address the submitted commissioner question of will temporary alternative housing be available for RBU owners if requested. Crestone
Crestone and the Hurd families have engaged in extensive discussions about the development of the Lone Tree North oil and gas location, including the possibility of alternative housing during the development. As of the date of this hearing, with the Hurd family's informed consent and Crestone's commitment to consistent communication and to the outlined BMPs, Crestone does not believe that alternative housing will be necessary. If the question arises in the future, however, Crestone and the Hurd family do have lines of communication and can discuss further. Upon review of all information provided on the Lone Tree North OGDP on February 7th, the director entered her recommendation for approval of this application. Specifically, the directors recognize that Crestone has proposed BMPs to minimize and or mitigate the potential adverse impacts to public health, safety, and welfare of this expansion. These BMPs demonstrate that the dialogue established between Crestone and the residents of the RVUs shows substantial engagement, and a significant amount of information was provided regarding the proposed location expansion and operations and potential adverse impacts that they may experience. The residents of the RVUs ultimately negotiated an agreement with Crestone that resulted in their signed informed consent, and the city of Aurora has approved the location. We believe that these 3 points are important for the commissioners to consider today under Rule 604B1. Recognizing that commission staff did a very thorough job in their analysis of the ALA we presented, we wanted to confirm our preference for the Lone Tree North location. One, it is an existing producing location whose expansion would utilize the existing access road and SUA. And this location will allow Crestone to complete development of the 2 adjacent DSUs, 4 full sections from a single location with reduced overall disturbed footprint relative to past development plans. Crestone conducted an analysis of 7 alternative locations for the OGDP ALA, and each of these alternatives reviewed had a variety of issues, such as unwillingness of service owners to grant SUA siting, inability to drill off-lease minerals or expand existing pads per SUA terms, lack of opportunity to develop the OGDP from a single site, floodplain impact, and lack of local approval and or citing in the operator agreement. In the director's recommendation, there were 2 items on the ALA in which the director requested additional information. Those are shown on this slide. In response to the first point regarding Section 16, the majority of Section 16 is owned by surface owners that are unwilling to grant SUAs, and a significant part of that section lies within 2,000 feet of the Harmony neighborhood. Local siting approval by the city of Aurora was not contemplated in the current operator agreement, and this location is approximately 4 miles from the eastern edge of the Lone Tree development area, and thus would require an additional pad and disturbance to the east to develop the entirety of the DSU. In response to the second point regarding the Grande 1AH location, the operator agreement limits the Grande 1AH oil and gas location to a total of 8 wells, and all 8 of those wells have been spud and are in various phases of development. These wells themselves are drilling east and west from that location to develop the north half of the Grande to the west and the east half of the Sunset drilling and spacing unit to the east. Further, this location is part of an approved surface development plan, and the developer will not allow expansion of the location for additional wells or pad footprint. And lastly, this location is also approximately 4 miles from the eastern edge of the development area and would not be suitable for a single site development. Crestone is eager to start development at the Lone Tree North location and anticipates starting construction, if approved, in the 3rd quarter of 2022, with drilling and completion starting in the 4th quarter and production starting up in early 2023. Upon approval of this OGDP, Crestone will be filing the corresponding Form 2s in order to keep the process moving forward. And with that, I'd like to turn the presentation over to Nathan Bennett.
Thank you, Dan. Good afternoon, commissioners. My name is Nathan Bennett, and I am the manager for well and location permitting with Civitas. I'm going to take a few minutes today to discuss a few of the best management practices we will be utilizing on the Lone Tree North location. Civitas is committed to Colorado's clean energy future, and the BMPs included on the Form 2A illustrate that commitment in a number of ways. Crestone requested that 4 conditions of approval, or COAs, be included in the Form 2A as shown on this slide. The director's recommendation noted that these 4 items could not be shown as COAs for the reasons stated in her findings, but she did confirm that they would be listed as BMPs on the Form 2A. Crestone is committed to using an electric drilling rig and covering all trucks carrying drill cuttings from the location, as well as complying with ozone action days as feasible. Crestone also requested best management practices that include the utilization of vapor recovery units to capture and route storage vessel gas into pipeline. We will employ IOGP Group 3 drilling fluids, as these are generally considered odorless and do not contain BTEX. We confirm that all of the equipment capable of generating noise will be located within the sound walls on the Lone Tree North location. And additionally, we added additional sound walls on the west, north, and east sides, excepting the access point, as well as a partial wall on the south side of the Lone Tree North location. More than 25 best management practices are included on the Form 2A Crestone submitted for the Lone Tree North. Additionally, the City of Aurora operator agreement requires almost 50 BMPs to be utilized on all locations within its jurisdiction. A few of these include baseline sound studies and mitigation, low profile tanks, fugitive dust emissions, electric line power for drilling equipment and production facilities, ambient air sampling, landscaping, and traffic management plans. In order to address the questions on oil pipeline usage, I can confirm that Crestone is working diligently to ensure oil pipeline is available for the Lone Tree North oil and gas location. As of today, Crestone cannot commit to utilizing oil pipeline on the date of first production from the Lone Tree North. However, it is Crestone's intent to utilize oil pipeline infrastructure for the development of the Lone Tree North. Once constructed and placed into service, 100% of the liquid hydrocarbons produced at Lone Tree North will be transported via pipeline. The City of Aurora mandates the use of pipelines except when factors may prevent or delay the installation thereof. In those instances where pipeline is delayed, Crestone will utilize industry-recognized alternatives to transport oil until pipeline infrastructure is viable, as is expressly allowed under the City of Aurora operator agreement. Crestone will continue its current practice of trucking liquid hydrocarbons as an industry-recognized alternative to pipeline until such a time pipeline infrastructure is available. Crestone received 2 inquiries about pipeline timing and availability, and I would like to address these now. Rather than read the questions in their entirety, I intend to paraphrase and provide a summary response. The first question was focused on the need for tanks, the timing of oil pipeline, and related traffic. Crestone appreciates the inquiry regarding permanent tanks located on the Lone Tree North and respectfully provides that the City of Aurora has already approved the Lone Tree North oil and gas location for up to 6 low-profile oil tanks and 2 low-profile water tanks. The COGCC should defer to the relevant local government's approved permit disposition in this instance and acknowledge Crestone's need to maintain its minimal number of tanks on the Lone Tree North location. Crestone also has the ability to truck product from the Lone Tree North under the express language of the City of Aurora operator agreement until pipeline is available. More importantly, the concept of oil pipeline servicing the Lone Tree North warrants an acknowledgement that the use of oil pipeline does not eliminate the need for above ground storage tanks. That is, those tanks itemized on the Lone Tree North Form 2A and shown on the associated drawings will be required regardless of the method of takeaway. The 6 low-profile oil tanks proposed for the location are required regardless of the method of transport. Maintenance and/or overflow tanks are always required on location for safety reasons. Further, the rules and regulations of both COGCC and CDPHE do not require the use of oil pipeline in any instance. I submit that an operator needs the ability to choose the transportation methodology that is most suitable for the location needing service. Deference must be given to the relevant local government's approval of the proposed transportation methodology. In this case, the Lone Tree North oil and gas permit issued by the City of Aurora expressly allows for the trucking of liquid hydrocarbons for a certain period of time. The second question asked, if the Lone Tree facility were folded into the Box Elder cap, would pipeline access be addressed and in place? Crestone does not believe that delaying the approval of the Lone Tree North OGDP would benefit anyone involved. The Lone Tree North oil and gas location was primarily considered for an expansion and inclusion of additional wells because it is an existing constructed location that will include multiple wellbores pursuant to Rule 603E. The location was approved under the June 5th, 2019 operator agreement with the City of Aurora. The location is subject to an existing surface use agreement with the surface owner, as well as a formal framework development plan with a land developer that has also been approved by the City of Aurora. Lastly, the location triggers only one of the non-waivable Rule 304B2B alternative location analysis criteria due to the residential building units located within 2,000 feet of the working pad surface of the existing Lone Tree North oil and gas location. Utilization of the existing Lone Tree North location is feasible because Crestone and its predecessor ConocoPhillips Company have had an amicable working relationship with the RBU owners since the original Lone Tree North oil and gas location was constructed in 2018. On February 4th, 2021, 2 months prior to the submission of the Lone Tree North OGDP application, Crestone representatives met with staff from COGCC and City of Aurora regarding the Lone Tree North OGDP application. Crestone carefully explained why it was submitting the OGDP application prior to the submission of Crestone's Box Elder Comprehensive Area Plan, or CAP. That CAP was ultimately filed on July 9th, 2021. COGCC staff supported this approach. It is important to note that the Lone Tree North is included within the boundaries of the CAP and is identified and accounted for in the Rule 314E11 cumulative impacts analysis. The necessity of keeping it as an individual OGDP application prior to the time the CAP is heard by the Commission relates to ensuring that Crestone maintains its development obligations tied to its City of Aurora assets. Crestone is not aware of any COGCC rule, guidance, or policy that prohibits an operator from seeking an OGDP prior to COGCC's review and hearing on a Rule 314 CAP. Crestone stresses the fact that Lone Tree North is an existing, previously approved location that is identified in the CAP and accounted for in the required cumulative impacts plan. The director recommendation noted one condition of approval that stated, and I quote, Crestone shall submit via Form 4 sundry notice a corrected disproportionately impacted community map that complies with Rule 304B7J for this location within 30 days of approval of this OGDP or prior to commencing construction, whichever is earlier, end quote. Crestone hereby agrees to provide a corrected map that complies with Rule 304B7J within 30 days of approval of the OGDP. I'm now going to take a short break in my portion of the presentation and hand it over to Kathy Stearman to address Crestone's air emissions and monitoring program.
Thank you. Good afternoon, commissioners. My name is Kathy Stearman. I am the manager of air compliance and engineering for Civitas, and I serve as an air quality subject matter expert for the company. Crestone is committed to eliminating emission sources, and one way we do that is by collaborating with industry peers throughout the basin and throughout the country. Participation in voluntary programs such as the Environmental Leadership Program and the EPA Natural Gas STAR program allow us to share processes that have worked and learn from other companies too. Our staff is presented at the EPA Natural Gas STAR Methane Challenge Implementation Workshop in Pittsburgh, sharing improvements we've made on how we transfer oil, for example. We've also obtained TrustWell certification throughout our field. Obtaining this certification is a rigorous, independent process which reviews a very broad spectrum of a facility's life, all the way from wellbore construction to facilities engineering to the company's operational commitments. Many of Lone Tree North's best management practices revolve around the protection of air quality. We are eliminating on-site emissions by utilizing electric compression, electric drilling. Our tanks will be equipped with vapor recovery systems. Routine flaring will be eliminated. Natural gas actuated pneumatics will be eliminated, and all those commitments will be measured by bolstering the ambient air quality monitoring program, which is what I'd like to focus on. Crestone Peak and its merging partners bring an admirable set of monitoring experience to the table. The goal for air monitoring has always been to ensure our data is meaningful, comparable, independent, and field tested. Meaningful and comparable data are collected by choosing methods that we now know work. Baseline and continuous monitoring will be performed using real-time sensors that have been used in Colorado and are now becoming trusted devices. Our sensors will be deployed at least 10 days before pad construction for baseline monitoring, and this will include monitoring for volatile organic compounds, also known as VOCs, monitoring for methane and particulate matter, and it will be supplemented by a SUMA canister, which will sample air for 7 days and then be analyzed by a mass spectrometer for speciated VOCs. Real-time total VOC methane monitoring will continue for the life of the facility at monitoring stations that surround the pad. To further enhance what's already a really good program, Crestone will be deploying sorbent tubes at every station, which focuses on one particulate analyte, which is benzene. This method will be based on an EPA-sanctioned method for measuring fence line benzene. It has rigorous procedural requirements for collection and analysis, and this data will be publicly available through the CDPHE. The early production benzene sampling will continue for the first year of production. These monitoring programs will be overseen and the data will be reported by third-party consultants, which ensures the independent confidence in the data. Independence is further strengthened by the agency's own monitoring programs, which can include flyovers, satellite programs, the highly sophisticated mobile labs and plume trackers that are operated by the CDPHE, and also unannounced inspections, which are all very much a routine part of how we operate in Colorado. Crestone will also do more leak detection than required. For example, our field experts are called out routinely to utilize cameras for a variety of reasons, such as safety, facility turn on, facility modifications, and maintenance. Optical gas imaging camera inspections will be performed monthly for the life of the facility. Before I wrap up, I wanted to address a commissioner question which asks if the RBU owners agreed to additional air monitoring on their property. I can confirm, yes, the RBU owners have agreed to Crestone providing the families their own personal air quality monitor to use in their homes. This is captured as a best management practice on the Form 2A. Crestone and the RBU owners will also agree to work cooperatively in connection with Dr. Daniel Bond from the CDPHE to locate CDPHE's camel and associated equipment on the RBU owner's property. Back to you, Nathan.
Thank you, Kathy. In addition to the best management practices and air monitoring program that will serve to minimize and mitigate impacts to the surrounding residents and the environment, the Lone Tree North location also provides a net positive impact to the surface and overall development of this general area. By way of example, the temporary disturbance area of 20 acres will be reclaimed to 13 acres once all the wells are producing. Utilizing the Lone Tree North location consolidates 3 oil and gas locations or location expansions into one. This results in significant reductions to surface impacts by eliminating 2 unused or unexpanded locations. Lastly, the 14 new horizontal wells will be developed from an existing producing location pursuant to Rule 603E. This results in 1 newly designed facility instead of 14 wells from 3 locations with multiple facilities. Crestone received minimal public comment on this OGDP application, 2 of which were anonymous. Crestone has engaged in conversations with Representative Weissman about the Lone Tree North OGDP and future development in the area. Many of the comments provided by Ms. Kosis from Arapahoe County as proximate local government representative have been addressed in Crestone's best management practices on the Form 2A. Crestone appreciates the detailed comments provided and believes that it has successfully addressed many of the concerns or issues contained therein. Commissioners, the following 4 slides illustrate the general comments in CDPHE COA recommendations from its January 7th consultation letter, as well as Crestone's response to each comment and recommendation. I know that you have already reviewed this information, so in the interest of time, I submit that these slides are included to illustrate that Crestone agreed to include 11 out of 13 CDPHE recommendations as COAs or BMPs on its Form 2A. The only 2 that Crestone could not agree to were the tankless design and pipeline commitment, which have already been addressed. To summarize the presentation today and Crestone's requested relief, Crestone believes that the Lone Tree North oil and gas location is the most protective location of the public health, safety, welfare, the environment, and wildlife resources. And the Form 2A includes voluminous best management practices crafted to avoid, minimize, and mitigate impacts to the community and the environment, many of which were crafted through Crestone's value discussion with the Hurd family. The Lone Tree North OGDP has the support of the City of Aurora, the support of the Hurd family as evidenced by their executed informed consents, and the support of Director Murphy as set forth in her recommendation for approval. Crestone respectfully requests approval from the Commission on the Lone Tree North OGDP. On behalf of Civitas, Crestone, and Jost Energy Law, I sincerely thank this commission, the COGCC director and staff, and Mr. Jeffrey Moore from the City of Aurora for their hard work on this application. We would also like to say a special thank you to the Hurd family and Mr. Sura for their thoughtful discussions and creative way of looking at things. Civitas and the Hurd family's relationship will continue to grow, and we look forward to working together as Lone Tree North development progresses. Thank you.
Thank you all for the presentation. Very thorough. We appreciate it. Commissioners, are there questions for the panel? Commissioner Messner?
Thank you, Mr. Chair. I'm trying to understand the need for the tanks should there be the opportunity to connect to an oil hydrocarbon or liquid hydrocarbon pipeline, because I'm hearing from other operators that it is possible to go relatively tankless once there's that ability to tie in, understanding that your application doesn't indicate that you're going to tie in. It indicates you're going to be trucking the liquid hydrocarbons with the potential for at some point in the future tying in. So there's no firm commitment to tying in. So maybe just help me understand to get a little more clarity about why there would still need to be, I can't remember now, 6 or 10 tanks.
Commissioner Messner, thank you for the question. Nathan Bennett. To answer your question, and this was alluded to by the prior applicant in some of their answers, there is an engineering design difference in pipeline systems, particularly on the oil side. If you're fortunate enough to have a high pressure oil system, the need for tanks is all but eliminated. That is the situation that Occidental Petroleum discussed in their testimony earlier today. As it relates to the infrastructure that is available in close proximity, and by close proximity, it's roughly 4 to 5 miles the way the crow flies, to our Lone Tree North location, that is a low pressure oil gathering system. Therefore, we need to produce oil into those tanks to lower the pressure before we can enter the pipeline.
Okay. And it takes that number of tanks to be able to do that?
Yes, sir. Our Form 2A indicates we will have 6 low-profile oil tanks on location. All 6 of those tanks will service the 14 new horizontal wells as well as the 1 existing horizontal well on that location.
Okay. That's my question right now. Thank you.
Further questions, Commissioner McGowan?
Thank you, Mr. Chair, and thank you for waiting it out today. I'm wondering if you have, and I know you can't say for certain, but what percentage chance the pipeline is going to work for this location? Because for me, it's not just the, trying to go tankless and reduce hydrocarbons, it's the truck traffic that's on that road that's going so close to that family. And I understand that they sign an agreement. But that, that road is right by their house. And so I'm just wondering, do you guys have an idea of the timing or the percentage of likelihood that it could be connected to the pipeline?
Thank you, Commissioner McGowan. I'll answer your question in 2 parts. It's not a matter of if, it's a matter of when. Crestone has every inkling and desire to connect to oil pipeline as soon as that infrastructure is available. As it relates to timing, you may have heard in my response to Commissioner Messner that as the crow flies, the nearest tie-in point to an existing oil pipeline system in this area is roughly 4 to 4.5 or 5 miles. From a right-of-way perspective, what our land department has identified as being potentially viable, we're talking about roughly an 8-mile right-of-way corridor, following the legal rights and access that we have or are trying to obtain from various surface owners. Given that length, there is an element of time here. Again, I can't speak in specifics because we don't know. I can just reaffirm our commitment that we will connect to oil pipeline as soon as that infrastructure is available.
Further questions? Commissioner Messner?
Thank you, Mr. Chair. I think it's a little bit of just a point. I actually think this application was thorough. I think your presentation was thorough. I appreciate that. I think the amount of information that was provided was good. There is an RBU inside of 2,000 feet. I've heard a couple of, both in the director's report and in your application, some sentiment that COGCC rules don't require, shouldn't compel operators to have certain requirements associated with 604B, including community engagement and additional alternative location analyses and so on and so forth. And I will point out, both for operators that are listening and this operator, that once we're engaged in an application where we're looking at something that includes an RBU or a receptor inside 2,000 feet, then the different elements associated with 604B, A through G do apply. And while I appreciate and I'm very compelled by situations that include informed consent, that doesn't preclude the need, should commissioners feel the need for it, for additional information associated with 604B. And so while I think generally the amount of information that was provided was adequate for me as a commissioner, I just think it's important to make the point that there is the ability for commissioners to expect a certain level of detail and information provided with all the elements associated with 604B, should there be an RBU or other receptors inside of 2,000 feet.
Further questions? Okay, I'm not seeing any further questions. I believe that that means that we are at the commissioner deliberation stage for docket number 2104-00033. Does anyone care to initiate deliberations? Commissioner Gonzalez.
Thank you, Chair. Happy to go first, and thank you to Civitas, Crestone Peak Resources, Ms. Jost, for their presentation today. This is a thorough application. This is an application that is pretty precisely tied to 604B1 and its request for an application of that rule through informed consent. So I'm appreciative of the work that Civitas has done with the landowner, the Hurd family in that regard, and with the city of Aurora. I'm influenced by the comments by Mr. Moore. Sounds like that has been a thorough process, that there were a lot of iterations that led us to this particular development plan. I appreciate the consideration specifically, not just with the Hurds as a landowner, but as a potential land developer and any future plans they may have for their land. I think this was a thorough application, and I'm comfortable supporting it moving forward.
Other commissioners with thoughts? Commissioner McGowan.
Thank you, Mr. Chair. And I felt that the operator answered all the questions that were put forth and tried to work through a lot of the concerns that I heard from in various iterations of what got submitted into the e-filing system and then removed. But I appreciate the effort put forth. That being said, I'm the commissioner who asked about whether I could be folded into your cap, because I'm not sure what the urgency is with this location versus having it be included as part of a larger application where you're already saying that the cumulative impacts is going to be included as part of the box elder cap, if I read the documentation correctly. So I don't know what the urgency is. I also know that the commission can't compel you to do your OGPs this way or that way. But it seems like it is kind of could fit into that. So just food for thought, but I do think that I do think that this application is complete and they provided adequate information for me to make a decision.
Commissioner Nanjapa?
Thank you, Mr. Chair, and appreciate Commissioners Gonzalez and McGowan going first and offering their thoughts. I agree that I feel like the application was thorough and complete, and concerns that I had initially have been addressed. I appreciate the responses to the question, especially the attention to the CDPHE's recommendations and the BMPs and et cetera that were adopted as part of it. I would, though, agree with some of the comments. You know, I'm always going to be concerned when we see an application with residential building units that are, you know, in such close proximity, or just want to make sure that we really are attending to all the concerns. I'm happy that the concerns that were raised have been addressed with the Hurd family. And glad to hear that the progress towards the pipeline and the commitments, you know, therein are well underway. And so I appreciate that. I would also, though, note and agree just with what Commissioner McGowan said, that given that this is going to be part of the CAP, you know, to me, in my view, and with what I recall our intents to be with the CAP process, is that that allows us for a much larger sort of landscape level assessment of the developments that are planned, the mineral estate that's intended to be developed, the wildlife and other environmental considerations, and would agree that it, to me, would have made more sense to submit it as part of the CAP, and to allow us to have that broader look at what's happening, you know, from a larger scale. I think that additional OGDPs that come forward, you know, depending on their location and proximity to this, well, it will just depend on obviously on the details of the application, but I think that it does make, to me, it would have made more sense to put that forward. I understand there was a drilling rig schedule concern. I'm not sure that is a great enough consideration in general. In this instance, I think because all the other concerns have been addressed, you know, I am, you know, glad to see that the various matters have been addressed, and that the application, you know, is complete. But I think especially from the perspective, as Commissioner McGowan noted, of cumulative impacts and kind of thinking of the broader scale, putting it in as part of the CAP would have been preferable. But appreciate all the attention to the details and other information that was submitted as part of the application.
Commissioner Messner?
Thank you, Mr. Chair. I generally concur with the other commissioners' thoughts on this. I mean, for me, you know, the number of best management practices worked in throughout the application are important, but because there was an RBU associated with this application inside of 2,000 feet, the fact that this applicant got an informed consent is very compelling for me, very important piece of this. I also appreciate the thoroughness of the city of Aurora's oil and gas regulations and their evaluation of oil and gas within their jurisdiction. And so reviewing that process and application was important in my decision-making as well. It wasn't use by right, but rather it was a complex application process through this local government. So I think that was compelling for me as well. So with all of those things, I would support this application.
All right. I agree with what I've heard. I'm in support of the application. I don't think we need to do much more other than, do we have a motion?
I'll move to approve the OGDP Lone Tree North location as presented by Civitas today.
Second.
Motion and a second. Do we have further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Motion carries. Thank you to Crestone, to Civitas. Thank you to Ms. Jost for the presentation and to the panel. You're approved to move forward.
Thank you very much. We appreciate it.
Okay. With that, and with the fact that we had previously continued docket 2108-00138 and 2106-00096, I believe we have concluded the business of the commission for today. I will remind commissioners and their 106 stakeholders that the next 4 business days are going to be very busy for us. We take up financial assurances rulemaking, docket 2106-00097 at 9 a.m. tomorrow. We will be hearing from parties on the most recent red line from staff. We will do the same thing on Friday. Monday is a holiday, and we will then continue with deliberations on financial assurances rulemaking on Tuesday and Wednesday. With that, I would look for a motion to adjourn.
So moved.
Second.
Motion to adjourn and a second. All those in favor signify by saying aye.
Aye.
Any opposed? We're adjourned. See you tomorrow morning, guys.